And Senator Romney of Utah. No word on Senator Lisa Murkowski and whether or not there is a fourth senator who would in fact support that. We're going to continue to monitor this as the senators make their way inside the Senate chamber. Most of the Democrats already there, including the Senate Democratic leader Chuck Schumer. We're also still waiting for the Republican leader, Mitch McConnell.
Did you guys nail it? What?
Everything done you need to get done and have a sense that
Will it give time for people to speak? Offer limited number of amendments are offered, and Democrats can offer limited date on the amendments.
actually. But the resolution itself, once it passed, a lot of things. The debate, the debate is going to be interesting.
Democrat from Delaware, retired Navy captain. I've been Delaware's treasurer, congressman, governor, and senator, and I love music. And my life, I promoted concerts ever since the age of 21. And I was thinking of a music lyric earlier today from my youth. It goes something like this: hold on, we're moving too fast. Gotta make democracy last. Hold on, moving too fast. Gotta make democracy last. Song of the day. Maybe song of the week.
Senator, how long do you think it'll last today? What do you think the timeline
I
would
think
be?
maybe 8 o'clock, but we'll see. This is moving so fast. I don't think we really know. The way things are going, who knows?
That was Delaware Senator Carper, and you saw just a moment ago Senator Blunt of Missouri. One of the issues that you're going to hear on the Senate floor is this new development from the New York Times and Maggie Haberman, the president telling Bolton to help his Ukraine pressure campaign. You'll be hearing references to that. We do know that there will be a vote and a debate on witnesses and new evidence. What we don't know is how long the session will last today and whether they will vote today, this weekend, or perhaps next week on those 2 articles of impeachment and whether there will be a vote to convict or acquit the president. And you've been hearing a lot of questions, a lot of uncertainty at this point in terms of that part of the schedule. Live coverage on Capitol Hill. Live outside the Senate chamber and live inside, we're waiting for the Chief Justice, John Roberts. The proceedings will begin with Reverend Barry Black, the Senate chaplain, and the afternoon prayer to start the session. I'm going to read to you what the New York Times is reporting because it will be coming up during the course of the debate this afternoon. Maggie Haberman, based on new revelations from John Bolton's book, more than 2 months before he asked Ukraine's president to investigate his political opponent, President Trump directing John Bolton, then his national security advisor, to help with his pressure campaign to extract damaging information on Democrats from Ukrainian officials. Mr. Trump giving that instruction, according to the New York Times, in Mr. Bolton's book, during an Oval Office conversation in early May that included the acting White House Chief of Staff, Mick Mulvaney, the president's personal lawyer, Rudy Giuliani, and White House counsel, who's now taking the lead in this Senate trial for the president, Pat Cipollone, who is now the impeachment defense manager for the president. New York Times pointing out that Mr. Bolton was asked to call President Zelensky, who had recently won election as the president.
Turn to our desk, that would be a good thing.
Leave it there and take you now to the floor of the U.S. Senate for this afternoon's proceedings. More details at nytimes.com.
The Senate will convene as a court of impeachment. The chaplain will lead us in prayer.
Let us pray. Eternal Lord God, you have summarized ethical behavior in a single sentence. Do for others what you would like them to do for you. Remind our senators that they alone are accountable to you for their conduct. Lord, help them to remember that they can't ignore you and get away with it, for we always reap what we sow. Have your way, mighty God. You are the potter, our senators, and we are the clay. Mold and make us after your will. Stand up, omnipotent God. Stretch yourself. And let this nation and world know that you alone are sovereign. I pray in the name of Jesus. Amen.
Please join me in reciting the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yeah, Bev. He doesn't play that.
Senators, please be seated. If there is no objection, the Journal of Proceedings of the trial are approved to date. The Deputy Sergeant at Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment while the Senate of the United States is sitting for the trial of articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
For the information of all colleagues, we'll take a break about 2 hours out.
Pursuant to the provisions of Senate Resolution 483, the Senate has provided up to 4 hours of argument by the parties equally divided on the question of whether or not it shall be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents. Mr. Manager Schiff, are you a proponent or opponent? Mr. Cipollone, are you a proponent or opponent? Thank you. Then, Mr. Schiff, you may proceed.
Before I begin, Mr. Chief Justice, the House managers will be reserving the balance of our time to respond to the argument of counsel for the President. Mr. Chief Justice, Senators, fellow House managers, and counsel for the President, I know I speak for my fellow managers as well as counsel for the President in thanking you for your careful attention to the arguments that we have made over the course of many long days. Today we were greeted to yet another development in the case when the New York Times reported with a headline that says, "Trump told Bolton to help his Ukraine pressure campaign," book says. The President asked his national security advisor last spring in front of other senior advisors to pave the way for a meeting between Rudolph Giuliani and Ukraine's new leader. According to the New York Times, more than 2 months before he asked Ukraine's president to investigate his political opponents, President Trump directed John R. Bolton, then his national security advisor, to help with his pressure campaign to extract damaging information on Democrats from Ukrainian officials, according to an unpublished manuscript by Mr. Bolton. Mr. Trump gave the instruction, Mr. Bolton wrote, during an Oval Office conversation in early May that included the acting White House Chief of Staff, Mick Mulvaney, the President's personal lawyer, Rudy Giuliani, and the White House counsel, Pat Cipollone, who is now leading the President's impeachment defense. Now, you will see in a few moments, and you will recall Mr. Cipollone suggesting that the House managers were concealing facts from this body. He said all the facts should come out. Well, there's a new fact which indicates that Mr. Cipollone was among those who were in the loop. Yet another reason why we ought to hear from witnesses. Just as we predicted, and it didn't require any great act of clairvoyance, the facts will come out. They will continue to come out. And the question before you today is whether they will come out in time for you to make a complete and informed judgment as to the guilt or innocence of the President. Now, the Times article goes on to say that Mr. Trump told Mr. Bolton to call Vladimir Zelensky, who had recently won election as president of Ukraine, to ensure Mr. Zelensky would meet with Mr. Giuliani, who was planning a trip to Ukraine to discuss the investigations that the President sought in Mr. Bolton's account. Mr. Bolton never made the call, he wrote. never made the call. Mr. Bolton understood that this was wrong. He understood that this was not policy. He understood that this was a domestic political errand and refused to make the call. The account in Mr. Bolton's manuscript portrays the most senior White House advisors as early witnesses in the effort that they have sought to distance the president from, including the White House counsel. Over several pages, according to the Times, Mr. Bolton laid out Mr. Trump's fixation on Ukraine and the president's belief, based on a mix of scattershot events, assertions, and outright conspiracy theories, that Ukraine tried to undermine his chances of winning the presidency in 2016. As he began to realize the extent and aims of the pressure campaign, Mr. Bolton began to object. He wrote in the book, affirming the testimony of a former National Security Council aide, Fiona Hill, who had said that Mr. Bolton warned that Mr. Giuliani was a hand grenade who's going to blow everybody up. Now, as you might imagine, the president denies this. The president said today, I never instructed John Bolton to set up a meeting for Rudy Giuliani, one of the greatest corruption fighters in America. So here you have the president saying John Bolton is not telling the truth. Let's find out. Let's put John Bolton under oath. Let's find out who's telling the truth. The trial is supposed to be a quest for the truth. Let's not fear what we will learn. As Mr. Cipollone said, let's make sure that all the facts come out.
Mr. Chief Justice, Senators, Counsel for the President, last Tuesday at the onset of this trial, we moved for Leader McConnell's resolution to be amended to subpoena documents and witnesses from the outset. This body decided to hold the question over. You have now heard opening arguments from both sides. You have seen the evidence that the House was able to collect. You have heard about the documents and witnesses President Trump blocked from the House's impeachment inquiry. We have vigorously questioned both sides. The President's counsel has urged you to decide this case and render your verdict upon the record assembled by the House. The evidence in the record is sufficient. It is sufficient to convict the President on both articles of impeachment, more than sufficient. But that's simply not how trials work. As any prosecutor or defense lawyer would tell you, when a case goes to trial, both sides call witnesses and subpoena documents to bring before the jury. That happens every day in courtrooms all across America. There is no reason why this impeachment trial should be any different. The common sense practice is born out of precedents. There has never before been a full Senate impeachment trial without a single witness. In fact, you can see in the slide, in every one of the 15 prior impeachment trials, the Senate has called multiple witnesses. Today, we ask you to follow this body's uniform precedents and your common sense. We urge you to vote in favor of subpoenaing witnesses and documents. Now, I'd like to address one question at the offset. There has been much back and forth about whether, if the House believes it has sufficient evidence to convict, which we do, why do we need more witnesses and documents? So I'd like to be clear. The evidence presented over the past week and a half strongly supports a vote to convict the president. The evidence is overwhelming. We have a mountain of evidence. It's direct, it's corroborated by multiple sources, and it proves that the president committed grave, impeachable offenses to cheat in the next election. The evidence confirms that if left in office, President Trump will continue to harm America's national security. He will continue to seek to corrupt the upcoming election, and he will undermine our democracy, all to further his own personal gain. But this is a fundamental question that must be addressed. Is this a fair trial? Is this a fair trial? Is this a fair trial? Without the ability to call witnesses and produce documents, the answer is clearly and unequivocally no. It was the president's decision to contest the facts, and that is his right. But because he has chosen to contest the facts, he shall not be heard to complain. He shall not be heard to complain that the House wishes to further prove his guilt, to answer the questions he would raise. He complains that few witnesses spoke directly to the president about his misconduct beyond his damning conversations with Sondland and Mulvaney. Okay, let's hear from others then. The witnesses the House wishes to call directly to the president's own words, his own admissions of guilt, his own confessions of responsibility. If they did not, all the president's men would be on their witness list, not ours. These witnesses and the documents their agencies produce tell the full story. And I believe that we are interested in hearing the full story. You should want to hear it. More than that, the American people, we know they want to hear it. The House Republicans' own expert witness in the House, Professor Turley, said if you could prove the president used our military aid to pressure Ukraine to investigate a political rival and interfere in our elections, it would be an impeachable abuse of power. And Senator Graham, too, recognized that if such evidence existed, it could potentially change his mind on impeachment. Well, we now have another witness, a fact witness, who would reportedly say exactly that. Ambassador Bolton's new manuscript, which we will discuss in more detail in a moment, reportedly confirms that the president told him in no uncertain terms. We're talking about the former national security advisor saying the president told him in no uncertain terms, no aid until investigations, including the Bidens. For a week and a half, the president has said no such evidence exists. They are wrong. But if you have any doubt about the evidence, the evidence is at your fingertips. The question is, will you let all of us, including the American people, simply hear the evidence and make up their own minds? And you can make up your own minds, but will we let the American people hear all of the evidence? You'll recall that Ambassador Bolton, the president's former national security advisor, is one of the witnesses we asked for last Tuesday. We did not know at the time what he'd say. We didn't know what kind of witness that he would be, but Ambassador Bolton made clear that he was willing to testify and that he had relevant firsthand knowledge that hadn't yet been heard. We argued that we all deserve to hear that evidence. but the president opposed him. Now we know why. Because John Bolton could corroborate the rest of our evidence and confirm the president's guilt. So today, Senators, we come before you and we argue again that you let this witness and the other key witnesses we have identified come forward so you have all of the information available to you when you make this consequential decision. If witnesses are not called here, these proceedings will be a trial in name only. And the American people clearly know a fair trial when they see one. Large majorities of the American people want to hear from witnesses in this trial, and they have a right to hear from witnesses in this trial. Let's hear from them. Let's look them in the eye, gauge their credibility, and hear what they have to say about the president's actions. For the same reasons, this body should grant our request to subpoena documents, the documents that the president also blocked the House from obtaining, documents from the White House, the State Department, DOD, and OMB that will complete the story and provide the whole truth, whatever they may be. We ask that you subpoena these documents so that you can decide for yourself. If you have any doubt as to what occurred, let's look at this additional evidence. To be clear, we're not asking you to track down every single document or to call every possible witness. We have carefully identified only 4 key witnesses with direct knowledge who can speak to the specific issues that the president has disputed. And we targeted key documents which we understand have already been collected, for example, at the State Department. They've already been collected. This will not cause a substantial delay. As I made clear last night, these matters can be addressed in a single week. As we made clear last night, these matters can be addressed in a single week. We know that from President Clinton's case. There, the Senate voted to approve a motion for witnesses on January 27. The next day, it established procedures for those depositions and adjourned as a court of impeachment until February 4. In that brief period, the parties took 3 depositions. The Senate then resumed its proceedings by voting to accept the deposition testimony into the record. In this trial, too, let's do the same. We should take a brief 1-week break for witness testimony and document collection, during which time the Senate can return to its normal business. The trial should not be allowed to be different from every other impeachment trial or any other kind of trial, simply because the president doesn't want us to know the truth. The American people that we all represent, the American people that we all love and care about, deserve to know the truth, and a fair trial requires it. This is too important of a decision to be made without all of the relevant evidence. Before turning to the specific need for these witnesses and documents, I want to make clear we are not asking you again to break new ground. We're asking quite the opposite. We are asking you to simply follow the Senate's unbroken precedents and to do so in a manner that allows you to continue the Senate's ordinary business. The Senate, sitting as a court of impeachment, has heard witness testimony in every other, as we've said earlier, in every other 15 impeachment trials in the history of the Republic. And in fact, these trials have had an average of 33 witnesses. and the Senate has repeatedly subpoenaed and received new documents while adjudicating cases of impeachment. That makes sense. Under our Constitution, the Senate does not just vote on impeachments. It does not just debate them. Instead, the Senate is commanded by the Constitution to try all cases of impeachment. Well, a trial requires witnesses. A trial requires documents. This is the American way, and this is the American story. If the Senate denies our motions, it would be the only time in history it has rendered a judgment on articles of impeachment without hearing from a single witness or receiving a single relevant document from the president whose conduct is on trial. And why? How can we justify this break from precedents? How would we justify, for what reason would we break precedents in these proceedings? There are many compelling reasons beyond precedents that demand subpoenas for witnesses and cases and documents in this case. And at this time, I yield to Manager Garcia.
Mr. Chief Justice, President's Counsel, Senators. Last week, I shared with you that I was reflecting on my first days at a school for baby judges. Y'all may recall that. And I mentioned to you that one of the first things they told us was that we had to be good listeners and be patient. And you as judges in this trial have certainly passed the test. Thank you for being good listeners and for being patient with us. It's been quite a long journey, but we're here today to talk about the other thing they told us in baby judge school, and that was that we had to give all the parties in front of us a fair hearing, an opportunity to be heard, an opportunity to cross-examine witnesses, an opportunity to bring evidence. And that's what I want to talk to you about today. Because in terms of fundamental fairness, subpoenas by the Senate in this trial would mitigate the damage caused by the president's wholesale obstruction of the House inquiry. The president claims that there is no direct evidence of his wrongdoing, despite direct evidence to the contrary in Ambassador Bolton's offer to testify to even more evidence in a trial. But let's not forget that the president is arguing that there is no direct evidence while blocking all of us from getting that direct evidence. It's a remarkable position that they have taken. Quite frankly, never, as a lawyer or a former judge, have I ever seen anything like this. And for the first time in our history, President Trump ordered his entire administration to defy every single impeachment subpoena. The Trump administration has not produced a single document in response to the congressional subpoenas. Not a single page, nada. That's never happened before. There is no legal privilege to justify the blanket blocking of all of these documents. We know that there are more relevant documents. There is no dispute about that. It is uncontested. Witnesses have testified in exceptional detail about these documents that exist that the president is simply hiding. President Trump's blanket order prohibiting the entire executive branch from participating in an impeachment investigation also extended to witnesses. 12 in all followed that order and refused to testify. Much of the critical evidence we have is a result of career officials bravely coming forward despite the president's obstruction. But those closest to the president, some may say, like in the musical Hamilton, those in the room when it happened, followed his instruction. The president does not dispute that these witnesses have information that is relevant to this trial, that these individuals have personal and direct knowledge of the president's actions and motivations and can provide the very evidence he says now that we don't have. Now, the president's counsel alleged the House managers hid evidence from you.
Because as House managers, really their goal should be to give you all of the facts, because they're asking you to do something very, very consequential. And ask yourself, given the facts you heard today that they didn't tell you, who doesn't want to talk about the facts? Who doesn't want to talk about the facts? Impeachment shouldn't be a shell game. They should give you the facts.
This is nice rhetoric, but it's simply incorrect. The president's counsel cherry-picked misleading bits of evidence, cited disposition transcripts of witnesses who subsequently corrected their testimony in public hearings, and said the opposite, and in some cases simply left out the second half of witness statements. That's how the House managers accurately presented the relevant evidence to you. We spent about 20 hours presenting the facts and the evidence. The president's counsel spent 4 hours focusing on the facts and the evidence. And that evidence shows that the president is guilty. But to the extent certain facts were shown to you, let's be very clear. We are not the ones hiding the facts. The House managers did not hide that evidence. President Trump hid the evidence. And that's why we are the ones standing up here asking you to not let the president silence these witnesses and hide these documents. We don't know precisely what the witnesses will say or what the documents will show, but we all deserve to hear the truth. And more importantly, the American people deserve to hear the truth. Never before has the president been put himself above the law and hid the facts of his offenses from the American people like this one. We cannot let this president be different. Quite simply, the stakes are too high. Second, as this builds on what we have been arguing, the Senate requires and should want a complete evidentiary record before you vote on the most sacred task that the Constitution entrusts in every single one of you. I can respect that some of you have deep beliefs that the removal of this president would be divisive. Others, you may believe that allowing this president to remain in the Oval Office would be catastrophic to our republic and our democracy. But regardless of where you are, or regardless of where you land on this spectrum, you should want a full and complete record before you make a final decision and to understand the full story. It should not be about party affiliation. It should be about seeing all the evidence and voting your conscience based on all the relevant facts. It should be about doing impartial justice. Consider the harm done to our institutions, our constitutional order, and the public faith in our democracy. If the Senate chooses to close its eyes to learning the full truth about the president's misconduct, how can the American people have confidence in the result of a trial without witnesses? Third, the president should want a fair trial. He has repeatedly said that publicly, that he wants a trial on the merits. He specifically said it, you saw a clip, that he wanted a fair trial in the Senate. And that would have to be with witnesses that testify, including John Bolton and Mick Mulvaney. He said that he wants a complete and total exoneration. Well, whatever you say about this trial, there cannot be an exoneration without hearing from those witnesses, because an acquittal on an incomplete record after a trial lacking witnesses and evidence will be no exoneration. It will be no vindication, not for the president, not for this chamber, and not for the American people. And if the president is telling the truth and he did nothing wrong, and the evidence would prove that, then we all know that he would be an enthusiastic supporter of subpoenas. He would be here probably himself, if he could, urging you to do subpoenas if he had information that would prove he was totally not in the wrong. If he is innocent, he should have nothing to hide. His counsel should be the ones here asking today to subpoena Bolton and Mulvaney and others for testimony. The president would be eager to have the people closest to him to testify about his innocence. He would be eager to present the documents that show he was concerned about corruption and burden sharing. But the fact that he has so strenuously opposed the testimony of his closest advisors and all the documents speaks volumes. You should issue subpoenas to the president so that the president can get the fair trial that he wanted. But more importantly, so the American people can get the fair trial that they deserve. The American people deserve a fair trial. I said at the onset of this trial that one of the most important decisions you would make at this moment in history will not be whether you convict or acquit, but whether the president and the American people will get a fair trial. The process is more than just the ultimate decision, because the faith in our institution depends on the perception of a fair process. A vote against witnesses and documents undermines that faith. Senators, the American people want a fair trial. The overwhelming majority of Americans, 3 in 4 voters, 3 in 4, as of this past Tuesday, believe that this trial should have witnesses. Now, there's not much that the American people agree on these days, but they do agree on that. And they know what a fair trial is. That involves witnesses and it involves evidence. The American people deserve to know the facts about their president's conduct and those around him. And they deserve to have confidence in this process, confidence that you made the right decision. In order to have that confidence, the Senate must call relevant witnesses and obtain relevant documents withheld thus far by this president. The American people deserve a fair trial. I now yield to my colleague, Manager Parsons.
Mr. Chief Justice, members of the Senate, counsel for the President, last week the House managers argued for the testimony of 4 witnesses: Ambassador John Bolton, Mick Mulvaney, Robert Blair, and Michael Duffy. And during the presentations from both parties, it has become abundantly clear why the direct testimony from those witnesses is so critical, and new evidence continues to underscore that importance. So let's start with John Bolton. The President's counsel has repeatedly stated that the President didn't personally tell any of our witnesses that he linked the military aid to the investigations.
There is simply no evidence anywhere that President Trump ever linked security assistance to any investigations. Most of the Democrats' witnesses have never spoken to the President at all. let alone about Ukraine security assistance. Not a single witness testified that the president himself said that there was any connection between any investigations and security assistance, a presidential meeting, or anything else.
Simply not true, as the testimony of Ambassador Sondland and the admission of Mick Mulvaney make very clear. The evidence before you proves that the president not only linked the aid to the investigations, he also conditioned both the White House meeting and the aid on Ukraine's announcement of the investigations. But if you want more, a witness to acknowledge that the president told them directly that the aid was linked, a witness in front of you, then you have the power to ask for it. I mentioned this portion, there's a slide, I mentioned this portion of Ambassador's manuscript in the beginning, and Manager Schiff referenced it as well. But he says directly that the president told him this. Now, the president has publicly lashed out in recent days at Ambassador Bolton. He says that what Ambassador Bolton is saying is nasty and untrue. But denials in 280 characters is not the same as testimony under oath. We know that. Let's put Ambassador Bolton under oath and ask him point blank. Did the president use $391 million of taxpayer money, military aid, intended for an ally at war to pressure Ukraine to investigate his 2020 opponent? The stakes are too high not to. I'd like to briefly walk you through why Ambassador Bolton's testimony is essential to ensuring a fair trial. Also addressing some of the questions that you've asked in the past 2 days. First, turning back to Ambassador Bolton's manuscript. The President's Counsel has said no scheme existed. And the President's Counsel has cited repeated denials, public denials, of President Trump's inner circle about Bolton's allegations. None of them, of course, under oath. And as we know from the testimony of Ambassador Bolton, how important being sworn in really is. But Ambassador Bolton, as the top national security aide, has direct insight into the president's inner circle. And he is willing to testify under oath whether, quote, everyone was in the loop, as he testified before. Ambassador Bolton reportedly knows, quote, new details about senior cabinet officials who have publicly tried to sidestep involvement, end quote, including Secretary Pompeo and Mr. Mulvaney's knowledge of the scheme. Second, Ambassador Bolton has direct knowledge of key events outside of the July 25th call that confirm the president's scheme. Remember, this is exactly the type of direct evidence the President's Counsel say doesn't exist. That's partly because they would like you to believe that the July 25th call makes up all of the evidence of our case. The call, of course, is just a part of the large body of evidence that you've heard about the past week, but it is a key part. But Ambassador Bolton has critical insight into the president's misconduct outside of this call, and you should hear it. Take, for example, the July 10th meeting with U.S. and Ukrainian officials at the White House. Dr. Hill testified during the meeting that Ambassador Sondland said that he had a deal with Mr. Mulvaney to schedule a White House meeting if the Ukrainians did the investigations. According to Dr. Hill, when Ambassador Bolton learned this, he told her to go back to the NSC's legal advisor, John Eisenberg, and tell him, quote, I am not a part of whatever drug deal Sondland and Mulvaney are cooking up on this, end quote. We already have corroboration of Dr. Hill's testimony from other witnesses like Lieutenant Colonel Vindman. And we have new corroboration from Ukraine, too. Alexander Deniluk, President Zelensky's former national security advisor, recently confirmed in an interview that the, quote, roadmap for U.S.-Ukraine relations should have been the substance, but the investigations were raised, end quote. Deniluk also explained why this was so problematic. He raised concerns that being, quote, dragged into this internal process would be really bad for the country. And also, if there's something that violates U.S. law, that's up to the U.S. to handle, end quote. Deniluk elaborated that there were serious things to discuss at the meeting. But if instead Ukraine was being dragged into, quote, internal politics using our president who is fresh on the job, inexperienced, that could just destroy everything, end quote. Another key defense raised by the president has been that Ukraine felt no pressure, that these investigations are entirely proper. Well, here's Ukraine saying the opposite of that. You know what else Denny Look said in the interview? Quote, "It was definitely John who I trusted," end quote, talking about Ambassador Bolton. So if you want to know whether Ukrainians felt pressured, call John Bolton as a witness. He was trusted by Ukraine, and he was there for these key meetings. And he was so concerned that he characterized the scheme as a drug deal and urged Dr. Hill and others to report their concerns to NSC legal counsel, who reports to White House counsel Cipollone. So let's ask Ambassador Bolton these questions directly under oath. The president says Ukraine felt no pressure, that soliciting these investigations wasn't improper. Is that true? If it is true, why is Ukraine publicly saying that the talk of investigations could destroy everything? And if the president's administration thought this was okay, why did you use the words drug deal? We should ask him that. Why did you urge your staff to report concerns to lawyers? These are all questions that we can get the answers to. Third, the president has suggested the House managers have not presented any direct evidence about Mr. Giuliani's role in the scheme.
In fact, it appears the House committee wasn't particularly interested in presenting you with any direct evidence of what Mayor Giuliani did or why he did it. Instead, they ask you to rely on hearsay, speculation, and assumption, evidence that would be inadmissible in any court.
Well, once again, that's simply not true. But if you want more evidence, we know that Ambassador Bolton has direct evidence of Mr. Giuliani's role regarding Ukraine and expressed concerns about it. The president has suggested that Mr. Giuliani wasn't doing anything improper, and he was not involved in conducting policy. By their own admission, they said he wasn't doing policy. So let's ask John Bolton what Giuliani was doing and whether the investigations were politically motivated or part of our foreign policy. He would know. Dr. Hill testified that Ambassador Bolton said Mr. Giuliani was, quote, a hand grenade, which he explained referred to, quote, all of the statements that Mr. Giuliani was making publicly, that the investigations that he was promoting, that the storyline he was promoting, the narrative he was promoting was going to backfire, end quote. The narrative Mr. Giuliani was promoting, of course, was asking Ukraine to dig up dirt on Biden. Dr. Hill also testified that Ambassador Bolton was so concerned, he told Dr. Hill and other members of the NSC staff, quote, nobody should be meeting with Giuliani, end quote. And that was, quote, closely monitoring what Mr. Giuliani was doing and the messaging that he was sending out, end quote. So let's ask Ambassador Bolton. If Mr. Giuliani wasn't doing anything wrong, why were you so concerned about his behavior? That you directed your staff to have no part in this. If Mr. Giuliani wasn't trying to dig up dirt on Biden, why did you seem to think he was, that he could, quote, blow everything up? Fourth, the president has said that there was nothing wrong with the July 25th call. But once again, the evidence suggests that Ambassador Bolton would testify that the opposite is true. According to witness testimony, Ambassador Bolton expressed concerns even before the call that it would be, quote, a disaster, because he thought there would be, quote, talk of investigations or worse. Now, if the president would have you believe that the call was perfect, as he's repeatedly stated, why don't we find out? Because all of the evidence before you suggests otherwise. And Ukraine knows this is not the case. The call was not perfect. Denny Look is clear on this point. He said, quote, one thing I can tell you that was clear from this July 25th call is that the issue of the investigations is an issue of concern for Trump, end quote. Or it was clear. But if there's still any uncertainty, we must ask Ambassador Bolton. If there was no scheme, how did you know President Trump would raise investigations on the call? What made you so concerned a call would be a disaster? Fifth, the president's main defense, once again, is that he withheld the military aid for a legitimate reason. But the evidence doesn't support that. We've heard a lot. The evidence doesn't support that. Witness testimony, emails, and other documents confirm that Ambassador Bolton and his subordinates, on many occasions, including through in-person meetings with the President himself, urged the President that there was no legitimate reason to withhold the aid. But if you're not sure, if you think this could in any way have been about a legitimate policy reason, let's ask the National Security Advisor, who was in charge of that. If this was simply a policy dispute, as the President argues, let's ask John Bolton whether that's true. The President also argues that you cannot evaluate the President's subjective intent, that the President can use his power any way he feels is appropriate. That's, of course, not the case. Whether his intent was corrupt is a central part of this case, as it is in nearly every criminal case in the country. As a backup argument, however, the President claims that we want you to read the President's mind. Juries, of course, are routinely...
Entire impeachment process is about the House manager's insistence that they are able to read everybody's thoughts, they can read everybody's intention, they think you can read minds.
They want to tell you what President Trump thought.
Of course, are routinely asked to determine the defendant's state of mind. That's central to almost every criminal case in the country. And it's disingenuous for the President's counsel to argue that the defendant's state of mind is unknowable, that it requires a mind reader, or is anything but the most common element of proof of any crime, constitutional or otherwise. But if you want more information, let's ask the President whether John Bolton can help fill in any gaps about his state of mind.
If you think about it, John, he knows some of my thoughts. He knows what I think about leaders.
The case is about the President's conduct in Ukraine. John Bolton knows a lot about that. Let's hear from him. A fair trial demands it. And it's more than just ensuring a fair trial. It's about remembering that in America, truth matters. As Mr. Bolton said on January 30th, quote, "The idea that somehow testifying to what you think is true is destructive to the system of government we have, I think, is very nearly the reverse. The exact reverse of the truth," end quote. Now, as Manager Schiff started this out, the truth continues to come out. Again, in an article today. More information. The truth will come out. And it's continuing to. The question here before this body is, what do you want your place in history to be? Do you want your place in history to be, let's hear the truth, or that we don't want to hear it?
Given our time constraints, we will now summarize the reasons why Mr. Mulvaney, Mr. Duffy, and Mr. Blair are also important. Let's turn first to Mr. Mulvaney. To begin with, Mr. Mulvaney participated in meetings and discussions with President Trump at every single stage of this scheme. We just talked about motive and intent. Well, if you want further insight into the President's motives or intent, further direct evidence of why he withheld the military aid in the White House meeting, you should call his acting chief of staff, who had more access than anyone. Mr. Mulvaney is important because the President's counsel continues to argue incorrectly that our evidence is just hearsay and speculation. Faced with Ambassador Sondland and Mr. Holmes saying this was all as clear as 2 + 2 = 4, the President says they are just guessing. That is simply not true. The evidence is direct. The evidence is compelling. and confirmed by many witnesses, corroborated by text messages, emails, and phone records. But if you want more evidence, if you want another first-hand account for why the aid was withheld, for the undisputed quid pro quo for that White House meeting, let's just hear from Mick Mulvaney. Over and over again, Ambassador Sondland described to multiple witnesses how Mr. Mulvaney was directly involved in the president's scheme. Here's some of that testimony.
And so when I came in, Gordon Sondland was basically saying, well, look, we have a deal here that there will be a meeting. I have a deal here with Chief of Staff Mulvaney. There will be a meeting if the Ukrainians open up or announce these investigations and, into 2016 in Burisma. And I cut it off immediately there. Ambassador Bolton told me that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
What I want to ask you about is he makes reference in that drug deal to a drug deal cooked up by you and Mulvaney. It's the reference to Mulvaney that I want to ask you about. You've testified that Mulvaney was aware of this quid pro quo, of this condition that the Ukrainians had to meet, that is, announcing these public investigations to get the White House meeting. Is that right?
Yeah, a lot of people were aware of it, and
including Mr. Mulvaney.
Correct.
Remarkably, the president is still denying the facts, even as they argue that if it's true, it's still not impeachable. But if the president did nothing wrong, if he held up the aid because of so-called corruption or burden-sharing reasons, he should want his chief of staff to come testify under oath before this distinguished body and say just that. Why doesn't he want Mulvaney to appear before the United States Senate? Well, we know the answer. Because Mr. Mulvaney will confirm the corrupt shakedown scheme. Because Mr. Mulvaney was in the loop. Everyone was in the loop. As Ambassador Sondland summarized in his testimony on July 19th, he emailed several top administration officials, including Mr. Mulvaney, that President Zelensky was prepared to receive POTUS's call and would assure President Trump that he intends to run a fully transparent investigation and will turn over every stone. Mr. Mulvaney replied, I asked NSC to set it up for tomorrow. The above email seems clear. Ambassador Sondland testified that it was clear, that he was confirming to Mr. Mulvaney that he had told President Zelensky he had to tell President Trump on that July 25th call that he would announce the investigation, which he explained was a reference to one of the two phony political investigations that President Trump wanted. And Mr. Mulvaney replies that he'll set up the meeting, consistent with the agreement that Sondland explained he'd reach with Mr. Mulvaney to condition a meeting on the investigations. But if there's any uncertainty, if there's any lingering questions about what this means, let's just question Mick Mulvaney under oath. Mr. Mulvaney also matters because we have heard several questions from this distinguished body of senators wanting to understand when or why or how the president ordered the hold on the security aid. As the head of the Office of Management and Budget, Mr. Mulvaney has unique insights into all of these questions. Your questions. Remember that email exchange between Mr. Mulvaney and his deputy, Rob Blair, on June 27th, when Mulvaney asked Blair about whether they could implement the hold? And Blair responded that it could be done, but that Congress would become unhinged. It wasn't just Congress. It was the Independent Government Accountability Office that determined that the president's hold violated the law. But if the president's counsel is going to argue without evidence that he withheld the aid as part of U.S. foreign policy, seems to make sense that the Senate should hear directly from Mr. Mulvaney, who has firsthand knowledge of exactly these facts. He said so himself.
Again, I was involved with the process by which the money was held up temporarily.
Why doesn't President Trump want Mick Mulvaney to testify? Why? Perhaps here's why.
Did he also mention to me in the past the corruption related to the DNC server? Absolutely. No question about that. But that's it. And that's why we held up the money. Now, there was a report.
So the demand for an investigation into the Democrats was part of the reason that he ordered to withhold funding to Ukraine.
The look back to what happened in 2016 certainly was part of the thing that he was worried about in corruption with that nation. And that is absolutely appropriate.
But to be clear, what you just described is a quid pro quo. It is funding will not flow unless the investigation into the Democratic server happened as well.
We do that all the time with foreign policy. We were holding up money at the same time for what was it? The Northern Triangle countries. We were holding up aid at the Northern Triangle countries so that they would change their policies on immigration. By the way, and this speaks to an important. I'm sorry. This speaks to an important point because I heard this yesterday, and I can never remember the gentleman who testified. Was it McKinney? The guy, is that his name? I don't know him. He testified yesterday. And if you believe the news reports, okay, because we've not seen any transcripts of this. The only transcript I've seen was Sondland's testimony this morning. If you read the news reports and you believe them, what did McKinney say yesterday? Well, McKinney said yesterday that he was really upset with the political influence in foreign policy. That was one of the reasons he was so upset about this. And I have news for everybody. Get over it. There's going to be political influence in foreign policy.
Is that what the Constitution requires? Get over it? Is that good enough for this body, the world's greatest deliberative body? Get over it? The President's counsel can try to emphasize Mr. Mulvaney and his attorney's efforts to walk back this statement. But as you've seen with your own eyes, the statement was unequivocal. And even when given the chance in real time on that day, on October 17th, to deny a quid pro quo, he doubled down. Get over it, he said. But if you have any questions about what the real answer is, where the truth lies, there's only one way to find out. Let's all just question Mr. Mulvaney under oath during a Senate trial. After all, counsel said that cross-examination was the greatest vehicle in the history of American jurisprudence ever invented to ascertain the truth. Your standard. Finally, I'd like to touch briefly on the importance of Mr. Blair and Mr. Duffy to this case. The President's lawyers have argued that withholding foreign aid is entirely within his right as Commander-in-Chief, that this was a normal, ordinary decision, and that this is all just one big policy disagreement. We have proven exactly the opposite. This can't be a policy disagreement because the President's hold actually went against U.S. policy. The hold was undertaken outside of the normal channels by a president who they admit was not conducting policy. The hold was concealed not only from Congress, but from the president's own officials responsible for Ukraine policy. And most importantly, the hold violated the law. The president has the right to make policy, but he does not have the right to break the law and coerce an ally into helping him cheat in our free and fair elections. And he doesn't have a right to use hundreds of millions of dollars in taxpayer funds as leverage to get political dirt on an American citizen who happens to be his political opponent. But if you remain unsure about all of this, who better to ask than Mr. Blair or Mr. Duffy? They oversaw and executed the process of withholding the aid. They can tell us exactly how unrelated to business as usual this whole shakedown scheme was when it was underway. They can testify about why the aid was withheld and whether there was any legitimate explanation for withholding it. Some of you have asked that very question. Multiple officials, including Ambassador Sondland, Ambassador Taylor, David Holmes, Lieutenant Colonel Vindman, Jennifer Williams, and Mark Sandy, all testified that they were never given a credible explanation for the hold. So let's ask Mr. Blair, let's ask Mr. Duffy if this happens all the time, as Mick Mulvaney suggests. Why at this time, in connection with this scheme, were all of those witnesses left in the dark? Despite the president's refusal to produce a single document, to produce a shred of information in this impeachment inquiry undertaken in the House, his administration did produce 192 pages of Ukraine-related email records in Freedom of Information Act lawsuits, albeit in heavily redacted form. These documents confirm Mr. Duffy's central role in executing the hold. He's on nearly every single email released. Nearly every single email. Here's an important email from that production. Just 90 minutes after the July 25th call, Mr. Duffy emailed officials at the Department of Defense that they should hold off on any additional DOD obligations of these funds. Mr. Duffy added that the request was sensitive and that they should keep this information closely held. The timing is important because if the aid wasn't linked to the July 25th call, if it wasn't related, why the sensitive, closely held request made within 2 hours of that call? Let's just ask Mr. Duffy. Mr. Duffy and Mr. Blair can testify about the concerns raised by DOD to the Office of Management and Budget, about the illegality of the hold, and why it remained in place even after DOD warned the administration that it would violate the Impoundment Control Act. Now, the president, of course, has disputed this fact. But we have demonstrated that OMB was warned repeatedly by DOD officials of two things. First, continuing to withhold the aid would prevent the Department of Defense from spending the money before the end of the fiscal year. And second, the hold was potentially illegal, as turned out to be the case. By August 9th, DOD told Mr. Duffy directly that DOD, the Department of Defense, could no longer support the Office of Management and Budget's claims that the hold would not preclude timely execution of the aid for Ukraine, our vulnerable ally at war with Russian-backed separatists. Yet, as Mr. Duffy reportedly told Ms. McCusker at the Department of Defense on August 30th, there was a clear direction from POTUS to continue the hold. Clear direction from the President of the United States to continue the hold. So how did Mr. Duffy understand the clear direction to continue the hold? Why is the President claiming that this wasn't unlawful? When DOD, the Department of Defense, repeatedly warned his administration that it was. Wouldn't we all like to ask Mr. Duffy these questions? Finally, here's another reason why we know this was not business as usual. On July 29th, Mr. Duffy, a political appointee with zero relevant experience, abruptly seized responsibility for withholding the aid from Mark Sandy, a career Office of Management and Budget official. Seized the responsibility from a career official. Mr. Duffy provided no credible explanation for that decision. Mr. Sandy testified that nothing like that had ever happened in his entire governmental career. Let's think about that. If this is as routine as the President claims, why is a career official saying he's never seen anything like this happen before? Mr. Duffy knows why. Shouldn't we just take the time to ask him? The American people deserve a fair trial. The Constitution deserves a fair trial. The President deserves a fair trial. A fair trial means witnesses. A fair trial means documents. A fair trial means evidence. No one is above the law. I now yield to my distinguished colleague, Manager Lofgren.
Mr. Chief Justice and Senators, it's not just about hearing from witnesses. You need documents. The documents don't lie. There are specific documents relevant to this impeachment trial in the custody of the White House, OMB, DOD, and the State Department, and the President has hidden them from us. I'm not going to go through each category again in detail, but here are some observations. This is, of course, an impeachment case against the President of the United States. Nothing could be more important. And the most important documents that go directly to who knew what when, are being held by the executive branch. Many of these records are at the White House. The White House has records about the phone calls with President Zelensky, about scheduling an Oval Office meeting with President Zelensky, about the President's decision to hold security assistance, about communications among his top aides, about concerns raised by public officials with legal counsel. We've heard about Ambassador Bolton's handwritten notes and book manuscript and Lieutenant Colonel Vindman's presidential policy memorandum. We know of reports about a number of emails in early August trying to create after-the-fact justifications for the hold, but we haven't seen any of them. They're at the White House, being hidden by the president. I think it's a cover-up. Documents at the State Department, records about the recall of Ambassador Yovanovitch, about Mr. Giuliani's efforts for the president, about concerns raised about the hold, about the Ukrainian reaction to the hold, and when exactly they learned about it, about negotiations with the Ukrainians for an Oval Office meeting. We know of Ambassador Taylor's first-person cable and notes and Mr. Kent's memos to file. We know about Mr. Sondland's emails with Pompeo and Breckbull and Mulvaney and Perry, but we haven't seen them. They're sitting at the State Department. DOD and OMB also have records. Records about President Trump's hold on military aid to Ukraine, about the justification for the hold, about hiding the hold from Congress and trying to justify the hold after the fact, and about why the hold was lifted, but we haven't seen them. They're at DOD and OMB. Why haven't we seen them? Because the president directed all of his agencies not to produce them. This trial should not reward the president's really unprecedented obstruction by allowing him to control what evidence you see and what will remain hidden. You should ask for these documents on behalf of the American people, and you should ask for these documents to get the truth yourself. Now let's come back to the issue of delay, since the president's lawyers have suggested that having witnesses and documents would make this trial take too long. There will be lengthy court battles, they say. The president might even invoke executive privilege for the very first time in this entire impeachment process. It would be better, we're told, to skip straight to the final verdict, to break from centuries of precedent and end this trial without hearing from a single witness, without reviewing a single document that the president ordered hidden. Respectfully, that shouldn't happen. House managers aren't interested in delaying these proceedings. We're interested in the full truth, in a trial that is fair to the parties and to the American people, in the facts that the President's Counsel agrees are so critical to this trial. It's why we've said we won't go to court. We'll follow all the rulings of the Chief Justice. We can get the witness depositions done in a week. In fact, I know we can, because if you, the senators, order it, that's the law. You have the sole power to try impeachments. If questions or objections come up, including objections based on executive privilege, the Senate itself and the Chief Justice in the first instance can resolve them. We aren't suggesting that the President waive executive privilege. We simply suggest that the Chief Justice can resolve issues related to any assertion of executive privilege. As the Supreme Court recognized in the case of Judge Walter Nixon, judges will stay out of disputes over how the Senate exercises its sole power to try impeachments. That ensures there will be no unnecessary delay, and it's why we propose we suspend the trial for 1 week, and that during that time, you go back to business as usual. While the trial is suspended, we'll take witness depositions, review the documents that are provided at your direction. The 4 witnesses you should hear from are readily available. Ambassador Bolton has already said he will appear. We can and would move quickly to depose these witnesses within a week of the issuance of subpoenas. The documents, too, are ready to be produced. We're ready to review them quickly and to present additional evidence. Meanwhile, the Senate can continue going about its important legislative work as it did during the depositions in the Clinton impeachment trial. The president's opposition to this suggestion says a lot. The president is the architect of the very delay he warns against. He could easily avoid it. He could move things along. He could stop trying to silence witnesses and hide evidence. I think he's afraid the truth will come out. He hopes his threats of continued delay, however unjustified, will cause you to throw up your hands and give up on a fair trial. Please don't give up. This is too important for our democracy. A decision to forego witnesses and documents at this trial would be a big departure from Senate precedent. When the Senate investigated Watergate, it heard from the highest White House officials. That happened because a bipartisan majority of the Senate insisted. We got to the truth then because the Senate came together and put a fair proceeding above party loyalty. We should all want the truth, and so we ask you, do it again, that you put aside any politics, party loyalty, belief in your president, which we understand and sympathize with, but subpoena the documents and the witnesses necessary to make this a fair trial, to hear and see the evidence you need to impartially administer justice. Now, there's been a lot of discussion of executive privilege during this trial. Even if the president asserts executive privilege, something he has not yet done, it wouldn't harm the president's legal rights or cause undue delay, and here's why. Let's focus on John Bolton, since this week's revelations confirm the importance of his testimony. First, as a private citizen, John Bolton is fully protected by the First Amendment if he wants to testify. There's no basis for imposing prior restraint for censoring him just because some of his testimony could include conversations with the president. That's commonplace. As long as his testimony isn't classified, it is shielded by the Free Speech Clause, by the First Amendment. Ambassador Bolton has written a book. It's inconceivable that he is forbidden from telling the United States Senate, sitting as a high court of impeachment, information that shortly will be in print. If the president did attempt to invoke executive privilege, he would fail. It's true for two separate reasons. First, claims of executive privilege always involve a balancing of interests. The Supreme Court confirmed in U.S. v. Nixon, the Nixon tapes case, that executive privilege can be overcome by a need for evidence in a criminal trial. That is even more true here. In an impeachment trial of the President of the United States, which is probably the most important interest under the Constitution, it would certainly outweigh any claim of privilege. Precedent confirms the point. To name just a few, National Security Advisors for President Carter, Zbigniew Brzezinski, President Clinton, Samuel Berger, President George W. Bush, Condoleezza Rice, and President Obama, Susan Rice, testified in congressional investigations. These advisors discussed their communications with top government officials, including the presidents they served. There's no reason why all of these officials could testify in the normal course of events and hearings, but Ambassador Bolton, a former official, couldn't testify in the most important trial there could possibly be. The second reason is the president waived any claim of executive privilege about Ambassador Bolton's testimony. All 17 witnesses testified in the House about these matters without any assertion of privilege by the president. President Trump, as well as his lawyers and senior officials, have publicly discussed and tweeted about these issues at some length. The president has also directly denied reports about what Ambassador Bolton will say in his forthcoming book. Under these circumstances, the president cannot be allowed to tell his version of the story to the public while using executive privilege to silence a key witness who would contradict him. You shouldn't let the president escape responsibility only to later see clearly what happened in Ambassador Bolton's book. There are no national security risks here. The president has declassified the 2 phone calls with President Zelensky. All 17 witnesses testified about the president's conduct regarding Ukraine. We aren't interested in asking about anything other than Ukraine. That's simply a bogus argument. The Constitution uses the word sole power only twice. First, when it gives the House sole power to impeach. And second, Article 1, Section 3, where it gives the Senate sole power to try impeachments. And here's what it says. The Senate shall have the sole power to try all impeachments. When the President of the United States is tried, the Chief Justice shall preside. Now, I think that provision in the Constitution means something. It's up to the Senate to decide how to try this impeachment with fairness, with witnesses, and documents. Privileges asserted can be decided using the process that you devise. That's not unconstitutional. It's what the Constitution provides. You have the power. You decide. Please decide for a fair trial that will yield the truth and serve our Constitution and the American people. I yield now to Manager Schiff.
Senators, before we yield to counsel for the President, I'd like to take a moment by talking about what I think is at stake here. A no vote on the question before you will have long-lasting and harmful consequences long after this impeachment trial is over. We agree with the President's counsel on this much. This will set a new precedent. This will be cited in impeachment trials from this point to the end of history. You can bet in every impeachment that follows, whether it is a presidential impeachment or the impeachment of a judge, if that judge or president believes that it is to his or her advantage that there shall be a trial with no witnesses, they will cite the case of Donald J. Trump. They will make the argument that you can adjudicate the guilt or innocence of the party who is accused without hearing from a single witness, without reviewing a single document. And I would submit that will be a very dangerous and long-lasting precedent that we will all have to live with. President Trump's wholesale obstruction of Congress strikes at the heart of our Constitution and democratic system of separation of powers. Make no mistake, the President's actions in this impeachment inquiry constitute an attack on congressional oversight, on the co-equal nature of this branch of government. Not just on the House, but on the Senate's ability as well to conduct its oversight, to serve as a check and balance on this president and every president that follows. If the Senate allows President Trump's obstruction to stand, it effectively nullifies the impeachment power. It will allow future presidents to decide whether they want their misconduct to be investigated or not, whether they would like to participate in an impeachment investigation or not. That is a power of the Congress. That is not a power of the President. By permitting a categorical obstruction, it turns the impeachment power against itself. How do we respond to this unprecedented obstruction will shape future debates between our branches of government and the executive forever. And it's not just impeachment. The ability of Congress to conduct meaningful and probing oversight that by its nature is intended to be a check and balance on the awesome powers of the executive branch, hinges on our willingness to call witnesses and compel documents that President Trump is hiding with no valid justification, no precedential support. If we tell the President effectively, you can act corruptly, you can abuse the powers of your office to coerce a foreign government to helping you cheat in an election by withholding military aid, and when you're caught, you can further abuse your powers by concealing the evidence of your wrongdoing, the President becomes unaccountable to anyone. Our government is no longer a government with three co-equal branches. The President effectively, for all intents and purposes, becomes above the law. This is, of course, the opposite of what the framers intended. They purposely entrusted the power of impeachment to the legislative branch so that it may protect the American people from a president who believes that he can do whatever he wants. So we must consider how our actions will reverberate for decades to come and the impact they will have on the functioning of our democracy. And as we consider this critical decision, it's important to remember that no matter what you decide to do here, whether you decide to hear witnesses and relevant testimony, the facts will come out in the end. Even over the course of this trial, we have seen so many additional facts come to light. The facts will come out. In all of their horror, they will come out. And there are more court documents and deadlines under the Freedom of Information Act. Witnesses will tell their stories in future congressional hearings, in books, and in the media. This week has made that abundantly clear. The documents the president is hiding will come out. The witnesses the president is concealing will tell their stories. And we will be asked why we didn't want to hear that information when we had the chance, when we could consider its relevance and importance in making this most serious decision. What answer shall we give if we do not pursue the truth now, if we allow it to remain hidden until it is too late to consider on the profound issue of the president's innocence or guilt? What we are asking you to do on behalf of the American people is simple. Use your sole power to try impeachment by holding a fair trial. Get the documents they refuse to provide to the House. Here are the witnesses they refuse to make available to the House, just as this body has done in every single impeachment trial until now. Let the American people know that you understand they deserve the truth. Let them know you still care about the truth, that the truth still matters. Though much divides us, on this we should agree. A trial stripped of all its trappings should be a search for the truth, and that requires witnesses and testimony. Now, you may have seen just this afternoon the President's former Chief of Staff, General Kelly, said that a Senate trial without witnesses is a job only half done. Trial without witnesses is only half a trial. Well, I have to say I can't agree. A trial without witnesses is no trial at all. You either have a trial or you don't. And if you're going to have a real trial, you need to hear from the people who have firsthand information. Now, we presented some of them to you, but you know as well as we, there are others that you should hear from. But let me close this portion with words, I think, more powerful than General Kelly's, and they come from John Adams, who in 1776 wrote, "Together with the right to vote, those who wrote our Constitution considered the right to trial by jury the heart and lungs, the mainspring and the center wheel of our liberties, without which the body must die, the watch must run down, the government must become arbitrary." Now, what does that mean? Without a fair trial, the government must become arbitrary. Now, of course, he's talking about the right of an average citizen to a trial by jury. Well, if in courtrooms all across America, when someone is tried, but they're a person of influence and power, they can declare at the beginning of the trial, if the government's case is so good, let them prove it without witnesses. If people of power and influence can insist to the judge that the House, that the prosecutors, that the government, that the people must prove their case without witnesses or documents, a right reserved only for the powerful, Because you know, only Donald Trump of any defendant in America can insist on a trial with no witnesses. If that should be true in courts throughout the land, then as Adams wrote, the government becomes arbitrary. Because whether you have a fair trial or no trial at all depends on whether you are a person of power and influence like Donald J. Trump. The body will die, the clock will run down, and our government becomes arbitrary. The importance of fair trial here is not less than in every courtroom in America. It is greater than any courtroom in America, because we set the example for America. I said at the outset, and I'll repeat again, your decision on guilt or innocence is important, but it's not the most important decision. If we have a fair trial, however that trial turns out, whatever your verdict may be, at least we can agree we had a fair trial. At least we can agree that the House had a fair opportunity to present its case. At least we can agree that the President had a fair opportunity to present their case, if we have a fair trial. And we can disagree about the verdict, but we can all agree the system worked as it was intended. We had a fair trial, and we reached a decision. Rob this country of a fair trial, and there can be no representation that the verdict has any meaning. How could it, if the result is baked in by the process? Assure the American people, whatever the result may be, that at least they got a fair shake. There's a reason why the American people want to hear from witnesses. And it's not just about curiosity. It's because they recognize that in every courtroom in America, that's just what happens. And if it doesn't happen here, the government has become arbitrary. There is one person who is entitled to a different standard, and that's the President of the United States. And that is the last thing the founders intended. We reserve the balance of our time.
Thank you, Mr. Manager.
Mr. Chief
The
Justice,
majority leader is recognized.
I request the Senate take a 15-minute recess.
Without ordered.
The Senate impeachment trial taking a break at this time. We'll return to live coverage when they gavel back in. In the meantime, Senate Democrats met with reporters prior to the start of today's session. Here's what they had to say.
Good morning, everybody. Good morning. I'm proud to be joined by my colleagues this morning. Now, as everyone knows, for months now, we Democrats have relentlessly asked to hear from relevant witnesses and review relevant documents in this trial for a very simple reason. This is about truth. And today, the Senate will vote on whether witnesses and documents are allowed in this trial. The importance of this vote is self-evident. Trials have witnesses. Trials have documents. The vote today is about whether the Senate will have a fair trial of the President of the United States. So it's deeply disturbing that on something of such importance to the future of our democracy, a few of my Republican colleagues announced last night they vote against hearing additional evidence. It's clear where the American people stand on the issue. Republican senators who decide to go against the will of the people will have to reckon with it. The result of today's vote is still an open question. But I would note that even in Senator Alexander's statement announcing his opposition to new evidence, he said that it was proven that the president did what he was accused of. He came to the wrong conclusion about hearing evidence in this trial, that's clear. But Senator Alexander, a senior Senate Republican, a retiring member, said out loud that I think most Senate Republicans believe in private. That yes, the president did withhold military assistance to try to get Ukraine to help him in his elections. And yes, the president did interfere with congressional investigations of that misconduct. He said yes, the president conditioned foreign aid and a White House meeting with an ally at war on the performance of bogus investigations that would help his reelection. Alexander rejected 90% of the argument from the president's counsel that the president did nothing wrong. He acknowledged that the president did something that the founders feared most: the potential corruption of our national elections by a foreign power, solicited by none other than our own president. And to hide that gross misconduct, the White House exhausted every legal trick in the book to prevent Congress from investigating. If my Republican colleagues refuse to even consider witnesses and documents in this trial, this country is headed towards the greatest cover-up since Watergate. If my Republican colleagues refuse to even consider witnesses and documents in the trial, what will the president conclude? We all know he'll conclude he can do it again, and Congress can do nothing about it. He can try to cheat in his election again, something that eats at the roots of our democracy. And one more point, a point I've been making for weeks, but is most relevant today. If my Republican colleagues refuse to consider witnesses and documents in this trial, the president's acquittal will be meaningless because it will be the result of a sham trial. If there are no witnesses, no documents in this trial, there will be a permanent asterisk next to the acquittal of President Trump, written in permanent ink. So, Senate Republicans face a choice today between seeking the truth and covering it up, between a fair trial and a farce, between country and party. No matter what the results of today's vote, I believe the truth will eventually come out. My Republican colleagues should think about that before they vote today. The truth will eventually come out. We could vote to see the truth in this trial, or it could come out in a few weeks or a few months. And on that day, every Republican who voted to hide the truth in an impeachment trial of the president will have to answer for it. Senator Murray.
That from Senator Chuck Schumer, the Senate Democratic leader, at about 11:20 this morning. It's now approaching 3 o'clock here in Washington, D.C. A short break between the arguments put forth by the Democratic impeachment manager, Adam Schiff of California, and we expect to hear from the president's attorneys after the break. There's Senator Schumer live at the Senate basement. Let's listen to see if he comes to the microphone to talk.
Okay, I'm going to be rather brief. Look, at 11 o'clock this morning, I was upstairs, and we said there's certainly going to be more revelations that come out. Little did we know that an hour later, a thunderbolt struck. John Bolton sat in the room with Mr. Mulvaney, Cipollino, and they talked all about withholding aid and letting the Ukrainian president know. More and more evidence comes out. It will. No mistake about it. What happened today won't be the only or even the most significant and important leak that comes out, because that's just how it is. When you have so many, one of the most troubling things about this is what the president did was so wrong, and there were so many people in the loop, all of whom shrugged their shoulders and went along with something that was decidedly against the law. Maybe they said to themselves, well, that's who Donald Trump is, that's who we're working for. But when there are so many people in the loop, There are so many revelations from that loop as time goes on. And so, no, folks. And so, that it is devastating. As for, there is no agreement between Leader McConnell and myself. We have stood for one thing. We do not want this rushed through. We do not want it in the dark of night. Members have an obligation to tell the American people and to tell the people of their states why they are voting. So we are going to use whatever power we have to prevent it from being rushed through. But right now there is no agreement. I'm not going to take any questions. That's it.
That very brief statement from the Senate Democratic leader with an indication on what the schedule will look like beyond when we hear from the president's impeachment managers. We're keeping an eye on that area in the Senate basement, in the basement of the U.S. Capitol that adjoins the Senate offices to the U.S. Capitol. If other senators come to the microphone, we will go to it live. The story that he is talking about, in case you missed it earlier, is from the Washington Post and the reporting of Maggie Haberman. Trump telling Bolton to help his Ukraine pressure campaign. The story begins as follows. More than 2 months before he asked Ukraine's president to investigate his political opponents, President Trump dictating to John Bolton, his national security advisor, to help with the pressure campaign. Here are some of the House Republican managers now speaking to reporters.
1999, there was a 100-0 vote against witnesses. Chuck Schumer was one of those votes. There was a great memorandum that was presented by none other than Joe Biden about how witnesses would not be necessary. In this case, the fact that they are decrying the lack of due process and the supposed unfairness is really just comical. Everyone knows and every American can see how this whole process developed, how it came through the House, how Adam Schiff and his team engineered the entire process, the sham process we call it, because there's no better explanation. Secret hearings in the basement, the lack of the president's counsel being involved, having any opportunity of involvement for 71 out of the first 70 or 79 days of this whole proceeding. They didn't allow Republicans to ask questions. They didn't allow Republican witnesses. Look, this is all famously known now by all the American people. So the idea that they would be down here saying that this is illegitimate and somehow the president being acquitted today doesn't really count, that there'll be an asterisk next to this. The only asterisk in the history books will be about the sham single-party impeachment that this has been and that the Founding Fathers clearly warned us against. They've opened a Pandora's box, as we keep saying, and we're very concerned about the future. I'll let my other colleagues speak here.
There were 17 witnesses. 17 of those witnesses were called by Adam Schiff. 0 witnesses were called by the president's counsel. Not only was the president unable to call any witnesses at all, his counsel wasn't even allowed in the room for those 17 witnesses. It's over. It's time to acquit the president.
I think what all of the senators in there agree is that regardless of what happened over here, House Democrats didn't do their job over there. On December 18th, we warned them. We stood on the floor of the House and said, there isn't enough evidence and testimony to impeach this president. But they were in a hurry to do that. And we told them, Senate Democrats aren't going to agree with you, and that's proven to be the case. 17 witnesses called over here could have been 117. The number of witnesses available to the House Democrats was the exact number that the House Democrats wanted to call over in the House. They didn't do that.
Yeah, I would just say the same thing. 17 to 0 is enough. Good news is the Senate is now not going to call any more witnesses. They don't want 18 to nothing. They don't want 19 to 0. They don't want 20 to 0. And we know that'd be the case. If another witness was called next week, then the Democrats would never stop. They'd want someone else because they want to keep going and go after this president. So Mr. Zeldin is exactly right. My colleagues are exactly right. It's time for this to end. It's time for the president to be acquitted, and we get moving with the American people's business. Thank you all very much.
Thank you. Questions? No.
That from Republican Congressman Jim Jordan of Ohio, joined by other members of the president's Team of defenders, Republicans in the House, over in the Senate, watching the trial as the events continue to unfold. Let me go back to the New York Times story, which is again getting so much attention today, and the reporting of Maggie Haberman pointing out that the president in this May meeting gave instructions to Mr. Bolton, who was the national security advisor at the time, during an Oval Office conversation that included the acting White House Chief of Staff, Mick Mulvaney, as well as the president's personal lawyer, Rudy Giuliani, and the White House counsel, Pat Cipollone, who is now leading the president's impeachment. More details at nytimes.com. We'll get to your calls in just a moment. I want to share with you from Chad Pergram, who covers Capitol Hill for Fox News, former C-SPAN employee, saying Senator Murkowski saying that she will vote no on calling witnesses. Quote, what also became clear some of my colleagues intend to further politicize this process and drag the Supreme Court into the fray while attacking the Chief Justice. I will not stand for or support that effort. Let's go to James in Livingston, Texas. Good afternoon.
How are you doing today? Thank you for taking my call.
Certainly. Go ahead with your comment.
On the question, I would definitely vote no witnesses, no documents. They didn't take the time to do incremental procedure. They say they didn't trust the American people to take it to the vote. I believe they're scared that they're going to lose power again. They've been scared the whole time since he got elected, and this has been a sham since day one.
Thank you for the call. We're asking yes or no on the issue of witnesses, which is what the Senate will be deciding later today. Our live coverage continues on C-SPAN 2. The other story that's been breaking in the last hour or so, this from the president's former White House Chief of Staff, John Kelly, saying without witnesses, it's a job only half done. It was an interview that he did. It's being posted at NJ.com. He's in New Jersey, speaking at Drew University, and was interviewed on the issue of witnesses. I'll just kind of scroll down here and share with you with the quote. In my view, they kind of leave themselves open to a lot of criticism, saying it seems it was only half a trial. That from the president's former chief of staff, who said yesterday or the day before that he believes John Bolton. Senator Mazie Hirono is coming to the microphone. Let's hear what she has to say.
Well, we read another thunderbolt today, and that is that a month after Biden announced his candidacy in May, there's a meeting with a lot of people in this meeting, including Bolton, Mulvaney, and very importantly, Cipollone, who is very busy spending hours making the argument that there is no evidence of any connection between the hold and the effort to get Ukraine to do an investigation. And if Bolton's allegations are correct, Cipollone basically is arguing something that he knows to be not true. If I were Cipollone as a lawyer, I would be very worried just about now. But this again points out why we need Bolton, why we need Mulvaney, why we need all these fact witnesses with first-hand knowledge to come and testify. And it is astounding to me that the Republicans don't see that. So now they're falling back apparently on this is all a partisan effort. There's nothing partisan about the facts. Facts are out there. And this is why we want the fact witnesses to come forward. So I think it's a pretty sad day that the Republicans don't want to hear from these witnesses.
Senator Hirono, now that Lamar Alexander and Ms. Murkowski declared their votes, are you still holding out hope that you could have witnesses or new evidence at this trial?
It doesn't look as though that the Republicans are going to see their way to face the facts and allow the people of America basically to get the information. However, you know, we're going to hear from Bolton one way or the other. There were so many people in the loop that all of this kind of information, there are texts, there are emails, there are all kinds of communications. The facts are going to come out as to exactly what's going on. And basically, Lamar Alexander said, yeah, okay, you know, the president did all this. So what? So they're either, and I have said for quite a while that they're probably going to say it's a so what defense, that he did all these things, but it's still not impeachable. And another our excuse seems to be that this is all a partisan effort. And as I said, look to the facts. Yes.
Senator Schumer telling Democrats about the process forward, and if McConnell moves ahead with like a resolution that he could pass with his own votes, will Democrats try to?
We'll certainly do our best to make sure that as much of the factual information and the arguments are placed before all of us and the American people. But at the same time, just as the Trump team has been arguing that it is up to the voters, as though impeachment is not a constitutional process. The voters are going to get to decide, and the information is going to keep coming out, and believe me, it will be an indictment on not only the president, in my view, but on also all of the Republicans and those who did not vote to have the factual evidence come up. I don't know. We shall see. That's why things change all the time.
To Murkowski's statement, where she basically said she didn't see any way that there would be a fair trial. She said Congress has failed, and that she wants to vote no because she doesn't want to put Roberts in a position of casting a tie-breaking vote or getting attacked for not casting a vote.
Chief Justice Roberts is not the issue. The issue is whether or not there are going to be enough Republicans who say, we want the fact witnesses. In fact, Chief Justice Roberts could very well say, I don't want to get involved in, this is not my role to break a tie, so there shouldn't even be a tie. And if that's the sort of the I don't know what, angst that she's feeling, I should think that that's nothing that should be the reason she wants to vote no on the witnesses. Without witnesses, we can't have a fair trial, and we know that the American people have said you can't have a trial without witnesses. And it's not just any witnesses, it's the witnesses who are actually there, who can speak firsthand to what the president was scheming.
One of the things that she is saying, that Lamar Alexander and other Republicans are saying, is that basically no matter what witness were to come forward or evidence would come forward, it wouldn't change the outcome. Do you have any thoughts on that?
Maybe they're prejudging the impact of somebody who's sitting there under oath, being questioned. Maybe they don't want to face that reality or that experience. But the bottom line of what Lamar Alexander is saying is at least he's candid enough to say, okay, the president did those things and they were not appropriate. Please, that is about as benign a way to describe what the president did. What he did is impeachable. So, they're making their own rationale and arguments, but the fact of the matter is the American people want witnesses. We want witnesses. We want documents, relevant witnesses and documents. You can't have that and not. You have to have that in order to get a fair trial. It's pretty simple, I think.
Senator, as far as Justice Bologna is concerned, you're saying that he should be worried. What exactly are you insinuating as far as
Well, if the allegations are true that he was actually at a meeting where he was very aware that the president was plotting this scheme to get the Ukrainian president to do his will, political will, and his whole entire argument has been there's no evidence to that effect, and he's one of the witnesses to this happening. There is such a thing as when lawyers lie to the tribunal, there are things that can happen to you.
Senator Hirono, would you like to see
there are disciplinary actions, but that's, you know what, I'm not focusing on that right now. I'm just saying if I were Pat Cipollone, I would be worried. But I'm still focused on the need to get witnesses.
Senator Schumer said if the president is acquitted, it will have a permanent asterisk on it. Do you agree? And is this now how are Democrats now focused on how Republicans who voted to acquit the president will be remembered by history and by voters?
There's agreement both sides, both the House managers and the Trump team, that this is going to have lasting impact, but the impacts are described very differently. In my view, the lasting impact will be that any president who doesn't want to comply with duly issued subpoenas can say, you know what, I'm just not going to comply with any of your subpoenas. I'm not going to have any of my people testify. You see, that does tremendous damage to the checks and balances. So I don't know how we expect any of our committees in any other matter to get information out of this administration. It is already not that easy to get information from this administration, by the way. For example, there's 6 children who have already died under our custody. Do you think that we're getting all the information as to what's going on with all these children in our custody? No. So with this kind of outcome, I think it's going to be even harder. And that's one of the lasting damages of a non-conviction, in my view. There are many.
State of the Union's on Tuesday night. What do you think is the State of the Union right now, given this impeachment trial, how divided the Senate is? And what are you thinking
You know
when
what,
you're going to be looking up at the
I
president?
think I will be attending the State of the Union to bear witness. That is what I did last year. By bearing witness, that means that I do not clap, I do not acknowledge, I'm just there as a witness. And I know that he's going to use that to make all kinds of arguments because basically he's an unhinged, lawless person who lies every single day. So I expect him to use the State of the Union to lie about everything he's doing. But you know what? That's 2 days from now or however. I'm still focused on what we need to do here, and I'm waiting for the votes on this, and people will be on record. That's for history. They will be on record not wanting to support witnesses who should come forward to enable us to make a decision on whether or not this president ought to be convicted for abuse of power and obstruction of Congress. Those will have lasting impacts on what Congress can do with our oversight responsibilities and what the president is going to continue to do, because we do need to ask ourselves, what other pot of money is he going to find to use as a bribe to lean on or bully another country? What other country is he going to pick on? What kind of investigations is he going to unleash that may not have any foundation other than is something that he wants to get done politically? And that's what we've been told, that the president can do basically anything he wants under Article 2, and that is his belief, and his non-conviction will simply lend a lot of support to that belief. And we are seeing, as I said yesterday, we are witnessing the coronation of Trump as king, with Mitch McConnell holding the crown and the Republicans holding the train.
Do you think there is still a value in going through the impeachment process?
Senator Mazie Hirono, who is speaking to reporters at the U.S. Capitol. We are waiting for the recess to conclude. Our cameras are around the Capitol and inside, just adjacent to the chamber, where senators are taking a mid-afternoon break. We do not control the cameras, so as soon as the cameras are turned back on inside the chamber, we will go to it immediately. In the meantime, we want to get to your phone calls. I want to share with you from the Hill newspaper reporting that a number of Republicans, including Senator John Cornyn, indicating that the timeline of the trial could spill into next week. It depends on a couple of things, including the cooperation or lack thereof between the Senate Democratic leader Chuck Schumer and Republican leader Mitch McConnell, which, as the Hill newspaper points out, has been in short supply during the trial. By all indications, the trial will go into the evening hours, potentially into tomorrow morning. The question is, does it move into next week? Of course, Monday is the state of the Iowa caucuses. Tuesday is the State of the Union. Bonnie from Tacoma, Washington, as we watch the scene in the U.S. Capitol, should there be witnesses?
No, absolutely not. Nadler stated, we make the rules in the House. Al Green stated, we can't beat him in the polls. If they would have used the required process to submit the subpoenas, they would have had what they want. Don't count on the Senate to do it now. The president was denied due process. And as far as Bolton, what better way can you get to market your book and have all the free publicity that you could possibly want?
We'll go to Deborah in Cheyenne, Wyoming. On the issue of witnesses, what do you say, Deborah?
I say yes. I say it's time to drop partisanship. It's time to drop opinion. It's time to drop commentary. If the Senate has the sole responsibility of holding a trial, then we need to have a full trial.
We'll go to Simon next in Camarillo, California. Go ahead, Simon.
Hi, thanks for taking my call, first-time caller. I was looking at the hearings, and I think Democrats had a choice to bring the witnesses in the House. I think it's like any trial, a prosecution team was given the chance to bring the witnesses to the case, and they did not do that. If they bring that to the Senate, their time is up. So I would say Democrats should stop asking for more witnesses, and the senators should vote no on impeachment.
According to thehill.com and the whip count, there are 2 senators who support witnesses. Lisa Murkowski, though, is a no vote. according to the Hill newspaper, dashing hopes by Democrats to have witnesses. The 2 yes votes, apparently Susan Collins of Maine and Mitt Romney of Utah, which would make the final vote 51-49 against witnesses. Shirley in Seattle, Washington. Go ahead, please.
We should absolutely have witnesses and documents. This is a thing of between right and corruption. This is abuse and obstruction. I don't see how anything else can come of it. And also, have people forgotten all the people of Trump's people that are indicted because of Ukraine corruption, and the fact that he's lied or gave misleading comments over 15,000 times to the American people? I mean, I don't get how other people are saying this. And also Republicans, in regards to the vote, there's so much voter suppression that's going on that's even in question.
We'll stop there. John Barrasso speaking to reporters. We'll see if we can hear what he's saying.
Don't run, please.
There isn't a microphone there, but John Barrasso, Republican of Wyoming, speaking to a handful of reporters just outside the entrance of the Senate chamber. Again, they are in a mid-afternoon recess. As soon as they gavel back in, we'll take you there live. Don is joining us from Orland Park, Illinois. Should there be witnesses, Don?
Democrats thought they had a slam dunk. They blew it, and now they want to do a do-over. They want to take the pressure off of the Congress, or off of the House of Representatives, and put it on the Senate.
Don, does any of the new information from John Bolton's book in any way sway your view on this?
It's a book. We don't know what's in the book. So let it go.
Dean in Los Angeles on the issue of witnesses. What do you say, Dean?
Well, yes, I believe we absolutely need to hear from witnesses and see evidence and documents. In my view, if Senate Republicans refuse to allow evidence or witnesses, which is not to say that this has at all been resolved, this is still alleging whether or not there is guilt or innocence. But they're risking really being viewed as complicit in covering up for the president, and that essentially is saying we are happy to disempower Congress from their role as being a co-equal branch with the executive. Do we really want to set that precedent? I don't think we really should.
Dean, thank you. We're taking your calls, asking the question whether or not you think there should be witnesses. If you were in the U.S. Senate, how would you vote on that question? Again, we expect the vote in the coming hours. Melva in Dothan, Alabama. Go ahead, please.
Yes, we are free because of the United States Constitution and because of everyone that has upheld it and fought for it to this day. Yes, it has developed as the world has developed. We have got to stick to the Constitution, and every single person in Congress has to defend it. Now, the House did a sloppy job in their inquiry. They rejected the Republicans asking for witnesses. They dismissed it. They were hurriedly trying to get articles to the Senate. And in any court of law, the procedures must be followed. They sent over 2 impeachment articles, and those 2 sloppily put together impeachment articles are what the Senate has to deal with. Now, about the witnesses and all this upset of the country that the Democrats are whining about now, and I hate to say Democrats, I would just say part of the Americans, because both the parties are as corrupt as they can possibly be, and they need to outlaw lobbyists, number one. Lobbying has created a big problem. And if anybody has been watching these procedures, when they saw a video of former Vice President Biden during the talking about the withholding of funds from the Ukraine during the Obama administration, basically bragging about it and talking about a prosecutor, that they would not release the funds until a prosecutor was removed. What in the world? I don't think that this is anything to do with election. I think this is to do with corruption.
Melva, thanks for the call from Dothan, Alabama. Well, we have this opportunity. Doesn't appear to be that the Senate will be coming in the next minute or two. Just want to give you a sense of the schedule. Senator John Cornyn telling reporters he would be, quote, surprised if the trial wrapped up today, and that without cooperation, it could drag on for days, saying it could carry over into the first part of next week. And Manu Raju of CNN saying a big reason why final acquittal vote may not happen till next week. Each senator is entitled to 15 minutes. Senator Collins and Murkowski want the time frame similar to the Clinton trial, which was 3 days of deliberations. The Democrats are warning of amendments if that time frame is not given. So by all indications, a long evening, potentially a session tomorrow. A big question mark, what happens next week with the State of the Union on Tuesday. Of course, 4 of the Democratic senators intend to be in Iowa on Sunday and Monday for the caucuses, which could lead us into next Wednesday, potentially. Again, it all depends on whether or not there is any sense of cooperation. And you could sense from Senator Mitch McConnell, who's not talking to reporters, but Senator Chuck Schumer, who did very briefly, did not want to answer reporters' questions on the schedule. Let's go to Irma in Newport News, Virginia. Good afternoon. You say yes to witnesses. Why?
Because when they had the impeachment trial, the Trump's administration stopped them from getting witnesses and data that they wanted to present at trial. If they had tried to go to court, they'd be there for years. The next president would have been in session by the time that they got a court date to get what they were after. I do not understand why American citizens do they not read? Trump is has one of the most corrupt administrations since Grant. They don't read the newspaper or go online and research this information. And what does Biden's guilt or innocence have to do with what the president is accused of doing?
Thanks for the call. There's Senator Pat Leahy, who is an avid photographer. He literally has thousands of photographs and taking pictures outside the Senate chamber, and many of those photographs are in his office and in scrapbooks as he talks to some individuals there. Alana Abramson of Time Magazine, again with more on the schedule, saying an actual thing complicating when the trial could end. Senators are able to announce whether they deem Trump guilty or not guilty, and then they have up to 15 minutes to do so. That in and of itself has the potential to take up to 25 hours. James is joining us from Ridgeville, South Carolina, as we look at Senator Pat Leahy photographing the press. Go ahead, James.
I do not believe they should be allowing any more witnesses to come forth. Adam Schiff and his bunch did a trial on Trump in Congress. They made up all the rules. They denied anybody else except the ones they wanted. They had 17 witnesses in there. And then when they got up before the Senate, they only showed little snips of the transcripts of what supported their side. So Adam Schiff and them has done their job very sloppily. They sent it to the Senate. Now the Senate is the court to decide whether he is to be impeached or not, and they're still trying to pull stuff out of the woodwork, just like with John Bolton. That story broke about his book exactly when they wanted to. They added to it today, trying to stir up a bunch of junk to get some more witnesses in there just to delay this trial. The Democrats has got one thing in mind, that's to get Donald Trump out of office through impeachment, because they know they cannot beat him next year.
James, thanks for the call. Senator Pat Leahy, the senior Democrat in the U.S. Senate, first elected in 1974 in the aftermath of Watergate. We'll go to Janice in Texas. What do you say about witnesses, Janice?
I say no witnesses. They did not allow President Trump due process, but that's minor to what's going on. The previous administrations, they were all corrupt. They're all crooked, and there is no reason why this man should not be acquitted, and the voters have the opportunity to make this choice.
Thank you.
But if I had to vote between all of them, I would choose his record over his character.
Thank you, Janice. Lisa Hagan of U.S. News, again quoting Senator Chuck Schumer, who told reporters, we carried it live just a short while ago, that we are going to use whatever power we have to prevent it from being rushed through, adding, but right now there is no agreement with the Senate Republican leader, Mitch McConnell. Let's go to Cindy in Mountainburg, Arkansas. Go ahead, Cindy.
I vote no for the main reason is that this impeachment is too divisive. The other side is not going to stop. They do not want this man to be the president. They're going to keep on throwing mud until they find something that sticks. So I say no, stop it, send them a message that this is not going to work. We're not going to fall for it. Thank you.
Thank you. Doug Jones, Democrat from Alabama, who earlier indicated that he was prepared to wait till hell freezes over to get more answers, saying just a short while ago at 3:11 Eastern Time, folks, bipartisanship is a two-way street. Well, guess what? So is partisanship. Partisanship in the House proceedings was a two-way street. Everyone should have come out of their partisan corners for this most solemn of constitutional proceedings to do so. Hashtag impartial justice. Buck is joining us from Grafton, Ohio. Good afternoon, Buck.
Good afternoon.
What's your view on witnesses?
Well, thank you for taking my call. And I am against witnesses because when our president was elected, there became the resistance. And in that spirit, they have done everything they can to resist. And along that, here we are now. So I'm against witnesses. They'd serve no purpose. We have the facts we need. We've had witnesses, and I really don't see wasting any more time on this. I'm very pleased with your programming, too, by the way.
Thank you for the call. Let's go to Deborah next in Salem, Oregon.
Yes, I am voting yes for witnesses and yes for documentation, because any trial that is worth anything should have witnesses and should have the documents. The Republicans are all corrupt, and they are all involved in one way or another by taking money from Russia or other people or oligarchs, and they don't want any information coming out because it's going to come out that many of them were involved in this directly, and all of them are corrupt. And why Mitch McConnell is allowed to take break after break so he can go and talk to them behind doors and say, oh, don't you vote for witnesses, don't you vote for documents, because then the truth will come out. Trump is the most corrupt president we have ever had. I am 69 years old. I don't know why people are not believing in the Constitution, and they believe Trump over everything when he's the biggest con artist around.
Deborah, thank you for the call. Again, I want to share with you the statement from John Kelly, the former White House Chief of Staff. He is interviewed by NJ Advanced Media, that's in New Jersey. He is scheduled to appear at Drew University on February 12th. And when asked about John Bolton and impeachment, he said, quote, in my view, they kind of leave themselves open to a lot of criticism. It seems as if it would be a half a trial. He also pointed out that John Bolton is, quote, a copious note taker, calling him an honest guy and an honorable guy. John Bolton's new book scheduled to be released on March the 17th, but excerpts have been leaked to the New York Times, including news that there was a meeting that took place in May that included Pat Cipollone, who is the president's lead defense lawyer and White House counsel. Maggie Haberman has that story. It's available online at nytimes.com. Jim in Minneapolis, on the issue of witnesses, what do you say?
Well, I'm a lifelong independent, and I watched all of the House proceedings, and from what I understand, the House proceedings are merely like a grand jury investigation where they refer charges to the Senate for trial. Now, in the Senate, I believe there should be documents, there should be witnesses, because you can't have a trial without documents and witnesses. So I say more witnesses.
Thank you, Jim. We'll go to Calvin next in Reidsville, North Carolina. Good afternoon, Calvin.
Yes, I think President Trump, I think they should have witnesses. That's what I think, because President Trump, he has something to hide, and he a crooked president, and it don't make no sense that he want to hide documents and witnesses. So they should get the witnesses and documents out there so the truth can get out. And the Democrats are telling the truth about this, because all he have done is lied ever since he became president. No, I did not vote for him in 2016, and I'm not going to vote for him again this year. I'm going to vote for Joe Biden. So, yeah, it needed to come out. The truth needs to come out. So Republicans need to stop hiding stuff, stop trying to cover up and make this trial a sham. It should be a fair trial, and that's what I think.
Calvin, thanks for the call. In this program, we, of course, will continue to cover the trial here on C-SPAN 2. We're also in Iowa covering the caucuses and events leading up to the caucuses. You can check out the schedule on our website at cspan.org. We're covering all of the major candidates as they crisscross the state. And we also were with President Trump last night. He was in Des Moines, Iowa. And over the weekend, we'll be hearing from Pete Buttigieg, Senator Bernie Sanders, Senator Amy Klobuchar, Senator Elizabeth Warren, and former Vice President Joe Biden. We'll go to Phil next in Mojave Valley, Arizona. On the issue of witnesses, Phil, what do you say?
I say that no, there should be no witnesses, and I would like to state three items that make this thing a complete sham. Number one, the continuing resolution for foreign aid. In that CR, it calls for the president to ensure or investigate corruption within the country. So therefore, the president is entirely within his right to ask about corruption in Ukraine. Number two, the Constitution says there are three branches of government: judicial, legislative, and executive. And the executive branch, its only power of defense is presidential. What? Presidential what? Executive privilege, and that any disputes between the executive branch and the judicial branch will be decided by the judicial branch. And as Nadler pointed out on his opening statements, the judicial branch has no bearing on this case. Number three, they're calling it a trial. The Democrats are calling it a trial. In a normal trial, a jury is always asked questions about whether or not they know or have followed whatever the trial is about. And in this case, we have so many senators that have indicated that they want President Trump impeached prior to the investigation, prior to the shenanigans that are going on right now. And the Constitution also says that you have the right to face your accuser. If you have the right to face your accuser, why are they defending and adamant that the whistleblower will not come forward? His statements did not replicate what the president said in his conversation with the president of Ukraine.
Phil, we will leave it there from Arizona. Thank you for the call. We're waiting for some movement. We're seeing a couple of senators making their way along the corridor of the U.S. Capitol, just outside the Senate chamber. This is a 15-minute break that clearly has gone well beyond that, now approaching 45 minutes in length. Mike DeBonis, who covers Capitol Hill for the Washington Post, a tweet just a moment ago. Let me share it with you. Endgame is falling into place. That, according to Senator John Barrasso, After the witness vote fails, McConnell will offer a second procedural resolution laying out closing arguments, Senate speeches, final vote, debatable for 2 hours, followed by amendments, each debatable for 2 hours. High hopes it will go quick. But based on that math, and if each of the senators decides to take up their 15 minutes, it could extend into the weekend. There are just a lot of unknowns in terms of the schedule, but we do know coming up when the Senate comes back in for the trial that we will hear from the president's defense lawyers. Jean in Manson, Washington, go ahead, please. Your view on witnesses is what?
My view on witnesses is yes, in the House. That's where the witnesses belonged, and that's where they should have been. They talk about this, they're not going to rush this, but yet they're trying to rush it from the House to the Senate. They didn't go through the process. I feel like they're trying to change the Constitution and change the rules of engagement. The president was not given any due process, in my view. I've watched it from the beginning. I think there should be executive privilege, or we're in deep trouble if anybody and everybody can know what's going on in the president's mind and his intentions. And that's how I feel.
We'll go to Paul in Philadelphia. Your view on witnesses, Paul, what is it?
Hi. Yes, I think it's pretty obvious that there should be witnesses. What's the problem with having additional information on what is happening? I mean, it is clear that Trump is guilty and he should be removed, in my opinion. And it's clearly a cover-up. These Republicans are out here trying to cover this up. They're trying to cover their own butts and making sure that there is that they aren't ousted for what they're doing. McConnell is covering it up, and I think that the Democrats are doing a fantastic job at making that very clear. I don't understand why the population of the United States isn't outside protesting this entire process. It's been absurd. The fact that we are at this point is absurd, and I just hope that somebody can figure out the way to do the right thing, because right at this point it is beginning to look like it's doomsday. And vote Bernie Sanders in 2020.
Paul, thank you. There were a handful of protesters outside the Capitol on the Senate side earlier in the day. Sarah Ferris, who covers Congress for Politico, has some color inside the Senate chamber notes. She writes that, and there's Senator Lisa Murkowski coming in. She's going to vote no on witnesses. Swings vote Senator Sinema of Arizona, wearing an ivory cloak dress and silvery heels, spent the first 15 minutes or so on the GOP side, chatting with Senator Alexander, and then to a group of senators that included Thune, Sass, Toomey, and Portman. That's from Sarah Ferris. Back to your phone calls. Jane is next from Carson City, Nevada.
Yes, hi. Yes, I'm calling from Nevada. Yes, I do have an opinion concerning witnesses, and most
sure, Jane,
definitely
let me just jump in. This is Senator Collins who's walking.
And documents, but that was not my main focus on calling. Apparently, a lot of the callers have not either been paying attention to what's going on, or they're just refusing to acknowledge what they're hearing.
And there's the Senate Republican leader, Mitch McConnell. We'll watch for just a moment as the senators begin to gather. Maybe one or two of them will say a word as they enter the Senate chamber. The break that was supposed to last about 15 minutes, now extending to just about 50 minutes. We'll watch and listen.
Yeah.
Yeah, man.
So that whole thing that you were shooting, what is C-SPAN? Put it in a box the whole time.
Please be seated.
Ready to hear the presentation from Counsel for the President?
Mr. Chief Justice, members of the Senate, the House managers have said throughout their presentation and throughout all of the proceedings here, again and again, that you can't have a trial without witnesses and documents, as if it's just that simple. If you're going to have a trial, there have to be new witnesses and documents. But it's not that simple. And that's really something that is a trope that's being used to disguise the real issues, the real decisions that you'd be making on this decision about witnesses. Because there's a lot more at stake there. And let me unpack that and explain what's really at stake there. The first is this idea that if you come to trial, you've always got to go to witnesses, have new witnesses come in and that. But that's not true. In every legal system, and in our legal systems on both civil and criminal sides, there's a way to decide right up front in some quick way whether there's really a triable issue, whether you really need to go to all the trouble of calling in new witnesses and having more evidence and something like that. And there's not here. There's no need for that, because these articles of impeachment on their face are defective. And we've explained that. Let me start with the second article on the obstruction charge. We've explained that charge is really trying to say that it's an impeachable offense for the president to defend the separation of powers. That can't be right. But it's also the case that no witnesses are going to say anything that makes any difference to the second article of impeachment. That all has to do with the validity of the grounds the president asserted, the fact that he asserted longstanding constitutional prerogatives of the executive branch in specific ways to resist specific deficiencies in the subpoenas that were issued. No fact witness is going to come in and say anything that relates in any way to that. It's not going to make any difference. And on the first article of impeachment, that too is defective on its face. And we've explained, we heard it again today here, that the way they have this subjective theory of impeachment that will show abuse of power by focusing just on the president's subjective motives. And they said again today here that the way they can show the president did something wrong is that he defied the foreign policy of the United States. And I talked about that before, this theory that he defied the agencies within the executive branch. He wasn't following the policy of the executive branch. That's not a constitutionally coherent statement. The theory of abuse of power that they framed in the first article of impeachment would do grave damage to the separation of powers under our Constitution, because it would become so malleable. They can pour into it anything they want to find illicit motives for some perfectly permissible action. It becomes so malleable, it's no different than maladministration, the exact ground that the framers rejected during the Constitutional Convention. The Constitution defines specific offenses. It limits and constrains the impeachment power. Now, there's also the fact that we actually heard from a lot of witnesses. We heard from a lot of witnesses in the proceedings so far. You've heard 192 video clips by our count from 13 different witnesses. There were 17 witnesses deposed in closed hearings in the House, and 12 of them testified again in open hearings. You've got all of those transcripts, so you can see the witnesses' testimony there. The key portions have been played for you on the screens. And you've got over 28,000 pages of documents and transcripts. You've got a lot of evidence already. But there's another principle that they overlook when they say, well, if you're going to have a trial, there just have to be witnesses, as if the most ordinary thing is you get to trial and then start subpoenaing new witnesses and documents. That's not true either. And we pointed this out. In the regular courts, the way things work is you've got to do a lot of work preparing a trial called discovery to find out about witnesses and depose them and find out about documents before you get to trial. You can't show up the day of trial and say, oh, Your Honor, actually, we're not ready. We didn't subpoena John Bolton or witness X or witness Y. And now we want to subpoena that witness. Now we want to do discovery. And why does that matter here? Because here, to show up not having done the work and to expect that work to be done in the Senate by this body has grave consequences for the institutional interests of this body, and it sets a precedent. Really, it sets an important precedent for two bodies, for the Senate and for the House. Because what the Senate accepts as an impeachment coming from the House determines not just precedent for the Senate, but really precedent for the House in the future as well. If the procedures used in the House to bring this proceeding here to this stage are accepted, if the Senate says, yes, we'll start calling new witnesses because you didn't get the job done, and whatever process you used to get it here, then that becomes the new normal. And that's important in a couple of ways. One is, as we've pointed out, the totally unprecedented process that was used in the House that violated all notions of due process. There are precedents going back 150 years in the House ensuring that someone accused in an impeachment hearing in the House has due process rights to be represented by counsel, to cross-examine witnesses, to be able to present evidence. They didn't allow the president to do that here. And if this body says that's okay, then that becomes the new normal. And they stand up here, the House managers, and say, this body would be unfair if this body doesn't call the witnesses. They talk about fairness. Where was the fairness in that proceeding in the House? And Manager Schiff says things would be arbitrary if you don't do what they say and call the witnesses they want. Well, wasn't it arbitrary in the House when they wouldn't allow the president to be represented by counsel, wouldn't allow the president to call witnesses? There was no precedent in a presidential impeachment inquiry to have open hearings where the president and his counsel were excluded. It also would set a precedent to allow a package, a proceeding from the House to come here that the House managers say, well, now we need new witnesses. We haven't done all the work. And it's witnesses they didn't even try to get. They didn't subpoena John Bolton. And they didn't go through the process when other witnesses were subpoenaed. When Dr. Kupperman, Charlie Kupperman, went to court, they withdrew the subpoena. And now to say that, well, fairness demands that this body has to do all that work, that sets a new precedent as well. And it would change for all the future the relationship between the House and the Senate in impeachment inquiries. It would mean that the Senate has to become the investigatory body. And the principles that they assert, they did a process that wasn't fair. They did a process that was arbitrary, that arbitrarily denied the president rights. They did a process that wouldn't allow witnesses. And then they came here on the first night. Remember when we were all here until 2 o'clock? And in very belligerent terms said to the members of this body, you're on trial. It will be treachery if you don't do what the House managers say. That's not right. When it was their errors, when they were arbitrary and they didn't provide fairness, they can't project that onto this body to try to say that you have to make up for their errors, and if you don't, the fault lies here. Now, they also suggest that it's not going to take a long time, that they only want a few witnesses. But of course, if things are opened up to witnesses, and it is going to be fair, it's not just one side, it's not just the witnesses that they would want. The president would have to be permitted to have witnesses. And with all respect, Mr. Chief Justice, the idea that if a subpoena is sent to a senior advisor to the president, and the president determines that he will stand by the principle of immunity that's been asserted by virtually every president since Nixon, that'll just be resolved by the Senate right here, whether or not that privilege exists, by the Chief Justice sitting as presiding officer. That doesn't make sense. That's not the way it works. The Senate, even when the Chief Justice is the presiding officer here, can't unilaterally decide the privileges of the executive branch. That dispute would have to be resolved in another way, and it could involve litigation, and it could take a lot of time. So the idea that this will all be done quickly, if everyone just does what the House managers say, is not realistic. It's not the way that the process would actually have to play out in accord with the Constitution. And that has another significant consequence. Again, affecting this institution as a precedent going forward. Because what it suggests, the new normal that would be created then is kind of an express path for precisely the sort of impeachments that the framers most feared. The framers recognized that impeachments could be done for illegitimate reasons. They recognized that there could be partisan impeachments. And if this is the new normal, this is the very epitome of a partisan impeachment. There was bipartisan opposition to it in the House, and it was rushed through with unfair procedures, 78 days total of inquiry. Think about that. In Nixon, there had been investigating committees, and there was a special prosecutor long before the House Judiciary Committee started its investigation. In Clinton, there was a special counsel, an independent counsel, for the better part of a year before the House Judiciary Committee even started hearings. Everything, from start to finish, in this case, from September 24th till the articles of impeachment were considered in the Judiciary Committee, was done in 78 days. In 78 days, and for 71 of them, the president was entirely locked out. So the new normal would be slapdash, get it done quickly, unfair procedures in the House to impeach a president, then bring it to the Senate, and then all the real work of investigation and discovery is going to have to take place with that impeachment hanging over the president's head. And that's a particular thing that the framers also were concerned about. And I mentioned this the other day. In Federalist number 65, Hamilton warned specifically about what he called, and I'm quoting, the injury to the innocent from the procrastinated determination of the charges which might be brought against them. Because he understood that if an impeachment charge from the House wasn't resolved quickly, if it was hanging over the president's head, that in itself would be a problem. And that's why they structured the impeachment process so that the Senate could be able to swiftly determine impeachments that were brought. That also suggests that's why there is a system for having thorough investigation, thorough process done in the House. And Hamilton explained that delay after the impeachment would afford an opportunity for intrigue and corruption. And it would also be, as he put it, a detriment to the state from the prolonged inaction of men whose firm and faithful execution of their duty might have exposed them to the persecution of an intemperate or designing majority in the House of Representatives. And that's what's happened here. And if you create a system now that makes the new normal a half-baked slapdash process in the House, just get the impeachment done and get it over to the Senate, and then once the president's impeached, and you have the head of the executive branch, the leader of the free world, having something like that hanging over his head, then we'll slow everything down, and then we'll start doing the investigation and just drag it out. That's all part of what makes this even more political, especially in an election year. It's not the process that the framers had in mind, and it's not something the Senate should condone in this case. The Senate is not here to do the investigatory work that the House didn't do, where there's been a process that denied all due process, that produced a record that can't be relied upon. The reaction from this body should be to reject the articles of impeachment, not to condone and put its imprimatur on the way the proceedings were handled in the House, and not to prolong matters further by trying to redo work that the House failed to do, by not seeking evidence and not doing a fair and legitimate process to bring the articles of impeachment here. Thank you.
Mr. Sekulow?
Chief Justice, members of the Senate, over a 7-day period, you did hear evidence. You heard evidence from 13 different witnesses, 192 video clips, and as my colleague, the Deputy White House Counsel said, over 28,000 pages of documents. You heard testimony from Gordon Sondland. He's the United States Ambassador to the European Union. You heard that testimony. He testified in the House proceedings. I did not have an opportunity to cross-examine him. If we get witnesses, I have to have that opportunity. William Taylor, former acting United States Ambassador to the Ukraine, testified. You heard his testimony. We didn't get the opportunity to cross-examine him. He would be called. Tim Morrison, the former senior director for Europe and Russia of the National Security Council. You saw his testimony. They put it up. We didn't get an opportunity. We did not have an opportunity to cross-examine him. Jennifer Williams, special advisor on Europe and Russia for Vice President Mike Pence. You saw her testimony. They put it up. I did not have the opportunity to cross-examine her. If we call witnesses, we would have to have that opportunity. David Holmes, the political counsel to the United States Embassy in Ukraine, saw testimony from him. We're not able to cross-examine. If he's called, or if we get witnesses, we will call the ambassador and we will cross-examine. Lieutenant Colonel Alexander Vindman, you saw his testimony, appear before the House. We didn't have the opportunity to cross-examine him. If we call witnesses, we will, of course, have that right to cross-examine him. Fiona Hill, she is the former Senior Director for Europe and Russia on National Security Council. She testified before the House. If we have witnesses, we have the opportunity to call her then and cross-examine Fiona Hill. Kurt Volker, former United States Special Representative for Ukraine negotiations. They called him. We did not have the opportunity to cross-examine. If we're calling witnesses, these are witnesses you've heard from, we would have the right to call witnesses and to cross-examine Mr. Volker. George Kent, the Deputy Assistant Secretary of State for the Bureau of European and Eurasian Affairs. You saw his testimony. They called him. If we have witnesses, we have the right to call that witness and to cross-examine Deputy Assistant Secretary Kent. The former United States Ambassador to Ukraine, Ambassador Yovanovitch, they called her. You saw that testimony. We did not have the opportunity to cross-examine her. If we have witnesses, we would have to call her. Laura Cooper, Deputy Assistant Secretary of Defense for Russia, Ukraine, and Eurasia. They called her. You saw her witness testimony right here. We did not have the opportunity to cross-examine her. We would have to be given that opportunity. These are the witnesses against the president. Laura Cooper, Deputy Assistant Secretary of Defense for Russia, Ukraine, and Eurasia. Again, same thing. David Hale, Undersecretary of State for Political Affairs. He was called by the House. You saw his testimony. We never had the opportunity to cross-examine. If we have witnesses, we have to have the opportunity to do that. There were other witnesses that were called, or you saw their testimony or heard their testimony, where it was referred to: Catherine Croft, the Special Advisor for Ukraine Negotiations, Department of the State, Mark Sandy, the Deputy Associate Director for National Security Programs, and Christopher Anderson, Special Advisor for Ukraine Negotiation, Department of State. You heard their testimony referred to. We did not have the opportunity to cross-examine them. So this isn't going to happen if witnesses are called in a week. Now, that's just the witnesses that have been produced that you have seen by the House managers. You are being called upon to make consequential constitutional decisions. Consequential decisions for our Constitution. We talk about the burden of proof. I've said this before, I'll say it again. 31 times the manager said they proved their case. 29 times they said the evidence was overwhelming. Manager Nadler, he didn't only say it was overwhelming in his view. On page 739 of the congressional record, he's very clear. He says, not only is it strong, there is no doubt. That's what he says. The one thing that the House managers think the President and Council's got right is quoting me, talking about Mr. Nadler, Manager Nadler, as saying, beyond any doubt, it is indeed beyond any doubt. Now, of course, we think that they have not proven their case by any stretch of any proper constitutional analysis. In the Clinton investigation, they talk about witnesses being called, but the 3 witnesses that were called had either testified before the grand jury or before the House committees. These weren't new witnesses. What Mr. Philbin said is correct. Under our constitutional design, they're supposed to investigate. You are to deliberate. But what they're asking you to do is now become the investigative agency, the investigative body. If they needed all this additional evidence, which they said they don't need, and by the way, not only did they say it in the record, this is House Manager Nadler, quote, this is when he was on CNN back on the 15th of this month, we brought the articles of impeachment because despite the fact that we didn't hear from many witnesses, we heard from enough witnesses to prove the case beyond any doubt at all. The same can be said of Representative Lofgren. You know, we have evidence proving the case through, for example, at the meeting when Bolton said it was a drug deal. Well, we have fact witnesses. Hill was there, Vindman was there, Sondland was there. So this idea that they haven't had witnesses, that's the smokescreen. You've heard from a lot of witnesses. The problem with the case, the problem with their position is, even with all of those witnesses, it doesn't prove up an impeachable offense. The articles fail. I think it's very dangerous if the House runs up, which they did, articles of impeachment quickly, so quickly that they are clamoring for evidence, despite the fact that they put all of this evidence forward. They got their wish of an impeachment by Christmas. That was the goal. But now they want you to do the work they failed to do. But as I said, time and time again we heard, you didn't hear from witnesses, you didn't hear from many witnesses. Mr. Schiff modified that a little bit today. A little bit. You heard from a lot of witnesses. But if we go down the road of witnesses, this is not a one-week process. Remember I talked about the waving the wand and Ukrainian corruption in Ukraine was gone. You're not going to have a witness wand here where we just say, okay, you got a week to do this and get it done. There's no way that would be proper under due process. But you know, due process is supposed to be for the person accused. And they are turning it on its head. They brought the articles before you. They're the ones that rushed the case up and then held it before you could actually start the proceedings. But they're the ones that passed the articles before Christmas. You know, we talked a lot about the court system and the fact that they were seeking witnesses. And when it got close to actually having a court proceeding, they decided that they didn't want to have that witness go through that proceeding. They actually withdrew the subpoena to moot the case out. How many constitutional challenges will we have in this body because they placed a burden on you that they wouldn't take themselves in putting their case forward. If we look at our constitutional framework and our constitutional structure, that's not the way it's supposed to work. Now, our opposition to this motion is rather straightforward, as I've said. We came here ready to try the case on the record that they presented. The record that the managers told us was overwhelming and complete. Mr. Schiff went through every sentence of the articles of impeachment just a few days ago and said, proved, proved, proved. The problem is what it proved is not an impeachable offense. You could have witnesses that prove a lot of things, but if there's not a violation of a law, if it doesn't meet the constitutional required process, the constitutional required substantive issues of do these articles, these allegations rise to the level of a sufficient for a removal of office for a duly elected president of the United States? It doesn't. And especially so when we are in an election year. I am not going to take the time, your time, which is precious, to go over in each and every allegation about witnesses that I could. I could do it. I could stand here for a long time. I'm not going to do that. I'm just going to say this. They created the record. Do not allow them to penalize the country and the Constitution because they failed to do their job. With that, Mr. Chief Justice, we yield our time.
Thank you, counsel. The House managers have 30 minutes remaining.
Thank you, Mr. Chief Justice. Senators, I want to walk through some of the arguments that you've just heard from the President's counsel. The first were arguments made by Mr. Philbin. Mr. Philbin began by saying the House managers assert that you can't have a trial without witnesses. And he said it's not that simple. Actually, it is. It is pretty simple. It is pretty simple. In every courthouse, in every state, in every county in the country where they have trials, they have witnesses. And I think you heard Mr. Philbin tie himself into knots as to why this should be the first trial in which witnesses are not necessary. But you know, some things are just as simple as they appear. A trial without witnesses is simply not a trial. You can call it something else, but it's not a trial. Now, Mr. Sekulow said something very interesting. He said, the House investigates and the Senate deliberates. Well, he would rewrite our Constitution with that argument, because the last time I checked the Constitution, it said that the House shall have the sole power of impeachment and the Senate shall try the impeachment, not merely deliberate about it, not merely think about it, not merely wonder about it. I know you're the greatest deliberative body in the world, but not even you can deliberate in a trial without witnesses. But Mr. Sekulow would rewrite the Constitution. Your job is not to try the case, he says. Your job is merely to deliberate. That is not what the founders had in mind, not by a long shot. Now, Mr. Philbin says none of these witnesses would have relevance on Article 2, I guess conceding that they would have relevant evidence on Article 1. But that's not true either. Imagine what you will see when you hear from the witnesses who ran the Office of Management and Budget, or imagine what you will see when you read the documents from the Office of Management and Budget. What you will see is what they have covered up. What you will see is the motive for their complete obstruction of Congress. When you see not the redacted emails, not the fully blacked out emails that they deigned to give in the litigation under the Freedom of Information Act, but when you see what is under those redactions, you will have proof of motive. When you see those documents, you will see just how fallacious these non-assertions of executive privilege are. You will see, in essence, what they have covered up. It could not be more relevant to whether their panoply of legal argumentation to justify we shall fight all subpoenas is merely a cover-up and legal window dressing. So these witnesses and documents are critical on both articles. Now, you also heard Mr. Philbin argue, and again, this is where we expected we'd be at the end of the proceeding, which is essentially they proved their case. They proved their case. We pretty much all know what's gone on here. We all understand just what this president did. No one really disputes that anymore. So what? So what? It's a version of the Dershowitz defense. So what? The president could do no wrong. The president is the state. If the president believes that corrupt conduct would help him get reelected, if he believes shaking down an ally and withholding military aid, if he believes soliciting foreign interference in our election, whether it be from the Ukrainians or the Russians or the Israeli prime minister or anyone else in any form that it may take, so what? He has a God-given right to abuse his power. And there's nothing you can do about it. It's the Dershowitz principle of constitutional lawlessness. That's the end-all argument for them. You don't need to hear witnesses who will prove the president's misconduct because he has a right to be as corrupt as he chooses under our Constitution. And there's nothing you can do about it. God help us if that argument succeeds. Now, they say that these witnesses already testified, and so you don't need to hear from anybody. There were witnesses who already testified, and so the House doesn't get to call witnesses in the Senate. That would be like a criminal trial in any courthouse in America where the defendant, if he's rich and powerful enough, can say to the judge, "Hey, judge, the prosecution got to have witnesses in the grand jury. They don't get to call anyone here. They had their chance in the grand jury. They called witnesses in the grand jury. They don't get to call witnesses here." That's not how it works in any courtroom in America, and it's not how it should work in this courtroom. Of course, you heard the argument again, repeated time and time again. The House is saying they're not ready for trial. Of course, we've never said we weren't ready for trial. We came here very prepared for trial. I would submit to you the president's team came here unprepared for trial, unprepared for the fact that there would be, as we all anticipated, a daily drip of new disclosures that would send them back on their heels. We came here to try a case, prepared to try a case, and yes, we had, I hope, the not unreasonable expectation that in trying that case, like in every courtroom in America, we could call witnesses. That is not a lack of preparation, that is the presence of common sense. They didn't try to get Bolton, they argued. Mr. Philbin said they didn't even try to get Bolton. Now, of course, we did try to get Bolton. And what he said when he refused to show up voluntarily is, if you subpoena me, I will sue you. I will sue you. He said basically what Don McGahn told us 9 months ago. I will sue you. Good luck with that. Now, the public argument that was made by his counsel was that he and Dr. Kupperman, out of just due diligence, they just want a court to opine that it's okay for them to come forward and testify. As soon as the court blesses their testimony, they're more than willing to come in. They just are going to court to get a court opinion saying they could do it. And so, of course, we said to them, if that's your real motivation, there's a court about to rule on this very issue of absolute immunity. And very shortly thereafter, that court did. That was the court, Judge Jackson in the McGahn case, and the judge said this argument about absolute immunity, which, yes, presidents have always dreamed about and asserted, but which has never succeeded in any court in the land. It was ridiculed in the case of Harriet Miers. It was made short shrift in the case of Don McGahn, where the judge said, no, we don't have kings here. In the 250 years of jurisprudence, there is not a single case to support the proposition that the president can simply say that my advisors are absolutely immune from process. And of course, in every other non-impeachment context where the courts have looked at the issue of a Congress's power to enforce its subpoenas against witnesses or documents, the courts have said the power to compel compliance to a subpoena is co-equal, coextensive with the power to legislate, because you can't do one without the other. If we can't find out whether the president is breaking the law, violating the Impoundment Control Act or any other when he is withholding aid we appropriated from an ally, how can we legislate a fix to make sure that this never happens again? We can't. If we can't get answers, we can't legislate. That is a proposition vindicated by every court in the land, and of course, in the context of impeachment, the courts have said that is never more important. Never more important. Now, I don't know why, after saying he would sue us, and we had to expect that, like Don McGahn, where we are still in court 9 months later, I don't know why he's changed his mind. But I suspect it's for the reason that if this trial goes forward and he keeps this to himself, it will be very difficult to explain to the country why he saved it for the book. When he knew information of direct relevance and consequence to a decision that you have to make about whether a president of the United States should be removed from office, it would be very difficult to explain why that was saved for a book. Well, I would submit to you it will be equally difficult for you to explain as it would be for him. But you can ask him that question. Why are you willing to testify before the Senate but not the House? And you should ask him that question. Now, it was said, and it has the character of, you should have fought harder to overcome our obstruction. The House should have fought harder to overcome our stonewalling. Shame on the House for not fighting harder to overcome our stonewalling. If only they had fought harder to overcome our stonewalling, maybe they could have gotten these witnesses earlier. That's a really hard argument to make while they're stonewalling. You should have tried harder. You should have taken the years that would be necessary to overcome our stonewalling. And the reason why that argument is in such bad faith, as I pointed out to you yesterday, that while they're in this body arguing the House was derelict, slapdash, they should have fought harder and longer and endlessly to overcome our stonewalling, while they're making that argument to you, the House should have fought up and down the courts, from the district to the Court of Appeals, to the Supreme Court, and back again. They're in the courthouse arguing the opposite. They're in the courthouse saying, Judge, they're trying to enforce a subpoena on Don McGahn. You need to throw it out. They don't have the jurisdiction. This is non-justiciable. You can't hear this case. That is a really hard argument to make. I credit them for making it with a straight face. But that's the character of it. You should have fought harder to overcome our stonewalling and obstruction. Now, they also say the Chief Justice cannot decide issues of privilege. No, the Chief Justice can't make those decisions. You need to let us litigate this up and down the court system. That's a pretty remarkable argument because the Senate rules allow the presiding officer to make judgments, to rule on issues of evidence, materiality, and privilege. That is permitted under your own rules. We don't need to go up and down the courts. We've got a perfectly good judge right here. Now, you heard our proposal yesterday that we take a week, just a week, to depose the witnesses that we feel are relevant, that they feel are relevant, and that the justice rules are relevant. Just 1 week. Now, they can say that the Constitution requires them to go to court, but of course it doesn't. There is absolutely no constitutional impediment from these fine lawyers saying, you know, that's eminently reasonable. We will allow a neutral party, the Chief Justice of the United States of America, to rule on whether a witness is material or immaterial, whether they're being called for purposes of probative evidence or harassment, and whether you're making a proper claim of privilege or merely trying to hide crime or fraud. The concern they have is not that this Chief Justice will be unfair, but rather that he will be fair. But do not make any mistake about it. Do not let them suggest that there is something constitutionally impermissible, or it would violate the President's rights to allow the Chief Justice of the United States to make those decisions in this court because he is empowered to do so by your rules and by the Constitution, which gives you the sole power to try impeachments. In the sole exercise of your power to try impeachments, you can say, we will allow the Chief Justice to make those decisions. Now, Mr. Sekulow said that you've heard the testimony of 13 witnesses. And I think the impression is meant to be given, if not to you, who know otherwise, then maybe to the people watching at home, that they must have been in between errands while watching the Senate trial and missed where those 13 witnesses came before the Senate and testified. But of course, you heard no live testimony in this body. There wasn't any live testimony before this body, and I don't recall any of you in that super secret basement bunker they've been talking about. Now, I'll admit there were 100 members eligible to be there, so maybe I missed one of you. But I don't think you were there for the live testimony in the House. Now, Mr. Sekulow says the President was deprived of his right of calling these witnesses himself and cross-examining these witnesses in the House, but that's not true either, because the President was eligible to call witnesses in his defense in the Judiciary Committee and chose not to do so. If the President's counsel felt that, you know, Bill Taylor says that he spoke with Sondland right after this phone call with the President, and Sondland talked about how the military aid was conditioned on these investigations. The President wanted Zelensky in a public box. And I'd really like to cross-examine that West Point grad Vietnam vet because I don't believe him. You know, they could have called Bill Taylor in the Judiciary Committee and cross-examined him. Or they could have called Mick Mulvaney and put him under oath and let him contradict what we now John Bolton would say. But of course they didn't do that. No, they said merely, just get it over with in the House. For all there was too quick, too slapdash, get it over with in the House. Because as the President said, when it comes to the Senate, we'll have a real trial where he gets to call witnesses. But they've changed their tune, because now they know what they really have known all along, which is those witnesses would deeply incriminate this President. And so, in Instead, they have fallen back on the argument that if we're going to go down the road to having a real trial, we, the president's lawyers, are going to make you pay. And the form of this argument is we are going to call every witness under the sun. We're going to call every witness that testified before the House. We're going to call every witness that we can think of that would help smear the Bidens. We are going to keep you here until kingdom come. That's essentially the argument that they're making when Mr. Sekulow says we're going to bring in Fiona Hill and we're going to bring in Tim Morrison, we're going to bring in this witness and bring in that witness. You have the sole power to try this case. You do not have to allow the president's lawyers to abuse your time or this process. You have the power to decide, no, we gave each side 24 hours to make their arguments. We're going to give each side a shared week to call their witnesses. You have that power. If you didn't, you couldn't have constricted the amount of time for our argument. You can likewise determine how much time should be taken with witness testimony. Now, Mr. Sekulow ended his argument against witnesses with where Mr. Philbin essentially began. It all comes back to the Dershowitz principle. What's the point of witnesses if the president can do whatever he wants under Article 2? What's the point of calling witnesses? What's the point of having a trial if the president can do whatever he wants under Article 2? The only constraining principle, and I think that one of the senators asked yesterday, what's the limiting principle in the Dershowitz argument? If a president can corruptly seek foreign interference in his election because he believes that his election is in the national interest, then you cannot impeach him for it, no matter how damaging it may be to our national security. What is the limiting principle? And I suppose the limiting principle is only this. It only requires the president to believe that his reelection is in the national interest. Well, it would require an extraordinary level of self-reflection and insight for a president of the United States to conclude that his own reelection was not in the national interest. Not unprecedented, mind you. I think that was the decision that LBJ ultimately arrived at. But I would not want to consider that a meaningful limitation on presidential power, and neither should you. Finally, counsel expressed some indignance that we should suggest that it's not just the Senate, it's not just the president, rather, who is on trial here, but it is also the Senate. How dare the House managers suggest that your decisions should reflect on this body? That's just such a calumny. Well, let me read you a statement made by one of your former colleagues. This is what former U.S. Senator John Warner, a Republican of Virginia, had to say. As conscientious citizens from all walks of life are trying their best to understand the complex impeachment issues now being deliberated in the U.S. Senate, the rules of evidence are central to the matter. Should the Senate allow additional sworn testimony from fact witnesses with firsthand knowledge and include relevant documents, he asks. As a lifelong Republican and a retired member of the U.S. Senate, who once served as a juror in a presidential impeachment trial, I am mindful of the difficult responsibilities those currently serving now shoulder. I believe, as I'm sure you do, that not only is the president on trial, but in many ways, so is the Senate itself. As such, I am strongly supportive of the efforts of my former Republican Senate colleagues who are considering that the Senate accept the introduction of additional evidence that they deem relevant. Not long ago, senators of both major parties always worked to accommodate fellow colleagues with differing points of view to arrive at outcomes that would best serve the nation's interests. If witnesses are suppressed in this trial, and a majority of Americans are left believing the trial was a sham, I can only imagine the lasting damage done to the Senate and to our fragile national consensus. The Senate embraces its legacy and delivers for the American people by avoiding the risk. Throughout the long life of our nation, federal and state judicial systems have largely supported the judicial norms of evidence, witnesses, and relevant documents. I respectfully urge the Senate to be guided by the rules of evidence and follow our nation's judicial norms, precedents, and institutions to uphold the Constitution and the rule of law by welcoming relevant witnesses and documents as part of this impeachment trial. That is your colleague, former Senator John Warner. Senators, there is a storm blowing through this Capitol. Its winds are strong, and they move us in uncertain and dangerous directions. Jefferson once said, "I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principles of its Constitution." The only anchor ever imagined, yet imagined by man, by which a government can be held to the principles of its Constitution. I would submit to you, remove that anchor, and we are adrift. But if we hold true, if we have faith that the ship of state can survive the truth, this storm shall pass. I yield back.
Thank you, Mr. Manager.
Mr. Chief Justice.
The Majority Leader
I
is
suggest
recognized.
the absence of a quorum.
The clerk will call the roll.
Mr. Alexander.
A live view of the U.S. Senate, and on the bottom of the screen you can see barely the top of the head of the Senate Republican leader Mitch McConnell and the Democratic leader Chuck Schumer. They are caucusing to determine how to proceed, whether or not they will continue into the evening hours and potentially into tomorrow morning, whether there will be a Saturday session, although that appears unlikely at the moment, and then whether the senators will use all the time to deliver speeches. Each would likely have up to 15 minutes apiece, which would add up to about 25 hours, moving a vote on the final articles of impeachment into next week. Keep in mind, Monday, the Iowa caucuses. Tuesday is the scheduled State of the Union address. So the question is, does this then move into Wednesday or Thursday, or is it resolved into the hours tonight? We just don't have the answers to that right now. Obviously, that's why the Senate leaders are meeting at the moment, as the trial takes a pause after hearing from the Democratic House impeachment managers and the president's defense lawyers, including Patrick Philbin, Jay Sekulow, and others. Alan Dershowitz, by the way, reportedly has left the defense team, according to a story in the Daily Mail. We'll continue to watch the scene on the Senate floor. If there's a further break, we'll open up our phone lines, get your phone calls, and get your reaction. We are approaching 20 minutes until the top of the hour, and just a short while ago, the president, with a tweet related to what's happening in the Senate and the impeachment trial, he wrote the following, quote, "The radical left do-nothing Democrats keep chanting fairness when they put on the most unfair witch hunt in the history of the United States Congress. They had 17 witnesses. We were allowed 0 and no lawyers. They did not do their job, had no case. The Dems are scamming America." That from the president, who is keeping an eye on what's happening on the Senate floor. We are live on C-SPAN 2. The Senate in a quorum call, and the reason why you're looking at a fixed shot is that those cameras are controlled by the Senate recording studio, the Sergeant at Arms. They are not C-SPAN cameras. They are controlled by the Senate, the same in the House of Representatives. On the bottom of your screen, you can see some conversations going on. John Cornyn, Republican of Texas, along with the Senate Democratic leader Chuck Schumer and Republican leader Mitch McConnell. Manu Raju of CNN tweeting the following: Schumer and McConnell are talking on the floor during this break, along with their top aides, as well as Senator Thune. This comes after Senator McConnell huddled with Senators Murkowski, Romney, Collins, and Lamar Alexander in his office during the last break. The focus, of course, on all how to end this trial. Our live coverage continues, and we're going to continue to watch the scene on the Senate floor, wondering what they were saying. Of course, we'd love to show you a better view of it, but this is what's provided to us by the Senate recording studio. Senate leaders talking on the bottom of the screen. You can see the tops of the head of Senator Mitch McConnell as he talks to his counterpart on the Democratic side of the aisle. We'll continue to watch and listen as best we can. You're watching C-SPAN's live coverage of the impeachment trial of President Donald J. Trump, live here on C-SPAN 2, which carries the Senate and those fixed cameras from the Senate recording studio. I do want to share with you some new information from Alex Bolton of the Hill newspaper. We'll continue to watch the scene, and of course, if a speaker comes to the floor, we will break away. But Alex Bolton reporting the following, quote, "Senators are bracing for a long impeachment debate and votes late Friday or early Saturday morning, as the Senate Majority Leader Mitch McConnell and Democratic Leader Chuck Schumer do not have an agreement on an endgame. They are meeting right now. You can see the two of them in the bottom of your screen discussing how to proceed." Alex Bolton saying that a Senate Republican aide said that McConnell is expected to announce a second organizing resolution this afternoon that would set the schedule for the end of the trial and a final up or down vote on those two articles of impeachment. Resolution, which could be offered as an amendment to the original organizing resolution that the Senate adopted Wednesday of last week, is subject to amendment, which means the Democrats could potentially force multiple changes to the document, with each vote preceded by 2 hours of debate. That means the Senate could battle into Saturday morning over what the trial should look like. There's talk of pausing the debate once the resolution is adopted and reconvening early next week to hold the final deliberations before voting on whether to convict or acquit the president. Senate Republican Conference Chair John Barrasso of Wyoming telling reporters one idea is to recess the trial Saturday and Sunday, return Monday to deliberate with a final vote expected on Wednesday. Senator Schumer telling reporters earlier today that he had not yet reached an agreement with Senator McConnell and warning Republicans of holding a vote on articles of impeachment into the wee hours of the night, saying, quote, "There is no agreement between Leader McConnell and myself." So that is the very latest as we watch Senate Republican Leader Mitch McConnell. He is talking to his colleagues on the bottom of the screen. And like all of you, we're waiting to hear more information in terms of the schedule, the next move, what the vote will look like, and whether they'll be into next week or whether this will be resolved into the night or potentially early tomorrow morning. Stay with us live here on C-SPAN 2. The Chief Justice of the United States is back standing just behind his chair as he continues to preside over the third impeachment of a sitting U.S. president. This is one of those split-screen days because we have the impeachment trial here in Washington and we have the Iowa caucuses across the 99 counties in Iowa. We are out there covering the events, and I mention that because MJ Lee of CNN pointing out, quote, at 4:41 p.m. Eastern Time, CNN's Dana Bash reporting that senators in the chamber have no idea what the evening will look like, how late things will go. One of those senators is Elizabeth Warren. She is due to be at a campaign event in Des Moines at 8 p.m. Eastern Time. Also expected to be in Iowa over the weekend, Senator Klobuchar and Senator Bernie Sanders, events that we'll be covering for the C-SPAN networks as part of our Campaign 2020 coverage. But of course, we're waiting, like you, to find out the schedule for the evening. And again, an agreement that needs to come in place between the Senate Democratic leader, Chuck Schumer, who did speak to reporters very briefly, did not take any questions, seemed to be a little bit perturbed as he talked to some of the reporters who were chatting behind him. You can see the video on our website at cspan.org. And on the bottom of your screen is the Senate Republican leader, Mitch McConnell, talking to his colleagues. We can't quite make out all the individuals that are around him, but we do know that there was a closed-door meeting during the break in which the Senate leader talked to his Republican colleagues to figure out what the end game and what the vote would look like, as well as senators who may speak, but again, under the Senate rules, potentially they could speak up to 15 minutes apiece, which adds up to about 25 hours. And so we continue to wait and watch live here on C-SPAN 2. And so this is classic politics, as each side now huddling to try to figure out the next move. Manu Raju, who is inside the Senate chamber with some new information, tweeting out just a minute ago that Senators McConnell and Schumer talked directly with a small group, including their respective floor generals, Laura Dove on the GOP side, Gary Myrick on the Democratic side, doing a good chunk of talking. Now the two leaders spoke for 10 to 12 minutes before Senator Schumer went to go huddle on his side with the Democrats. And so that's where things stand. You can see the Senate Republican leader with his colleagues, assuming that he's waiting to hear back from what Senator Chuck Schumer wants to do. Republicans clearly want to see this wrapped up. Ideally, they'd like to see a vote tonight or even early tomorrow morning. There's the talk that it could possibly go into next week. We expect to hear more when this quorum call comes to an end. Basically a procedural move by the Senate to delay any proceedings until they figure out the next move. And that's where things stand as we approach the 5 o'clock hour here in Washington. So a number of the senators have left. The pages are still there. The Chief Justice is standing just off from his chair in the center seat as the presiding judge of this trial, and Lisa Desjardins of the PBS NewsHour with this update saying that Senator Schumer has just left the chamber after lengthy sidebars, first with Senator McConnell and his floor staff, and then with his own Democratic floor staff. She asked the question, what's happening? They're trying to work out a deal for the next steps in the impeachment. And of course, that deal includes the calendar, with 4 of the senators who are running for the Democratic presidential nomination. All would much rather be in Iowa or New Hampshire in advance of the caucuses on Monday in Iowa and a week from Tuesday in New Hampshire. But of course, they are all here. There are scheduled events over the weekend with Senators Klobuchar, Warren, and Sanders. We will be live at many of those events, and we're getting word from thehill.com that if this does extend into next week, the Senate would take a recess Saturday and Sunday, returning on Monday. Keep in mind, Tuesday is the State of the Union, and there is no indication from the White House that the President or the House Speaker will cancel or change the State of the Union address. As a way of precedent, during the impeachment trial of President Bill Clinton back in 1999, the trial was still going on, but President Clinton did deliver his State of the Union address. Not once, though, did he mention the impeachment trial against him. That was 20 years ago. If you are a veteran of watching C-SPAN 2 and the Senate, this is a quorum call now in its 25th minute. Essentially a delay in the proceedings. The next thing that needs to happen is the vote on witnesses, and then whether the Senate will vote on those 2 articles of impeachment. But still more questions than answers from Senator Marsha Blackburn, Republican of Tennessee. She sent a tweet just a few minutes ago saying, quote, "Fighting corruption is not an impeachable offense. A policy disagreement is not an impeachable offense. Asserting executive privilege is not an impeachable offense. That from one of the Republican senators who was a juror. And according to the whip count from thehill.com, there are 47 Democrats and 2 Republicans in favor of witnesses, not enough to clear the threshold of 51. And a lot of speculation earlier if it was a 50-50 tie, the role of the Chief Justice, but that now appears not to be the case, with Senator Lisa Murkowski announcing, in part because she didn't want that to happen with the Chief Justice, she will vote against any witnesses. Also, we heard last night, of course, from Senator Lamar Alexander saying that even though he believes what the president did was wrong, he said that he doesn't think it rises to an impeachable offense and would also not vote for witnesses. As we watch the scene on the Senate floor, again, these cameras controlled by the Senate recording studio, the Sergeant at Arms, the Senate itself, John Brejnehan, a Politico, writing that the Senate impeachment trial for President Trump, quote, could drag into next week, even as Republican leaders appear to have the votes needed to prevent additional witnesses and testimony from being offered. Republicans suggesting that the trial could extend into next week due to scheduling concerns over the Iowa caucuses, that's on Monday, and the President's State of the Union address, that is slated for Tuesday. But Politico points out nothing is decided, and the party's spending about an hour hashing out the next steps during the lunches earlier today. The White House also saying it wants more time to prepare for their closing arguments. So that's the reporting from Politico right now, and we saw earlier a rather lengthy exchange, lengthy because it was probably the longest conversation, according to congressional watchers, between the Senate Democratic and Republican leader. They spoke for about 10 to 12 minutes. You saw that earlier in the bottom of your screen. They have now gone to their respective caucuses in meeting and gathering and talking, where Senator Schumer has left the Senate floor as he meets with his Democratic colleagues and floor managers, again, to decide how long they want to continue the process and whether or not it continues into next week. That's where things stand at the top of the hour, 5 o'clock Eastern Time here in Washington. The Chief Justice, John Roberts, who, by the way, turned 65 on Monday, has now left the dais. The chair is empty. He is talking to Senator Michael Bennet, Democrat of Colorado, one of the 4 Democrats running for president. And then on the other side of the screen, the right-hand side of the screen, Senators Cruz and Thune and Barrasso are talking to the Senate Republican leader, Mitch McConnell. Really, the ball now in the Democratic court in terms of what they want to do, what they can agree to. Under Senate rules, they can delay the process with a series of procedural votes. We certainly saw that last week when the procedural votes lasted until 2 in the morning, or just about 2 in the morning. And so the question is whether or not Senate Democrats want to continue to do that. They do not have the votes right now for any witnesses, or do they want to proceed with the vote on the articles of impeachment? And again, keep in mind, there are 4 Democrats running for president who very much want to get back on the road in Iowa this weekend. The polls are tightening. One survey has Senator Klobuchar in 3rd place. And then, of course, a week after that, the New Hampshire primary. So a lot at stake for the Democrats. The Republicans who want to wrap this up. Democrats say they still want witnesses. And then we also have the State of the Union address. So the calendar, politics, a lot coming in play as we continue to wait, watch, and see what Senator Schumer decides that he and the Democrats want to do next. The president, by the way, who is heading to Michigan, Caitlin Collins of CNN, pointing out that the president departed the White House without taking questions from reporters, breaking with his usual style. In fact, the CNN White House correspondent saying that he has not stopped to speak on the South Lawn since January the 13th. New reporting from the Washington Post, again, on what we're looking at and what may happen. The Post reporting that Senator John Barrasso of Wyoming telling reporters on Friday that Senator McConnell is working to chart the end of the impeachment trial, a process that is expected to begin into the evening. After the president's defense team makes arguments lasting up to 2 hours, the Senate will then vote on a motion to allow more witnesses and documents. That motion is expected to fail. Senator McConnell will then move to adopt an organizing resolution that will lay out procedures for the remaining of the trial, including possible closing arguments, senator speeches, and possibly closed deliberations. Now, that resolution will be debated for up to 2 hours. Then senators can offer amendments, each of which can be debated for up to 2 hours. It's that process that could lead into the late evening hours into early tomorrow morning. Now, once there are no more amendments to the debate, the Senate will then vote on the organizing resolution and then probably break for the night. What happens after that will be based ultimately on what passed in that organizing resolution. The schedule Friday night, according to Senator Barrasso, is up in the air. He's saying hopefully they won't take that kind of time. That's what we're looking at right now. The Democrats are meeting off the Senate floor. These cameras controlled by the Senate recording studio. Senator McConnell and Senator Schumer spent between 10 to 12 minutes, according to Manu Raju of CNN, which was their longest conversation in weeks, according to the CNN congressional reporter. There's also Senator Lamar Alexander and Senator Ted Cruz in the screen as they continue to chat. Senator John Cornyn, Republican of Texas, and Mike Lee of Utah. All as they continue to gather. Like you, we're waiting to see what happens. The Chief Justice, John Roberts, speaking to staffers on the Senate floor, and you can see Senator Mitch McConnell in a conversation that includes Senator John Barrasso of Wyoming, Senator John Cornyn of Texas, Lamar Alexander of Tennessee, and Ted Cruz of Texas, as they try to figure out what the Senate Democrats will be doing next. Robert Costa of the Washington Post with this tweet: "They aren't willing to come forward." That's a quote from Senator Sherrod Brown, Democrat of Ohio, adding, "That's one of the tragedies of this era. Endangered Republicans go all in for Trump." That on Robert Costa's Twitter page. Emily Cochran of the New York Times writing, "The Senate waits as the leadership negotiates." Quote, "The Senate temporarily recessed as the leadership appeared to be negotiating an agreement over the next steps in the president's impeachment trial. Colleagues milling around the floors. Senator Kyrsten Sinema, Democrat of Arizona, could be seen spotting and chatting with Senator Mitt Romney, Republican of Utah, while Representative Zoe Lofgren, Democrat of California, one of the House impeachment managers, spoke quietly with Democratic senators. But in the center of the chamber, the focus was on Mitch McConnell, the Republican leader, Chuck Schumer, the Democratic leader, who huddled with staff as they appeared to discuss the timing for the trial's next steps. Also want to share with you Lev Parnas, who's back on Capitol Hill. He appeared poised to speak to the senators. He wrote a letter that was issued earlier today to the Senate Republican leader saying Mr. Parnas would testify that at all times he was acting at the direction of Mr. Giuliani on behalf of his client, President Trump, and that the president and a number of people in his administration and the GOP were aware of the demands being imposed upon Ukraine. That from Joseph Bondi, who's the lawyer for Lev Parnas, who's making his way around the Capitol. He was briefly in the Senate chamber watching the proceedings. He is wearing an ankle bracelet and so was forced to be removed. But like so much other activity on Capitol Hill, as he's making his way across the corridors, either in the Russell Senate Office Building or in the U.S. Capitol, he is followed by reporters trying to get more information on what he would say if he testified as a witness. But again, the senators right now appear highly unlikely they will get the votes for witnesses. The Chief Justice is now seated in the dais. We'll watch and listen. Pat Cipollone, who is the president's defense lawyer and White House counsel, is back on the Senate floor. Again, if you're just tuning in, we're in a quorum call that is now approaching 1 hour. These are normally rather short breaks during Senate business, but right now the question is how long this trial will continue. Will it go into the evening? Could it extend into next week? There are questions that we just don't have answered at the moment. Want to share with you some other news, and this is just in courtesy of NPR. One of the key individuals in the center of this Ukraine story, Marie Yovanovitch, the former U.S. ambassador to Ukraine, she has retired from the State Department. She was removed from her post back in May of last year and served as a key witness in the impeachment inquiry into President Trump. And so again, that news from NPR that Marie Yovanovitch has now retired from the State Department. After more than 30 years, she had a number of postings, including her most recent one in Ukraine. Chad Pergram, who covers Congress for Fox News, saying Fox is told that there are some Republicans who are pushing to end this trial this weekend and strike while the iron is hot and not tempt fate. Other Republicans think there should be an effort to have senators speak and deliberate the articles of impeachment. Chad also saying that the Senate takes this pause in the trial. The problem is that Senator McConnell doesn't have everyone on his side lined up on how to finish the trial. That's why the action is moved off the floor as both sides try to negotiate a path forward. We're going to continue to watch that. If this stretches into the next hour, we'll open our phone lines, get your reaction and calls. But for the moment, we'll continue to watch as best we can with the single camera inside the Senate chamber. Camera is controlled by the Senate recording studio. Alana Train from Axios has a tweet just a moment ago saying that as of now, there have been no discussions of moving the State of the Union address due to the impeachment trial. That from senior Democratic Senate aides saying that there's been no outreach to Speaker Pelosi's office from the White House. Of course, it's the House of Representatives that actually holds the State of the Union in a joint session of Congress for a very simple reason. The House is much larger than the Senate chamber to accommodate members of the House, the Senate, and also members of the President and Cabinet, and the members of the Supreme Court, including the Chief Justice, John Roberts, who at this very moment is just off the dais, is presiding over the trial of President Trump. We're going to continue to watch this and share with you some of the closing arguments earlier today from lawyers representing the President and the House impeachment managers. Let's watch and listen.
Mr. Sekulow.
Chief Justice, members of the Senate. Over a 7-day period, you did hear evidence. You heard evidence from 13 different witnesses, 192 video clips, and as my colleague, the Deputy White House Counsel said, over 28,000 pages of documents. You heard testimony from Gordon Sondland. He's the United States Ambassador to the European Union. You heard that testimony. He testified in the House proceedings. I did not have an opportunity to cross-examine him. If we get witnesses, I have to have that opportunity. William Taylor, former acting United States Ambassador to the Ukraine, testified. You heard his testimony. We didn't get the opportunity to cross-examine him. He would be called. Tim Morrison, the former senior director for Europe and Russia of the National Security Council. You saw his testimony. They put it up. We didn't get an opportunity. We did not have an opportunity to cross-examine him. Jennifer Williams, Special Advisor on Europe and Russia for Vice President Mike Pence. You saw her testimony. They put it up. I did not have the opportunity to cross-examine her. If we call witnesses, we would have to have that opportunity. David Holmes, the political counsel to the United States Embassy in Ukraine, saw testimony from him. We're not able to cross-examine. If he's called, or if we get witnesses, we will call the ambassador and we will cross-examine. Lieutenant Colonel Alexander Vindman, you saw his testimony appear before the House. We didn't have the opportunity to cross-examine him. If we call witnesses, we will, of course, have that right to cross-examine him. Fiona Hill, she is the former Senior Director for Europe and Russia on National Security Council. She testified before the House. If we have witnesses, we have the opportunity to call her then and cross-examine Fiona Hill. Kurt Volker, former United States Special Representative for Ukraine negotiations. They called him. We did not have the opportunity to cross-examine. If we're calling witnesses, these are witnesses you've heard from, we would have the right to call witnesses and to cross-examine Mr. Volker. George Kent, the Deputy Assistant Secretary of State for the Bureau of European and Eurasian Affairs. You saw his testimony. They called him. If we have witnesses, we have the right to call that witness and to cross-examine Deputy Assistant Secretary Kent. The former United States Ambassador to Ukraine, Ambassador Yovanovitch. They called her. You saw that testimony. We did not have the opportunity to cross-examine her. If we have witnesses, we would have to call her. Laura Cooper, Deputy Assistant Secretary of Defense for Russia, Ukraine, and Eurasia. They called her. You saw her witness testimony right here. We did not have the opportunity to cross-examine her. We would have to be given that opportunity. These are witnesses against the president. Laura Cooper, Deputy Assistant Secretary of Defense for Russia, Ukraine, and Eurasia. Again, same thing. David Hale, Undersecretary of State for Political Affairs. He was called by the House. You saw his testimony. We never had the opportunity to cross-examine. If we have witnesses, we have to have the opportunity to do that. There were other witnesses that were called, or you saw their testimony or heard their testimony, where it was referred to: Catherine Croft, the Special Advisor for Ukraine negotiations, Department of the State; Mark Sandy, the Deputy Associate Director for National Security Programs; and Christopher Anderson, Special Advisor for Ukraine negotiations, Department of State. You heard their testimony referred to. We did not have the opportunity to cross-examine them. So this isn't going to happen if witnesses are called in a week. Now, that's just the witnesses that have been produced that you have seen by the House managers. You are being called upon to make consequential constitutional decisions. Consequential decisions for our Constitution. We talk about the burden of proof. I've said this before, I'll say it again. 31 times the manager said they proved their case. 29 times they said the evidence was overwhelming. Manager Nadler, he didn't only say it was overwhelming in his view. On page 739 of the congressional record, he's very clear. He says, not only is it strong, there is no doubt. That's what he says. The one thing that the House managers think the President and Council's got right is quoting me, talking about Mr. Nadler, Manager Nadler, as saying, beyond any doubt, it is indeed beyond any doubt. Now, of course, we think that they have not proven their case by any stretch of any proper constitutional analysis. In the Clinton investigation, they talk about witnesses being called, but the three witnesses that were called had either testified before the grand jury or before the House committees. These weren't new witnesses. What Mr. Philbin said is correct. Under our constitutional design, they're supposed to investigate. You are to deliberate. But what they're asking you to do has now become the investigative agency, the investigative body. If they needed all this additional evidence, which they said they don't need, and by the way, not only did they say it in the record, this is House Manager Nadler, quote, this is on, when he was on CNN back on the 15th of this month, we brought the articles of impeachment because despite the fact that we didn't hear from many witnesses, we heard from enough witnesses to prove the case beyond any doubt at all. The same can be said of Representative Lofgren. You know, we have evidence proving the case through, for example, at the meeting when Bolton said it was a drug deal. Well, we have fact witnesses. Hill was there, Vindman was there, Sondland was there. So this idea that they haven't had witnesses, that's the smokescreen. You've heard from a lot of witnesses. The problem with the case, the problem with their position is, even with all of those witnesses, it doesn't prove up an impeachable offense. The articles fail. I think it's very dangerous if the House runs up, which they did, articles of impeachment quickly, so quickly that they are clamoring for evidence, despite the fact that they put all of this evidence forward. They got their wish of an impeachment by Christmas. That was the goal. But now they want you to do the work they failed to do. But as I said, time and time again we heard, you didn't hear from witnesses, you didn't hear from many witnesses. Mr. Schiff modified that a little bit today. A little bit. You heard from a lot of witnesses. But if we go down the road of witnesses, this is not a one-week process. Remember I talked about the waving the wand and Ukrainian corruption in Ukraine was gone. You're not going to have a witness wand here where we just say, okay, you got a week to do this and get it done. There's no way that would be proper under due process. But you know, due process is supposed to be for the person accused. And they are turning it on its head. They brought the articles before you. They're the ones that rushed the case up and then held it before you could actually start the proceedings. But they're the ones that passed the articles before Christmas. You know, we talked a lot about the court system and the fact that they were seeking witnesses. And when it got close to actually having a court proceeding, they decided that they didn't want to have that witness go through that proceeding. They actually withdrew the subpoena to moot the case out. How many constitutional challenges will we have in this body because they placed a burden on you that they wouldn't take themselves in putting their case forward? If we look at our constitutional framework and our constitutional structure, that's not the way it's supposed to work. Now, our opposition to this motion is rather straightforward, as I've said. We came here ready to try the case on the record that they presented. The record that the managers told us was overwhelming and complete. Mr. Schiff went through every sentence of the articles of impeachment just a few days ago and said, proved, proved, proved. The problem is what it proved is not an impeachable offense. You could have witnesses that prove a lot of things, but if there's not a violation of a law, if it doesn't meet the constitutional required process, the constitutional required substantive issues of do these articles, these allegations rise to the level of a sufficient for a removal of office for a duly elected president of the United States? It doesn't. And especially so when we are in an election year. I am not going to take the time, your time, which is precious, to go over in each and every allegation about witnesses that I could. I could do it. I could stand here for a long time. I'm not going to do that. I'm just going to say this. They created the record. Do not allow them to penalize the country and the Constitution because they failed to do their job. With that, Mr. Chief Justice, we yield our time.
Thank you, counsel.
That from Jay Sekulow, one of the president's attorneys, earlier today during their final round of arguments. On the bottom of the screen, a number of Republican senators are talking, including Mike Lee and Marco Rubio, along with Ted Cruz of Texas. Pat Cipollone, who is the president's lawyer, making news because according to the John Bolton book, he was in a meeting back in May of last year in which, according to John Bolton, the president said to begin the conversations with the Ukrainian leader to talk to Rudy Giuliani. That was 1 month after Joe Biden formally entered the Democratic presidential race. This from NPR, that Marie Yovanovitch, the former U.S. ambassador to Ukraine, has retired from the State Department. She was abruptly removed from her post back in May of last year and has been a key witness in the impeachment inquiry into President Trump. Again, NPR reporting that Ambassador Marie Yovanovitch has retired from the State Department. So according to the New York Times, the negotiations that are going now between Democrats to decide how to proceed, the next step in this process is to vote on additional evidence, including witnesses, and the Republicans have the votes to block that, at least 51
colleagues,
votes.
If everyone would return to their desk. I ask consent that further proceedings on the quorum call be dispensed with.
Without objection.
The Democratic leader and I have had an opportunity to have a discussion, and it leads to the following. We'll now cast a vote on the witness question, and once that vote is complete, I would ask that the Senate stand in recess, subject to call of the chair.
Thank you. Without objection, so ordered. The question is, shall it be in order to consider and debate under the impeachment rules any motion to subpoena witnesses or documents? The yeas and nays are required under Senate Resolution 483. The clerk will call the roll.
Mr. Alexander? No. Ms. Baldwin? Aye. Mr. Barrasso? No. Mr. Bennett? Aye. Mrs. Blackburn? No. Mr. Blumenthal? Mr. Blunt? No. Mr. Booker? Aye. Mr. Bozeman? No. Mr. Braun? No. Mr. Brown? Aye. Mr. Burr? No. Ms. Cantwell? Aye. Mrs. Capito? No. Mr. Cardin? Aye. Mr. Carper? Aye. Mr. Casey? Aye. Mr. Cassidy? No. Ms. Collins? Aye. Mr. Coons? Aye. Mr. Cornyn? No. Ms. Cortez Masto? Aye. Mr. Cotton? No. Mr. Kramer? No. Mr. Crapo? No. Mr. Cruz? No. Mr. Daines? No. Ms. Duckworth? Aye. Mr. Durbin? Aye. Mr. Enzi? No. Ms. Ernst? Mrs. Feinstein? Aye. Ms. Ernst, no. Mrs. Fisher? No. Mr. Gardner? No. Mrs. Gillibrand? Aye. Mr. Graham? No. Mr. Grassley? No. Ms. Harris? Aye. Ms. Hassan? Aye. Mr. Hawley? No. Mr. Heinrich? Aye. Ms. Hirono? Aye. Mr. Hoven? No. Mrs. Hyde-Smith? No. Mr. Inhofe? No. Mr. Johnson? No. Mr. Jones? Aye. Mr. Kane? Aye. Mr. Kennedy? No. Mr. King? Aye. Ms. Klobuchar? Aye. Mr. Langford? No. Mr. Leahy? Aye. Mr. Lee? No. Mrs. Leffler? No. Mr. Manchin? Aye. Mr. Markey? Aye. Mr. McConnell? No. Ms. McSally? No. Mr. Menendez? Aye. Mr. Merkley? Aye. Mr. Moran? No. Ms. Murkowski? No. Mr. Murphy? Aye. Mrs. Murray? Aye. Mr. Paul? No. Mr. Perdue? No. Mr. Peters? Aye. Mr. Portman? No. Mr. Reed? Aye. Mr. Risch? No. Mr. Roberts? No. Mr. Romney? Aye. Ms. Rosen? Aye. Mr. Rounds? No. Mr. Rubio? No. Mr. Sanders? Aye. Mr. Sass? No. Mr. Schatz? Aye. Mr. Schumer? Aye. Mr. Scott of Florida? No. Mr. Scott of South Carolina? No. Mrs. Shaheen? Aye. Mr. Shelby? No. Ms. Sinema? Aye. Ms. Smith? Aye. Ms. Stabenow? Aye. Mr. Sullivan? No. Mr. Tester? Aye. Mr. Thune? No. Mr. Tillis? No. Mr. Toomey? No. Mr. Udall? Aye. Mr. Van Hollen? Aye. Mr. Warner? Aye. Ms. Warren? Aye. Mr. Whitehouse? Aye. Mr. Wicker? No. Mr. Wyden? Aye. Mr. Young? No. Mr. Blumenthal? Aye.
Are there any senators in the chamber wishing to change his or her vote? If not, the yeas are 49, the nays are 51. The motion is not agreed to. Under the previous order, the Senate stands in recess, subject to the call of the chair.
All right, no more witnesses. The rest of the schedule for the evening still to be decided. We'll keep an eye out for the Senate to come back into session. In the meantime, we want to get your reaction to what is going on. We've divided our phone lines a little bit differently now. Guilty, not guilty, and undecided when it comes to what you've heard this week. If you think the president is guilty and should be convicted, 202-748-8920 is a number for you to call. If you say not guilty and should be acquitted, 202-748-8921. If you're still undecided, 202-748-8922, and you can always text us at 202-748-8903. Make sure to include your name, your city, and your state, and we'll begin taking your calls in just a minute. So don't know what's going to happen the rest of the night, if there's going to be amendments on the process going forward, what the discussion's going to be when the final vote to convict or acquit is going to be. We'll also be waiting for senatorial reaction. Here comes the Democratic leader, Chuck Schumer. Let's listen in.
I'm just going to make a statement. I'm not going to take questions.
Going to make a statement. Okay, thanks.
Great.
Man, you beat everyone down here. It's good cardio, right? Huh? Yeah, that's fine.
How are your talks going with McConnell? Okay, I'm going to make a brief statement. Okay. To not allow a witness, a document, no witnesses, no documents in an impeachment trial is a perfidy. It's a grand tragedy, one of the worst tragedies that the Senate has ever overcome. America will remember this day, unfortunately, where the Senate did not live up to its responsibilities, where the Senate turned away from truth and went along with a sham trial. This, if the president is acquitted with no witnesses, no documents, the acquittal will have no value, because Americans will know that this trial was not a real trial. It had no witnesses, no documents. It is a tragedy on a very large scale. I will be now going up to my caucus to discuss what we're doing next. I will not talk about it here. Okay? Thanks.
And let's hear from Elaine, who's calling in from Rawls, Texas. Elaine, you say the president is not guilty. Why?
Because I feel the Democrats have done this because he was elected president and Hillary wasn't, and they have been out to impeach him since the day he was elected.
And so therefore he's not guilty from the evidence you've heard this week, is that correct?
Yes, because they have said from the very beginning they were going to impeach him, and he has done nothing but good for America. He has done everything he has said he was going to do when he was running for president.
Garland, Euclid, Ohio. You say guilty. Why?
I mean, I think people have been found guilty of, like, harsher and lesser crimes with less evidence. And I just really feel this is a travesty, and I hope that the Republicans are voted out in November.
That's Garland in Euclid, Ohio. Pat Leahy is talking with the press, or moving around with the press outside the Senate floor. We have no idea how long this recess is going to be, subject to the call of the chair. But in the meantime, we'll take your calls and get your reactions. Susan, Florence, Kentucky, what do you think?
I think he's not guilty. They have not proven their case. They did not give due process. They did not follow procedure. He's not guilty. That's all there is.
Craig Kaplan of C-SPAN tweets out that the Senate defeats the motion to allow for votes to subpoena witnesses or documents in impeachment trial on a near-party line. 2 Republicans, Senators Collins and Romney, voted yes with all the Democrats. Where are you calling from, caller? Caller? 202 is the area code. 748-8920 for those of you who think he is guilty. 202-748-8921 for those of you who think he is not guilty and should be acquitted. If you're still undecided, 202-748-8922. And finally, you can text us if you can't get through on the phone lines. Just include your name and city, 202-748-8922. 8903. Charles, Bonita, California. You say guilty. Why?
The president may have won the battle. The president's been a president, so men may have won the battle. As the truth comes out in the days ahead, and it will, they will lose the war. And in doing so, the American people will win because we'll have the truth. And we're going to act on the truth.
Do you expect your Republican colleagues to try to force through an acquittal vote tonight?
I do not.
How do you see this playing out?
I see this playing out in the next couple of weeks. Additional information, additional people step forward with knowledge of what actually went down, and paint a clearer picture, a fuller picture. And I think at the end of the day, and it may well come before Bolton's book is actually published.
Would you encourage your Democratic colleagues in the House now to pursue John Bolton through subpoenas or other means, since it won't happen in the Senate?
We're going to have a caucus right now, and let me think about that. I don't know. Thank you all.
And a little bit from Senator Carper, a Democrat of Delaware. Charles, Bonita, California, thanks for holding. If you could hold one more second, we've got Ron Wyden of Oregon speaking to the press.
Places Hillary Clinton won. Everybody said, hey, you got to have these witnesses. You have to have an equal number. And we're still obviously working our way through that. But what I'm hearing and seeing essentially everywhere is that people have said this is all about fairness, it's about common sense, get it done.
Would you encourage your colleagues in the House now to pursue John Bolton and these other witnesses, since it won't be done in the Senate?
I have said that I will look at every opportunity to make sure that the relevant witnesses and the relevant facts get out. I will tell you that is going to happen regardless of what position I take, and I think it will happen sooner rather than later. At the rate in which we're going, practically every single day, there is another development. It is not a small development, it's a major development. So I'm not going to stand before you and say my position on urging people to do X, Y, and Z is most relevant. I think at the rate we're going to see significant development. Some people say, well, there'll be books and the like months and years from now. I think it's going to continue to be something we see every day. Okay, got to get in.
And Charles, in Bonita, California, you've been very patient. Why do you think the president is guilty?
Well, he's demonstrated himself to be a traitor on multiple occasions, starting in Helsinki. His continued communications with Putin lead me to believe that the reason he was attacking the Ukrainians had nothing to do with anything except his own personal benefit to get himself reelected and to make Putin happy. Okay, as he said before, unfortunately, there used to be ways to deal with traitors, and he should think about that.
Tim, East Brady, Pennsylvania, not guilty. Why is that, Tim?
Well, I'd like to clarify my fact on people calling in and associating the Trump administration with Russian interference and stuff. Nothing concrete has ever been implemented. It is assumed by the government that there was interference with Russian counterpart. Let's go back to the Obama administration while we're at it. I mean, it is definitely proven there was election interference with the Obama administration. As far as to Trump's accountability for a guilty or not guilty verdict in this impeachment trial, our president, let's face it, is a boisterous man. He's loud. He gets the job done. He doesn't make any bones about it. He's very transparent about it, and he's a straightforward guy. Yeah, he does some things that are off color to people. He's not quite presidential, but he's Trump. That's what he does.
Tim, did you hear anything this week that changed your mind?
Yes, a lot of testimony and run around back from the Democratic side of the House representatives. It really blew my mind, some of the stuff, the hypocritical situations that were put in by Nadler and Schiff himself.
Thank you, sir. Linda, out down in Wadesboro, North Carolina. Linda, what did you hear this week that makes you think the president's guilty?
A lot of things in reference to that, due to the fact that some of the news that came out today, I always thought he was. He even said in a way that he was. And the things that came out today from Bolton Book, and to see that one of his lawyers was sitting up there involved in it and then going to defend you, that's just like somebody stole from you, but yet saying they didn't because they didn't get caught at the time. But then when they caught, oh, I didn't mean to do that. No. He's guilty. He's guilty. It's going to come out. And to the Republicans that are afraid of him to vote, things happen to this country. The blood is going to be on their hand as well, and they'll see in November through the voting. Thank you.
Senator McConnell has released a statement on the next steps in the Senate impeachment trial. A majority of the U.S. Senate has determined that the numerous witnesses and 28,000 plus pages of documents already in evidence are sufficient to judge the House manager's accusations and end this impeachment trial. There is no need for the Senate to reopen the investigation, which the House Democratic majority chose to conclude and which the managers themselves continued to describe as overwhelming and beyond any doubt. Never in Senate history has this body paused an impeachment trial to pursue additional witnesses with unresolved questions of executive privilege that would require protracted litigation. We have no interest in establishing such a new precedent, particularly for individuals whom the House expressly chose not to pursue. Senators will now confer among ourselves with the House managers and with the President's counsel to determine next steps as we prepare to conclude the trial in the coming days. That's a statement from Senator Mitch McConnell in the last few minutes. Siri's in Concord, North Carolina. Siri, what'd you hear this week and what's your conclusion?
Well, I do not think he is guilty, never have. The Democrats have tried to impeach him the whole time he's been president, and I just think what he could have done, he's kept all his promises. What could he have done if he didn't have to fight the Democrats? It takes a tough guy to take on the corrupt and lying Democrats and the lying media. And I am so glad we have him for president.
So why not hear from more witnesses if there's more information out there?
If they wanted more witnesses, they should have done that when they were in the House.
Thank you, ma'am. Angel's in Hope, Arkansas. Angel, what's your conclusion?
Hey, I think he's guilty because I believe that all he cares is about staying in power. Everything shows us that he's guilty. But besides that, because he don't want to show the paperwork and the witnesses, he's been stopping all that. And honestly, I've been serving as a jury duty 5 times. I'm 35 years old, and I serve as jury duty for 5 times so far. And in a trial, if they don't show any paperwork or witnesses, there's not a trial. I will refuse to be a jury duty because that's not fair.
But Angel, the way this is set up, isn't the House supposed to take that role?
Yes. Well, what happens here is they're not trying to do their job. I'm very upset and disappointed because I wish. I mean, he is our president. I vote for him, and and I'm very disappointed for all his job. I mean, he's been doing good stuff, but our economy was up anyways. Our President Obama, he did a good job, I think. But like you say, our Congress, they're supposed to do this and decide what to do. But to be honest, as a juror, which I was for 5 times, I think our Congress, they're looking forward to being in power. They're not being honest, Senator, many senators, they're just trying to be over there.
All
in
right.
that power.
Thank you for calling in. Laura Litvan, Bloomberg, tweets out that senators in both parties are caucusing now in separate rooms off the Senate floor. They're trying to see if everyone can agree to rules to finish the trial and have a vote on the verdict, perhaps next week instead of today. Carl's out in Washoe Valley, Nevada. Carl, what's your conclusion after this week?
To tell you the truth, I'm not 100% sure how I feel about all of it. What I'm really seeing is a problem with credibility towards from the prosecution. It doesn't make much sense to me.
All right. That's it?
So what I'm to the point that what's happening is Adam Schiff has been caught in quite a few lies, and specifically when reading the transcripts, pretending as though he's reading the transcripts verbatim and actually making shit up in his head.
David's down in Georgia, Toccoa, Georgia, is it, David?
Yes, it is.
All right. Well, go ahead and tell us your conclusion.
I'd vote not guilty. I've watched the trial from the House starting it to, I've watched it all through the Senate so far, and with the House pulling some of the stuff that they did, and my Congressman Doug Collins has done a great job in filling us in what's going on with the House. So I would vote not guilty. The only thing I would say about Adam Schiff, that guy could sit on the most complicated lie detector device there was, and he could pass every lie that he told because he is so smooth at it.
So, David, there's a chance that this could extend into next week. What do you think about that?
I'd rather see it over with tonight, and then I'd get some more sleep. The old man, 82-year-old, needs his sleep, and I will set up and watch it and see what goes on. But I do think that the president's lawyers, counsel, did a good job of presenting their thing, and I didn't see anything that the House did that was so overwhelming that they could even call an impeachment and get a vote for it. And the reason they did is because they control the House. And even some of the Democrats voted for with the Republicans on that side. But it's one of the things that happens in politics, and I'm not saying all politicians are liars, but there happens to be a lot of lies that falls around in the political circuit.
Senator Ted Cruz tweeted out at 5:51 p.m. after nearly 2 weeks of the impeachment trial, the Senate just voted to move forward without additional witnesses by a vote of 51 to 49. We have heard more than enough, he tweets. The House managers failed to make their case. It is time to acquit the real Donald Trump. And somebody texted in, not guilty, thank you. And Senator Tina Smith, Minnesota, Democrat. Sad moment for our country to see the U.S. Senate reject bipartisan precedent and block witnesses in this trial. Yolanda, Milledgeville, Georgia. You called in on the guilty line. Why do you think the president's guilty, Yolanda?
because he's not doing anything that he's supposed to do as far as like letting people, like the elderly people, letting them keep their Social Security. He was talking about taking food stamps, Social Security checks, and things like that. I don't think that's right at all.
But
I don't agree with
But that's
that,
not
period.
that's not part of what this trial is about.
Well, I don't think he done. I don't think he's done anything that he's supposed to do. I really don't.
All right, Ralph, Picayune, Mississippi. Ralph, what's your conclusion when it comes to the
My
two
conclusion
articles
is he's
of
not
impeachment?
guilty, and he never was guilty from the very start. Ever since it started in the House, those people has been running around saying,
Ralph,
he
you
is
got to
the-
turn down your TV. If you're going to call in, you got to turn down the TV, otherwise you get the delay. So we appreciate that. Senator Cory Booker, Democrat, New Jersey, his tweet at 5:50 p.m. The Senate may have closed its eyes to the truth, but history will remember. Republicans just voted not to allow a single witness in this impeachment trial. The world's greatest deliberative body has abdicated its responsibilities to the Constitution. Alex, Berkeley, California. What's your impression of this week?
Yeah, he's definitely guilty. I've been watching the trial for the last week live, and every single day it's a disappointment after disappointment. The White House counsel, it seems to me like they're arguing over like small technicalities instead of actually arguing the case. It's extremely disappointing. And then this partisan vote today is just makes me feel like justice has not been served at all.
Are you a student at UC Berkeley?
Yes, sir.
And what are you studying?
Electrical engineering and computer science.
Is there a variety of opinion on the campus out there?
No, it's pretty monoculture here. However, I believe some people are arguing that maybe the House didn't do a good enough job creating the case, and it might have backfired on them.
Thank you, Alex. Let's hear from Dan in Indian Lake Estates. Where is Indian Lake Estates, Dan?
That's a community in Central Florida.
Thank you,
Not
sir.
where I live, but we share a zip code. So a couple things. I'm a registered independent. I live in rural Polk County, Florida. I went to school and got a degree in criminal justice, so I've paid attention to similar things throughout the entire process here. I'm undecided because I feel like, with my knowledge of the criminal justice system, I look at the House as the grand jury. We are looking at things that may bring probable cause to go to a trial. Generally, when you're running into a trial, there is continued discovery, or you can even ask for more evidence to be entered due to more things popping up in the middle of a trial. The fact that I have two senators in this state who both voted no to hear from further people to get more information is it is absolutely absurd. I will be voting no on them coming back in to be senators for this state. It is ridiculous.
But now you called in on the undecided line. Where's the undecided part of this equation?
Because I need more. I need more information. I've seen things from both sides that are fantastic in their version of their story that they're both telling.
We had a caller earlier this afternoon who compared the House to the grand jury and the Senate then to the actual trial. What do you think of that analysis?
That's exactly the way I look at it. When you're doing an inquiry for any type of criminal cases and things like that, that's exactly what you're doing. You're looking for more stuff, and then when it comes time for trial, then both sides usually discuss which witnesses that they want. You get to pick jurors. In this case, the jurors are supposed to pick who they talk to, what information they have. I heard both sides say that the other side was leaving out information. They were both doing it. So it's pretty terrible that they're both doing it.
All right. Richard Shelby, Republican, Alabama Senator. It's evident to me that POTUS's actions are not worthy of removal from office, and I do not believe additional evidence would prove otherwise. Matt, Doylestown, PA, what's your reaction to this week?
Well, very similar to the gentleman who just called in from Florida, who basically laid it out and agreed with a previous caller saying that the House had to decide whether to bring charges or not, just like a grand jury. And in a grand jury, the defense doesn't get to cross-examine. Despite that, they were invited to, despite the lies that were told by the defense during the actual trial that's happening now. We've seen the equivalent of opening arguments, and now the defense is taking control of it and saying, well, we're not going to let there be any witnesses or any evidence shown. I think anyone who says guilty or not guilty without hearing any witnesses in front of the defense, I think Jay Suklo made the perfect argument. Let us cross-examine. Go ahead, cross-examine. That's what I say.
If you're just joining us, the Senate is in recess subject to the call of the chair. They voted no on witnesses, and we do not know what the path is going forward at this point. But Majority Leader McConnell issued this statement a little while ago. A majority of the U.S. Senate has determined that the numerous witnesses and 28,000 plus pages of documents already in evidence are sufficient to judge the House manager's accusations and end this impeachment trial. There is no need for the Senate to reopen the investigation, which the House Democratic majority chose to conclude and which the managers themselves continued to describe as overwhelming and beyond any doubt. Never in Senate history has this body paused an impeachment trial to pursue additional witnesses with unresolved questions of executive privilege that would require protracted litigation. We have no interest in establishing such a new precedent, particularly for individuals whom the House expressly chose not to pursue. Senators will now confer among ourselves with the House managers and with the President's counsel to determine next steps as we prepare to conclude the trial in the coming days. Next call is Bill in Dunfermline, Illinois. Bill, what's your conclusion after this week?
Yes, I find him not guilty. The Democrats have been after him since the day he was elected. They lie, they cheat, they do everything that's dishonest. They're a bunch of scumbags. I never seen such a bunch of dishonest people in my life. When it comes to election time, we definitely need to get rid of those people and put in some good quality people. And that's pretty much, I also want to say that I believe Trump is the greatest president in my lifetime. And I'm 63 years old, and I've never, ever had a politician that said he was going to do so many things, and he did it. He's the only politician that's ever done that. The rest of them just lie to you.
Thank you, sir. Stephanie, Lakewood, Ohio. What do you think?
He's guilty. It doesn't even seem like the facts are in dispute at this point. It's just a matter of opinion as to whether or not asking a foreign government to help us win and help the sitting president win another election, is that okay for a president to do? And the answer is no. We don't ask foreign governments to help us win an election. That's not in the best interest of the country. It's only in the best interest of the president. It was an entirely self-serving motive behind what he did. And we have the documentation, we have witnesses that show what happened, and the idea that all of that is wrong and everyone is lying except for the president, who lies constantly and has been proven to lie constantly, is just ridiculous. It makes no sense.
Thank you, ma'am. You can see the senators. It looks like they're coming back onto the Senate floor. That doesn't mean anything at this point. We don't know what is going to happen, but we will certainly go live as soon as they gavel back in. The president tweeted this out at 6:05 p.m. Democrats equal 17 witnesses. Republicans equal 0 witnesses. David, Lamar, Missouri. David, what's your conclusion after this week?
Yes, thank you very much for taking my call. I've watched it from the beginning and up until this point right now, and I'm very pleased with what the Senate has done and accomplished to this point. I truly do wish that they would just keep moving along, take their votes, and pass their ballot. I do not encourage anyone on the Republican side to vote against our President of the United States. I understand the Democrats' point of view. They are what they are. They're either part of the problem or they're part of the solution. And I don't think that they are part of that solution. So let's move on. Let's get back to work. Vote not guilty and leave our president alone.
And Senator Lindsey Graham, chair of the Judiciary Committee, tweeted this out. This has been a partisan impeachment from day one, terrible on process and dangerous on substance. It rings hollow for Adam Schiff to talk about wanting a fair process. Finally, the sooner this trial is over, the better for the American people. Bamesh, Rice, Virginia, you're calling in on the guilty line. Why is that?
Yes, I'm just calling to just say that this has been a scam from the beginning, even with Trump getting in office. I remember Trump when I was living in New York for over 30 years, and I've seen some of his actions and his tactics and how he manipulated, citizens of New York regarding the West Side Highway deal with the apartments and all there and the land deals that he made. And now that he is the president of the United States, I see him still making deals that are one-sided in his interests and things that are not for the people. And I live in Virginia, in one of the most biased counties that I grew up in here in Virginia. And I'm going on 62 years old, and all I see is us going backwards to those same Jim Crow era laws that he's trying to push through these same antics. And I say this to the Republicans, the real Republicans, because this is not a Republican party that I see. And all I see is the Trump party, not a Republican party. For the Democratic Republic is what we should be standing for in this country, not a scam and a sham and a cover-up. I've never seen nothing like this since this early 60s when I came along. And this is what I see us resulting back to, those same things that held not just blacks down, but held everybody back in so many ways, But if Trump stays in there any further than where we are now with him, believe me when I tell you, this country is going to regret it. We're seeing it happening already with the stock market. It's not the virus that's causing the stock market to crash. They're fudging figures. All I see is Wall Street passing money back and forth. No money is going into the Treasury, at all at this point. And it's sad to see us go backwards. And all I can say is this is nothing but a cover-up.
All right, that's Bamesh in Rice, Virginia. Kyle Cheney of Politico, reporter, tweeting out that Senator Roy Blunt, Republican of Missouri, is saying that the Senate is planning to resume Monday and finish the trial on Wednesday. Ryan, Philadelphia, what have you heard this week, Ryan?
Hi there. So the charges against President Trump are really serious, and it's the responsibility of the Senate to hear those charges and hear all the evidence against the president. But also, when the president and the executive branch has obstructed the investigation, it's also the responsibility of the Senate to stand up as a check on that branch. And the Senate has really abdicated both of those responsibilities in covering up the evidence and in refusing to stand up to the president. And I think when the charges are this serious and the evidence is this overwhelming, it's really crass for Republican senators to just dismiss this out of hand because it's politically expedient. The other big takeaway I've had from this week has been that President's counsel is really arguing based on a legal standard that doesn't apply to impeachment. They frame this as a criminal trial, and you need what they call due process. You need to think beyond a reasonable doubt is the standard. But impeachment is a political process, and if senators feel that the president is a danger to the country, or if they think it's more likely than not he broke the law, they should convict him. And based on the evidence I've seen, I think he should be convicted. Ryan, what is that singular piece of evidence that the House managers presented that convinced you of it? I think, really, if you just look at the transcript, you don't need lawyers to read through that and tell you what it means. It seems pretty clear to me. He asked for an investigation into a political opponent. It was an investigation that was meritless. It was a conspiracy theory. And to me, that screams not in the national interest, but rather in his personal interest. And that's a betrayal of the oath of office he took when he became the president. What do you do in Philadelphia? I'm a high school student. Really? How old are you? I'm 17. I'll be voting, though, in the primary. Oh, because you'll be 18 by Election Day? Is that how it works? That's right. Okay. And in the primary, who do you plan on voting for today? I'm not sure yet. I haven't made up my mind. All right. And is this something that you're watching, following in your civics class in high school? No. It's just something that I'm personally interested in. I plan to major in political science when I go to college, and I care about what's going on, so I'm watching. Thanks for watching. We appreciate it. George, Clifton. Thank you. Have a good one. You too. George in Clifton Park, New York. George, what's your conclusion after this week in the Senate?
I've been watching it all week long, and I'm going to call on the undecided line because they've been making a good point. It needs to be the House's responsibility to come up with the evidence, to come up with the witnesses during the House impeachment process. You can't leave it on the Senate to come up with the witnesses and the documents that they're asking for. They should have went through the process and let the courts decide if those witnesses should have been subpoenaed and called to the floor. And other than that, I don't know if Trump did it, don't know if he didn't do it. The evidence right now isn't there to support it, but they should have done their process in the House, and then we wouldn't have been all this. Would have took longer, but it also would have let the public know exactly what happened. And that's pretty much all I got to say. All right, thanks for calling in. From the Washington Post, Mike DeBonis tweets out, this is new per Indiana Republican Senator Braun. Final vote expected Wednesday. Senate will come back Monday, Tuesday for speeches. Tonight, votes on resolutions setting all this out, plus 2 to 3 amendments. Estimated time that the gavel will conclude is 8:30 to 9 p.m. So a little bit earlier tonight, if that's accurate, than it has been the last couple of nights. Mark's in Marion, Indiana, undecided line. Hi, Mark.
Hi, how you doing, sir?
Why are you undecided?
I'm undecided because, for one, I voted for Trump. I think he's doing a terrific job. And I know the Democrats has been after him ever since he's been in office. But I don't think all the proof. I think he's just not presidential. A lot of it is mannerism, and just the way that it's going down right now in the history that as far as trials in our judicial system works, no witnesses. I'm just undecided about that. But other than that, I think he's doing a great job. I know the Democrats have been after him for a while since he started the office. I'm just undecided right now.
Thank you, sir. Mac, Cincinnati. What's your conclusion after this week, Mac?
Oh, he's not guilty. I met this man and his dad, Fred, at the Swifton Shopping Center down here in Cincinnati 52 years ago.
So why does that make him not guilty?
Well, he's not guilty. He's always been a sincere, honest individual. If he says he's going to do something, he carries through with it and goes all the way.
Okay.
And that man And what I can't understand, all these people on the line who pleading for guilty, how can you do this when they don't even know this guy? Half of them don't even know what he looks like. I don't know how they can make all these accusations and how do you do that? I don't know how you do that.
Ron, Festus, Missouri. Good evening to you, Ron.
Yeah, he's not guilty.
Why do you say that?
He's not guilty because he didn't do anything impeachable. You read the transcript, you listen to the transcript, you look at what he said and what he asked. The president has an obligation to inspect places where our money is going. Why we're giving people all the money we give them, I don't know. We have congressmen and senators who have blatantly said they've been trying to impeach this man before he even was inaugurated. They say it all the time. Nancy Pelosi herself, we've been working on impeachment for 2.5 years. He didn't do anything wrong. He's still not doing anything wrong. What kills me as a United States citizen and taxpayer is the fact that these people get to keep their jobs. Adam Schiff has lied to Congress, to the Senate, to everybody several times. He gets to keep his job. We get fired or jailed. This is a sham. It's been created. Everybody, I've listened to your callers. They want this has to be fair and just. Read how this works. The House didn't do their job. They pushed it through. Ask Nancy why she held the articles as long as she did. So certain people can't campaign. So their buddy Biden can. There's so much wrong. Why is Pelosi's son, Biden's son, several others on these boards? How in the world does somebody like Chelsea Clinton make $9 million a year for nothing? Because they're using their parents. Their parents funding money through them and become multimillionaires. Donald Trump was a billionaire before he got the job. He's given away more money than anybody.
All right, that's Ron in Festus, Missouri. Elizabeth Warren has tweeted out, Senate Republicans just failed the American people and broke their oath to the U.S. Constitution. And she would be one of the people affected if the Senate did come back in on Monday, which is also the day of the Iowa caucuses. State of the Union address is scheduled for Tuesday night. And if what we're reading here, the Senate will be back in on Monday and a final vote on Wednesday, that could affect next week's schedule as well. Now, Steny Hoyer is the majority leader in the House of Representatives, and he has released a statement. A trial cannot be fair if witnesses are prohibited from being heard. Senators cannot be faithful to their oaths of impartiality if they conspire with the president to prevent the testimony of witnesses with damning information against his case. Since the House voted to impeach the president, the public has learned that former Ambassador John Bolton was in the room and heard the president admit firsthand that the hold on military aid to Ukraine was directly tied to an announcement of a bogus investigation against his political opponent. Republican senators have now rejected a fair trial with witness testimony and with key documents, leaving the American people with no doubt that the impeachment trial held in the Republican-led Senate was a sham. That will be a legacy of every senator who voted against hearing witnesses. Again, that's Majority Leader Democrat Steny Hoyer. Now, C-SPAN has done a quick analysis of questions to the House impeachment managers and to the Trump defense team, and the number of questions that individuals answered. Number one on the list is Pat Philbin of the president's team. Number two is Adam Schiff, Jay Sekulow, Jason Crow. The one who answered the fewest questions, Eric Hirschman, Pam Bondi. So the total questions directed to the White House counsel over the last 2 days, 76 questions. To the House impeachment managers, 73 questions, and 31 questions went to both. Those are all the senatorial questions. So you can find that at cspan.org/impeachment. Everything that we've covered about impeachment since September, when Nancy Pelosi announced the impeachment inquiry, is on that page. All the press conferences, all the hearings, and all the questions that were asked over the last 2 days. Philip, San Antonio, good evening. What's your conclusion after this week?
Well, first of all, I want to make a quick comment about a few calls ago with that 17-year-old board that was calling. I think he has more common sense than all the callers y'all have had so far. I mean, he really knows what he's talking about. But second of all, I voted for. I mean, I didn't vote for Trump, but I wanted him to succeed. I really did. But from what he's been doing the last couple of years, it's horrible for the country. I mean, I was telling all my friends, give him a chance, give him a chance. But and then people start bringing the past. What about, the past is the past. This is present right now. This is what's happening right now. And people always get hung up on the past. And that's how they make some of their decisions. And when you do that, you're never going to get past anything. And so I think that this guy, this president, is clearly guilty. I mean, but people are not really paying attention to the facts. And then they start bringing up Burisma. And they start bringing up Biden. And that's all in the past. People have had many chances, even in 2016, when the Republicans controlled everything, to investigate all that. And in some cases, they have already, and there's nothing there. So, it's crazy that people still go to the past when we're talking about.
All right, Philip in San Antonio, thanks for calling in. The Senate remains in recess. They had the vote on the witnesses, which failed, and now they're looking ahead, trying to map out a strategy for tonight and potentially next week as well when it comes to amendments and a final vote on the 2 articles of impeachment. As soon as the Senate comes back into session, we will join them. Earlier, Adam Schiff reacted to the most recent New York Times John Bolton revelation.
Before I begin, Mr. Chief Justice, the House managers will be reserving the balance of our time to respond to the argument of counsel for the President. Mr. Chief Justice, Senators, fellow House managers, and counsel for the President, I know I speak for my fellow managers as well as counsel for the President in thanking you for your careful attention to the arguments that we have made over the course of many long days. Today we were greeted to yet another development in the case when the New York Times reported with a headline that says, "Trump told Bolton to help his Ukraine pressure campaign," book says. The President asked his national security advisor last spring in front of other senior advisors to pave the way for a meeting between Rudolph Giuliani and Ukraine's new leader. According to the New York Times, more than 2 months before he asked Ukraine's president to investigate his political opponents, President Trump directed John R. Bolton, then his national security advisor, to help with his pressure campaign to extract damaging information on Democrats from Ukrainian officials, according to an unpublished manuscript by Mr. Bolton. Mr. Trump gave the instruction, Mr. Bolton wrote, during an Oval Office conversation in early May that included the acting White House Chief of Staff, Mick Mulvaney, the President's personal lawyer, Rudy Giuliani, and the White House counsel, Pat Cipollone, who is now leading the President's impeachment defense. Now, you will see in a few moments, and you will recall Mr. Cipollone suggesting that the House managers were concealing facts from this body. He said all the facts should come out. Well, there's a new fact which indicates that Mr. Cipollone was among those who were in the loop. Yet another reason why we ought to hear from witnesses. Just as we predicted, and it didn't require any great act of clairvoyance, the facts will come out. They will continue to come out. And the question before you today is whether they will come out in time for you to make a complete and informed judgment as to the guilt or innocence of the President. Now, the Times article goes on to say that Mr. Trump told Mr. Bolton to call Vladimir Zelensky, who had recently won election as president of Ukraine, to ensure Mr. Zelensky would meet with Mr. Giuliani, who was planning a trip to Ukraine to discuss the investigations that the President sought in Mr. Bolton's account. Mr. Bolton never made the call, he wrote. Never made the call. Mr. Bolton understood that this was wrong, He understood that this was not policy. He understood that this was a domestic political errand and refused to make the call. The account in Mr. Bolton's manuscript portrays the most senior White House advisors as early witnesses in the effort that they have sought to distance the president from, including the White House counsel. Over several pages, according to the Times, Mr. Bolton laid out Mr. Trump's fixation on Ukraine and the president's belief, based on a mix of scattershot events, assertions, and outright conspiracy theories, that Ukraine tried to undermine his chances of winning the presidency in 2016. As he began to realize the extent and aims of the pressure campaign, Mr. Bolton began to object. He wrote in the book, affirming the testimony of a former National Security Council aide, Fiona Hill, who had said that Mr. Bolton warned that Mr. Giuliani was a hand grenade who's going to blow everybody up. Now, as you might imagine, the president denies this. The president said today, I never instructed John Bolton to set up a meeting for Rudy Giuliani, one of the greatest corruption fighters in America. So here you have the president saying John Bolton is not telling the truth. Let's find out. Let's put John Bolton under oath. Let's find out who's telling the truth. The trial is supposed to be a quest for the truth. Let's not fear what we will learn. As Mr. Cipollone said, let's make sure that all the facts come out.
And that was part of Adam Schiff's closing argument today in the Senate trial. Senator Pat Roberts, Republican, Kansas, tweet, after hearing the entire case presented, I believe we've heard all we need in this impeachment trial. The job of the Senate is not to make up for the lack of investigation conducted by the House. With what we have seen, it is clear witness testimony is unnecessary. Both Susan Collins and Mitt Romney voted to hear from witnesses. Gene, Parker, Arizona. What's your conclusion after this week, Gene?
Well, I've got questions. This is bugging the heck out of me. Now, he's being impeached over the Ukraine, what they're trying to say, quid pro quo, correct?
Okay, go on.
Okay. I'm just trying to get this right. Biden and his boy did wrong in Ukraine with the old corrupt government. Trump and Rudy Giuliani understood that that was going on. They withheld funds from Ukraine to get an investigation going. Basically, the DNC got caught with their hands in the cookie jar again, and they're upset because of the way Trump and allegedly Trump went after them. Is that correct or even close?
Well, why don't you go ahead and finish it with your conclusion, all right?
Okay. Well, the conclusions. This is stupid. They got another bad guy, as far as I'm concerned. Rudy Giuliani's still fighting corruption.
That was Gene in Parker, Arizona. This is Cherry in Pensacola, Florida. Cherry, what do you think?
It's Sherry.
Oh, I'm so sorry. But it's spelled Cherry, isn't it?
An SH.
It is an SH. Okay, all right. That's not what popped up, but that's all right. Go ahead,
That's
Sherry.
Okay. I think he's not guilty. Look what he's done for the country. He doesn't get paid a dime. And what he does get in salary, he donates to the military and other organizations to help. A lot of the Democrats that are upset...
Hey, Sherry, if you can hang on, let's see if we can hear Roy Blunt.
This impeachment process, what I believe happens is that the leader lays that resolution down. The Democrats have 4 or 5 non-debated amendments. They're debatable, but we believe they will not be debated, and we vote on those. We then wouldn't be here tomorrow or Sunday, and there'd be 4 hours Monday, I think from 11 to 3 for final arguments. The chief would be here for that, and then he would not be back until sometime on Wednesday. And between the time he leaves and the time he comes back, the time on the floor would be available in a more normal session for members to talk about their vote and the process and whatever else they want to talk about. And then I think the time to have the final vote would be 4 o'clock Wednesday.
Is this plan certain?
What?
Is this plan certain? Is this how it's going to happen?
Well,
It's what you all
it's as certain as anything is until it's done, but it appears to be certain. And I think from our point of view, I'd have much rather seen it done right now and finished in whatever time it took to stick with it if we were done. But I do think the Democrats could make the case that if they wanted to, they could extend all of this with various motions and other things through Wednesday at about 4 o'clock. And so, accepting that argument, we decided the best thing for everybody involved would be to go ahead and come to that certain date, but try to eliminate any the needless pain and suffering, as if this hasn't been painful enough already.
You don't think if you powered through tonight, you could have gotten this done by the State of the Union?
You know, the belief of the leader and his staff was that Democrats, if they wanted to, and they appeared to be willing to, could take it into Wednesday afternoon. So I guess that would mean no, they were not willing to get this done before the State of the Union on Tuesday.
Are you aware of any discussions of changing the date of the State of the Union?
Not aware of any. Not aware of any. That could happen, but I'm not aware of it at all.
Has Senator Schumer agreed to this plan?
I hope so. Certainly it was presented to us as if it was something he and the leader both were agreed on.
Can I ask some details of what you just laid out? So so the Chief Justice would be there on Monday for 4 hours of final arguments?
Right.
And those are arguments between the House managers and the President's lawyers, like official arguments. And then they would leave after 4 hours.
But we would hope they'd leave even sooner than that, but they would have up to 4 hours.
They would have up to 4 hours, and then the trial would no longer go out of session. And then would you all start arguments again would you guys start speaking on the floor on Monday, or would you wait until Tuesday? So then you're just in normal Senate session.
Yes.
You can talk through, and then through the day Tuesday, up until the State of Union, basically. And then you could talk, then the court goes into session on Wednesday, is that right? I mean, it'll have to for the final.
Whether we'd have to go in at 1 or not, I don't know. If this is an agreement, we could probably come in for a final vote closer to 4.
Okay.
Because that would be a non-debatable.
Because the arguments would have already been done Monday.
That would be a non-debatable thing, right?
But can't the articles be amended, or is this part of the agreement they wouldn't be amended?
They can't. No, they wouldn't.
Okay.
Okay. Thank you all.
But the Chief Justice only has to be here for the closing arguments, right? And acquittal.
So a pretty clear roadmap from Senator Roy Blunt, who's part of the Republican leadership. He was a longtime House whip as well, but a pretty clear roadmap of potentially where the Senate is going. We'll certainly have to wait until they come back into session tonight and vote on this. But looking like, as you all heard as well, 4 p.m. on Wednesday for the final vote on this. Sherry, you've been very patient. Please go ahead and finish your thought.
Thank you, sir. All I'm saying is the reason a lot of the Democrats are upset is because he's getting them off of the lazy ones off of welfare and food stamps, and he's made jobs for them to get out and work and quit living off the system. And he's cleaning the house because all they're doing is lining their pockets with our hard-working money that the rest of us get out and work hard every day for.
Thank you, ma'am, for calling in. Now, Senate Cloakroom has put out a tweet as well. At approximately 7 p.m. tonight, the Senate is expected to proceed to up to 5 roll call votes. Votes will be in relation to Democrat amendments to the McConnell resolution, followed by a vote on passage of the resolution organizing the timeline for votes on the articles of impeachment. So what we heard from Senator Blunt and what we're hearing from the cloakroom now, the Democrats will present some amendments. There will be some votes on those amendments, and we'll see if the McConnell resolution for the timeline gets amended, and then we'll know for sure what's going to happen next week. But it does not sound at this point as if they will be in for the weekend. Now, sometimes we get a little bit of tunnel vision when we're working on an issue like this, and and our world becomes impeachment. But this is an AP story that just came out. So long, farewell, auf Wiedersehen, adieu. With little fanfare, Britain left the European Union on Friday after 47 years of membership, taking a leap into the unknown in a historic blow to the bloc. The UK's departure became official at 11 p.m. midnight in Brussels, where the EU is headquartered. Thousands of enthusiastic Brexit supporters gathered outside Britain's parliament to welcome the moment they'd longed for since Britain's 52-48 vote in June 2016. Lena, Anderson, South Carolina. What'd you hear this week, Lena? And what's your conclusion at this point?
Well, I've listened to all of it, and I think so much has happened with the Democrats, and they're the ones that are guilty. Biden's son, Pelosi's son. I mean, you know, this money laundering is such a farce. This whole impeachment has been such a farce. I mean, I'm originally from Michigan. I've retired down here. I heard someone comment that all the ones that are voting for Trump are the baby boomers. That's not true. All my kids that are in their 40s are voting for Trump.
So back to the trial, back to the Senate trial that we've witnessed all week. What did you think?
Well, I think Schiff, he seems so corrupt. Pelosi, I mean, that's another issue totally. Really, she shouldn't even be in there. Their biased opinions are ridiculous. I think President Trump has done so much for this country, and you know, bringing the jobs back, getting so much employment out there for people. He's done so much.
All right, that's Lena in Anderson, South Carolina. Now, we heard from Roy Blunt about the schedule and whether or not the State of the Union speech scheduled for next Tuesday night is still going to happen. He did not indicate that it was going to be canceled, but the Associated Press is reporting that President Trump will use next week's State of the Union to promote what he calls the Great American Comeback. The speech comes at a moment when Trump is hoping to put his Senate impeachment trial behind him. Well, it doesn't sound like that will be completely the case, but the Great American Comeback is going to be the theme, according to the Associated Press, of the President's State of the Union. Sandra is up in Anchorage, Alaska. Hi, Sandra. Whoop, we lost Sandra. Kevin, Oceanside, California. Kevin, what's your reaction to this week?
Oh, thanks for taking my call, and thanks for trying to be impartial. I noticed that you mentioned after there was a Republican making a statement about how this was a joke or whatever, that indeed a couple of Republican senators had voted for witnesses. So kudos to you. I think this week we learned that Donald Trump has done a really good job for the Russians and other people who have influenced him and given him money. We've learned this week that Lev Parnas is hanging outside in the hall, hoping that he can be called as a witness. And so I don't think Trump can get a fair trial.
Repeat that last sentence again, Kevin, and explain it. I wasn't completely clear what you said.
Well, you've got Bolton who's written a book. Lev Parnas is outside the halls of Congress, hoping to talk to somebody or to testify. But indeed, Trump cannot get a fair trial because he's going to hold up the Republican Party for everyone to see what a great job he did. Last week, another Russian got money back. Its sanctions were removed at the order of Trump and the Trump team. Yay, look.
That's Kevin in Oceanside, California. Jesse, Albuquerque, good evening to you.
Well, yes. I started listening to this, and the thing that really struck me this evening is that the Republican Party, Mitch McConnell, have put the final nail in the coffin of our standing in the world. the Republican Party, the ones that stood with it, and this sham that turned into a sham because no witnesses will be allowed. And if witnesses allowed, it should be as in any other type of trial from both sides, defense and prosecutors. But the main thing is that's happened right now is we've been turned in to a laughingstock to the entire world. The repercussions of this are yet to be seen, but you can already see the writing on the walls and the weeds growing through the cracks.
All right, Jesse in Albuquerque. Senator Mike Lee, Republican of Utah. Tweet. Senator Mitt Romney is a good friend and an excellent senator. We have disagreed about a lot in this trial, but he has my respect for the thoughtfulness, integrity, and guts he has shown throughout this process. Utah and the Senate are lucky to have him. Mitt Romney, of course, was one of 2 Republicans to vote for more witnesses and more testimony, along with Susan Collins. Julius up in Buffalo, you're on the air. What do you think?
First and foremost, I'd like to thank God for you guys for C-SPAN. I'm an avid watcher of all 3 of the channels. You just get a much more unabridged view of everything. I'm calling on a not guilty line. Being from New York here, my 2 senators are a great embarrassment to me. I don't feel that the House did their job. They could have kept it over there much longer. Coming up to the end of it with the bumping fists and the pen ceremony was quite embarrassing also. Pelosi with her statements of the president has been impeached, that impeachment's forever, with the 5-year-old level comments. There'll be an acquittal, and that acquittal will also be forever. So
all right.
I'm just glad.
Thank you, Julius. And according to the Senate cloakroom, the Senate will be coming back at 7 p.m. to take some votes on amendments to the McConnell plan for the rest of this process. Barbara's in Hudsonville, Illinois. Hi, Barbara.
Hi, thank you for accepting my call. I just want to say that I don't consider myself a Republican or a Democrat. I look to people as to what I see as their characteristics and so forth. I believe that Trump is guilty. I think he's an embarrassment. And I'm so disappointed in our United States Senate for how they've ignored that he's covered up things, used money that is so obvious that he took the young president that needed a visit to the White House, all the hidden and buried information. It was just totally not fair. I believe that in the mouths of 2 or 3 witnesses, everything should be established. And that didn't happen. I can only imagine what is to come.
Salvador, Corona, New York. Good evening. Salvador, Corona, New York.
I'm
Good
sorry,
evening.
yes.
Yep.
Good evening. Thank you for taking my call. I'm just calling because I believe, I don't believe, I am sure that Donald J. Trump is guilty, but he's corrupt. He's a liar, and by God on his side, the leadership of the Republican Senate that is also corrupt. That's why he could get away with all his corrupt things.
So can you give a specific example of why you think he is guilty of abuse of power or obstruction of Congress?
Yes, because you cannot bribe a foreign country. You cannot ask them something in favor for his own personal benefits. And he obstructed Congress with all. Yes.
All right, Salvador, we got it. Senator Tom Udall, New Mexico, Democrat, tweet, What's a trial without witnesses and documents? A sham. It's a sad day when senators are helping orchestrate a cover-up on behalf of a president. And that's what the majority of the Senate GOP did today when they voted against bringing witnesses and documents into the impeachment trial. Denise in Lutz, Florida, good evening.
Hi there. I'm an independent and therefore, I'm a constitutionalist and therefore I'm independent. I have no party loyalty at all. And I would submit to you that guilt or innocence isn't an appropriate question. And the magnitude of what's happening in the Senate right now is greater than you can possibly imagine. If I think that the senators should be required to watch the House process completely every single hour like I did. And I have a full-time job, so there's no excuse for them to not be able to know what happened in the House. And the only legitimate decision in this whole thing would be mistrial. I would send the House back to the House and tell them that they need to follow the processes and do it legally, or there's nothing for them to be making any votes on. That's how I feel about it.
Denise, why do you say it's a mistrial?
Because the House did not follow the legal processes. They didn't do it the way they were supposed to do. And beyond that, if you're looking into theoretically and you really read the Federalist Papers and how the framers came up with the whole impeachment thing, it was completely partisan. I mean, it was bipartisanly opposed to, and they rammed it through anyway. And so aside from whether you think he's guilty or not, that if somebody kind of came into a court of law, which it's not really even like a regular trial, but to come to the Senate with when they got to the Senate without following the proper procedures that are in the Constitution, it should be rejected. There should be no vote about guilt or innocence because it wasn't legitimate to begin with.
Tammy's in Wyandotte, Michigan. Tammy, what's your conclusion after this week?
I'm going to say that he's not guilty because the House didn't do their job the way that they were supposed to do it. I thought in our country we were supposed to be innocent until proven guilty, and they basically said he was guilty and he had to prove himself to be innocent. That's not how this country works.
Let's hear from Louisiana Senator Kennedy.
Limited debate. We'll probably finish tonight about, 8:30, maybe sooner. Then we will reconvene Monday, probably at 11 o'clock. Go till 3 or 4. People will have a chance on Tuesday to make 4 statements, and then there'll be a final vote on Wednesday. That's the tentative plan right now.
Do you know the timing of that on Wednesday?
Do not know. Okay.
Thank you.
You're welcome.
And a little bit of a reaffirmation of what Senator Blunt said, coming in on Monday, finishing up tonight, setting the rules, the roadmap ahead, and then each senator will have the chance to talk on Tuesday, potentially looking at the clock, a 4 p.m. vote on Wednesday on the 2 articles of impeachment. Dave is in Pennsylvania. Dave, what's the name of your town?
Tunkhannock.
Thank you. Go ahead. What's your conclusion after this week?
Well, I have more like of a question. I'm seeing where people say this is like a grand jury in the House. Isn't it more like it's a trial in the House where each side is supposed to present their case, and then you bring in your witnesses, and each side gets to cross-examine them, which didn't happen, and then you send it to the Senate, which would be like arguing in front of the Supreme Court. When you get to the Supreme Court, there are no other – you stand on what you've brought. So if that's my understanding of the Constitution, then it's like the other lady said, this is a no trial. They didn't do their job. They didn't send the information correctly. So I guess you got to vote not guilty.
Dave, are you a supporter of the president?
Yeah, I think he's doing a good job. I mean, I don't always vote for the Republicans in the presidential elections, but I think Trump's done an excellent job so far.
All right, thanks for your analysis. Madison in Bruce, Mississippi texts in that President Trump is not guilty. He has done so much good for this country that he obviously loves, seeing as how he takes no salary. The Democrats are just furious because they lost the last election and are afraid of losing this one. This whole impeachment is unfair, senseless, and ridiculous. I pray it ends in acquittal. Henry in Middletown, Delaware. Henry, where have you landed so far this week?
Oh, I'm definitely not guilty. I'm a Democrat, been a Democrat, shame to say so, actually. But the couple points, your past three callers were really right on point with everything they said. But the point that everybody that thinks he's guilty needs to understand, there's a bigger picture here, and that's our Constitution. And the fact that it didn't move forward in a bipartisan manner. The Constitution expressly states that it needs to be bipartisan, even if it's one vote, and it wasn't. So just on those grounds alone, it's a moot point. It's definitely, this is something that I think our legislators need to take up and make this thing so it never becomes a partisan issue again. And then it'll have some validity. And everybody is absolutely correct that the House did not do their job. And the previous caller was right on point with what he said, is the actual depositions and trials and testimony should have taken place in the House. And when the jurors move into the juror box in a regular trial, that's where they decide and they bring their verdict back. That's the way our system works.
All right, thank you. Henry in Middletown, Delaware. You probably just saw Mitch McConnell and Chuck Schumer live walking back onto the Senate floor, and there's Amy Klobuchar, who's still outside the Senate. It is 7 p.m. in the East, and that means that the Senate should be coming back into session in a very short while. Senator Debbie Stabenow has tweeted out, she's a Democrat from Michigan, a fair trial requires all relevant witnesses and evidence. If President Trump's staff has evidence of his innocence, he would have insisted that we hear from them, as we should. Senate Republicans have once again voted to hide the truth about the president's actions. Matthew in Hamden, Connecticut, let's see if we can get you in here before the Senate comes back into session.
Yeah, thank you. And I'll be really brief. I think the president is guilty, but let's face it, my opinion on this matter, my opinion doesn't matter. Senator Rubio said today that the president is guilty when he said that his actions are impeachable, but that doesn't necessarily mean that he should be removed from office. Senator Alexander said last night that the president's actions were inappropriate, but he's not going to be removed from office. So the real question here is whether bribing a foreign power to interfere in our elections, does that rise to the level of impeachment? That is the question that the senators have to answer. That is the question that they answered today. And to just respond to the previous callers, no, the House, when it comes to impeachment, the House is more like the grand jury. And in any grand jury, the defense is not required to actually put forth the defense is not allowed or do not have to actually put forth the defense in the grand jury. Now, the Senate is the actual trial where the witnesses come forth, and that is where the defense can actually put on a defense in the trial. So the Senate is not the Supreme Court when it comes to impeachment. So,
all right, Matthew, thank you for your analysis. Here is the resolution that Mitch McConnell will be introducing as soon as the Senate comes back into session, and this will be the one that they will begin debate on. And this is a resolution to provide for related procedures concerning the articles of impeachment against Donald John Trump, President of the United States. Resolved that the record in this case shall be closed and no motion with respect to reopening the record shall be in order for the duration of these proceedings. The Senate shall proceed to final arguments as provided in the impeachment rules waiving the two-person rule of the Rules of Procedure and Practice. Such arguments shall begin at 11 a.m. on Monday and not exceed 4 hours and be equally divided between the House and the President. At the conclusion of the final arguments by the House and the President, the Court of Impeachment shall stand adjourned until 4 p.m. on Wednesday, February 5th, 2020, at which time the Senate, without intervening action or debate, shall vote on the articles of impeachment. So what we heard from Senators Blunt and I believe it was Braun seem accurate. That's the resolution that's going to be presented as soon as the Senate comes back in. Brenda's in Hilliard, Ohio. Brenda, what's your conclusion after this week?
Well, I feel that Trump is guilty. I feel that he is guilty of showing how corrupt the Democrat Party is.
And do you have a specific reason that you feel that way?
The whole thing in the Congress was a sham. The ship comes to the Senate and says, oh, well, this is all a sham. Well, no, we've been calling that the whole time.
Pete in Warsaw, Indiana. Hi, Pete. What's your conclusion after this week?
Not guilty.
Why?
And I agree with the previous caller that he's guilty in the fact that he's making the Democratic Party look like total fools. I watched this through the House with Nadler and Schiff. They never yielded to the Republicans as far as allowing questions, etc. It's a sham, and it's time to move on in this country.
The House managers put out a statement following the vote on witnesses and documents. Senators just voted to make this the first impeachment trial in the history of the United States without witnesses and documents, which were blocked by President Trump during the inquiry. The House managers proved their case with a mountain of evidence, as some Republican senators have acknowledged, and there is more direct evidence of the president's corrupt scheme only a subpoena away. But at the president's urging, the Senate chose not to hear from people like John Bolton, knowing they would only add to the overwhelming evidence of the president's guilt. The truth cannot be denied, not for long, and the facts will continue to come out as they did today. Senators who opposed hearing from these witnesses when their testimony would have better informed a judgment on the guilt or innocence of the president will be hard-pressed to explain why. Senators chose instead to set a dangerous precedent that will have long-lasting repercussions for the U.S. Congress, the balance of powers, and our democracy as a whole. Again, that's a statement by the House managers that just came out. Stephanie in Springdale, Arkansas. Good evening to you, Stephanie. What are your thoughts?
Well, I believe he's guilty, and here's why. There is a pattern with this man. I'm from New York. I've seen him for decades on how he acts. They showed enough evidence to show that he's guilty, but he's also an unindicted co-conspirator for paying off an adult film star to influence the last election he was running in. In the Mueller report, they stated he didn't seek out interference, but he welcomed interference from the Russians. So that's a pattern. And he knows how to use the courts to his advantage. He's been doing that for decades, and he figured he could do that here by stonewalling. But because the election of 2020 was on the line, they rushed it through, and they may have made a mistake doing that. They didn't follow process. I hear everybody, these other callers saying they didn't do like they were supposed to. When the Justice Department was made aware of what Trump did in Ukraine, they declined to take the case. So there was no special counsel. So the House had to do the special counsel's job of gathering evidence and, how that usually goes in any other impeachment.
Do you think the House rushed the case, Stephanie?
I think they did out of desperation for our upcoming election.
And what about holding then for 30 days the articles of impeachment before sending them to the Senate?
I think that was just a power play. Nancy Pelosi has been doing, this job for a long time. She knows how to get what she wants. The senators and representatives have done this for decades.
You said you lived in New York for a long time. Are you retired to Springdale, Arkansas?
I didn't retire here, but I am retired. So I've watched pretty much gavel to gavel. I've watched the House's hearings, and I've watched this. Now, the argument that President Trump's legal team is making is, yeah, okay, so, he did it basically. So what? Many of the Republican senators have come out and said, yeah, he did it, but, who cares, basically.
Thank you very much for calling in. I want to remind you, cspan.org/impeachment. Everything you want to see about this entire process from start to finish, including all 183, I believe, questions that were asked by the senators to the House managers and the Trump defense team. When you get there, you will also see this chart that was compiled by C-SPAN that Patrick Philbin had the most questions addressed to him at 66. Adam Schiff had 53 questions that he answered. I should say they weren't directed to them. So those two answered the most questions, and Pam Bondi only answered 2 questions, as did Eric Hirschman. And that's all contained at cspan.org/impeachment. John, Jacksonville, Florida, you called in on the not guilty line. Why?
Yes, I have one word that will destroy their case, and it's in the transcript. Okay, the call. The president says, do us a favor. That right there, it says it all. And I agree with everybody else that says they've been after the president since he took the oath, before he took the oath, actually. And, this has all been a sham, just like everybody else is saying that's got any brains. I mean, if you can't see that, there's something wrong with you. You're not.
Paul is in Scottsdale, Arizona, undecided line. Hi, Paul.
Hi, thanks for taking my call. I think the Congress did a very good job. I think the Senate did a good job, but the Senate, where they messed up, to me, is they didn't hear the witnesses. They didn't get all the paperwork that the Democrats wanted to send them. I'm 82 years old and 12-year military veteran, and I honestly don't think this country's had a president for the last 20 years. They've had I guess you could call him not a king maybe, but imperial, and his ruling party they're members of the royal family. So I don't know. I think because they didn't call more witnesses to the Senate, I think they set a bad precedent, and in the years to come.
So you would have voted for witnesses in the Senate. What about the House not subpoenaing these witnesses?
What's that again?
You would have voted for more witnesses in the Senate, correct?
Absolutely.
Great. Thank you,
and
sir.
More paper.
Oh, sorry about that. I thought you were finished. Harmon and Valley, Alabama. Not guilty, you say. Why?
Not guilty. Do you really believe the House was going to let us call the whistleblower and the Bidens? I can't understand why the Democrats are protecting the Bidens so. And the House says they want a fair trial. They did not give us Republicans a fair trial in the House. So it's time to put the Pelosi, Schiff, Schumer, and Nadler thing to bed. He's not guilty. He's the greatest president we've ever had. Look at everything he's done for this country. He doesn't take his money. He gives it to something. And he's the greatest president we've ever had. And it's time that everybody got on board. If the Democrats would get in there with Republicans and work together, we could be doing better than what we're doing now, but we're doing great. And
you mentioned Speaker Pelosi. She has put out a statement following the vote on witnesses and documents. The Senate Republicans' vote against calling witnesses and compelling documents in the impeachment proceedings makes them accomplices to the president's cover-up. The president was impeached for abuse of power and obstruction of Congress. He is impeached forever. There can be no acquittal without a trial, and there is no trial without witnesses, documents, and evidence. It is a sad day for America to see Senator McConnell. That's Nancy Pelosi's statement. The Senate is back.
The Senate will come to order. The Majority Leader is recognized.
Mr. Chief Justice, I send a resolution to the desk and ask the clerk to report.
The clerk will report.
Senate Resolution 488 to provide for related procedures concerning the articles of impeachment against Donald John Trump, President of the United States. Resolved that the record in this case shall be closed and no motion with respect to reopening the record shall be in order for the duration of these proceedings. The Senate shall proceed to final arguments as provided in the impeachment rules, waiving the two-person rule contained in Rule 22 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials. Such arguments shall begin at 11 a.m. on Monday, February 3rd, 2020, and not exceed 4 hours, and be equally divided between the House and the President to be used as under the rules of impeachment. At the conclusion of the final arguments by the House and the President, the Court of Impeachment shall stand adjourned until 4 p.m. on Wednesday, February 5th, 2020, at which time the Senate, without intervening action or debate, shall vote on the articles of impeachment.
Justice.
Mr. Majority Leader.
I ask unanimous consent that the Democratic leader or his designee be allowed to offer up to 4 amendments to the resolution. Further, that I be recognized to make a motion to table the amendment after it's been reported with no intervening action or debate.
Is there objection? Without objection, so ordered. The Democratic leader is recognized.
Mr. Chief Justice, I have a parliamentary inquiry.
The Democratic leader will state the inquiry.
Is the Chief Justice aware that in the impeachment trial of President Johnson, Chief Justice Chase, as presiding officer, cast tie-breaking votes on both March 31st and April 2nd, 1868?
I am, Mr. Leader. The one concerned a motion to adjourn. The other concerned a motion to close deliberations. I do not regard those isolated episodes 150 years ago as sufficient to support a general authority to break ties. If the members of this body, elected by the people and accountable to them, divide equally on a motion, the normal rule is that the motion fails. I think it would be inappropriate for me, an unelected official from a different branch of government, to assert the power to change that result so that the motion would succeed.
Now, Mr. Chief Justice, I send an amendment to the desk to subpoena Mulvaney, Bolton, Duffy, Blair, and the White House, OMB, DOD, and State Department documents, and I ask that it be read.
The clerk will report.
Senator from New York, Mr. Schumer, proposes an amendment number 1295. At the appropriate place in the matter following the resolving clause, insert the following. Section, notwithstanding any other provision of this.
The amendment be considered as read.
Objection? So ordered. The Majority Leader is recognized.
I move to table the amendment and ask for the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Mr. Alexander, aye. Ms. Baldwin. Ms. Baldwin, no. Mr. Barrasso. Mr. Barrasso, aye. Mr. Bennett. Mr. Bennett, no. Mrs. Blackburn. Aye. Mrs. Blackburn, aye. Mr. Blumenthal. No. Mr. Blumenthal, no. Mr. Blunt. Aye.
Mr. Blunt, aye. Mr. Booker? Mr. Booker, no. Mr. Bozeman? Mr. Bozeman, aye. Mr. Braun? Mr. Braun, aye. Mr. Brown? Mr. Brown, no. Mr. Burr? Mr. Burr, aye. Ms. Cantwell? Ms. Cantwell, no. Mrs. Capito? Mrs. Capito, aye. Mr. Cardin? Mr. Cardin, no. Mr. Carper? Mr. Carper, no. Mr. Casey? Mr. Casey, no. Mr. Cassidy? Mr. Cassidy, aye. Ms. Collins? Ms. Collins, aye. Mr. Coons? Mr. Coons, no. Mr. Cornyn? Mr. Cornyn, aye. Ms. Cortez Masto? Ms. Cortez Masto, no. Mr. Cotton? Mr. Cotton, no. Mr. Cotton, aye. Mr. Kramer? Mr. Kramer, aye. Mr. Crapo? Mr. Crapo, aye. Mr. Cruz? Mr. Cruz, aye. Mr. Daines? Mr. Daines, aye. Ms. Duckworth? Ms. Duckworth, no. Mr. Durbin? Mr. Durbin, no. Mr. Enzi? Mr. Enzi, aye. Ms. Ernst? Ms. Ernst, aye. Mrs. Feinstein? Mrs. Feinstein, no. Mrs. Fisher? Mrs. Fisher, aye. Mr. Gardner? Mr. Gardner, aye. Mrs. Gillibrand? Mrs. Gillibrand, no. Mr. Graham? Mr. Graham, aye. Mr. Grassley? Mr. Grassley, aye. Ms. Harris? Ms. Harris, no. Ms. Hassan? Ms. Hassan, no. Mr. Hawley? Mr. Hawley, aye. Mr. Heinrich? Mr. Heinrich, no. Ms. Hirono? Ms. Hirono, no. Mr. Hoven? Mr. Hoven, aye. Mrs. Hyde-Smith? Mrs. Hyde-Smith, aye. Mr. Inhofe? Mr. Inhofe, aye. Mr. Johnson? Mr. Johnson, aye. Mr. Jones? Mr. Jones, no. Mr. Kane? Mr. Kane, no. Mr. Kennedy? Mr. Kennedy, aye. Mr. King? Mr. King, no. Ms. Klobuchar? Ms. Klobuchar, no. Mr. Langford? Mr. Langford, aye. Mr. Leahy? Mr. Leahy, no. Mr. Lee? Mr. Lee, aye. Mrs. Loeffler? Mrs. Loeffler, aye. Mr. Manchin? Mr. Manchin, no. Mr. Markey? Mr. Markey, no. Mr. McConnell? Mr. McConnell, aye. Ms. McSally? Ms. McSally, aye. Mr. Menendez? Mr. Menendez, no. Mr. Merkley? Mr. Merkley, no. Mr. Moran? Mr. Moran, aye. Ms. Murkowski? Ms. Murkowski, aye. Mr. Murphy? Mr. Murphy, no. Mrs. Murray? Mrs. Murray, no. Mr. Paul? Mr. Paul, aye. Mr. Perdue? Mr. Perdue, aye. Mr. Peters? Mr. Peters, no. Mr. Portman? Mr. Portman, aye. Mr. Reed? Mr. Reed, no. Mr. Risch? Mr. Risch, aye. Mr. Roberts? Mr. Roberts, aye. Mr. Romney? Mr. Romney, aye. Ms. Rosen? Ms. Rosen, no. Mr. Rounds? Mr. Rounds, aye. Mr. Rubio? Mr. Rubio, aye. Mr. Sanders? Mr. Sanders, no. Mr. Sass? Mr. Sass, aye. Mr. Schatz. Mr. Schatz, no. Mr. Schumer. Mr. Schumer, no. Mr. Scott of Florida. Mr. Scott of Florida, aye. Mr. Scott of South Carolina. Mr. Scott of South Carolina, aye. Mrs. Shaheen. Mrs. Shaheen, no. Mr. Shelby. Mr. Shelby, aye. Ms. Sinema. Ms. Sinema, no. Ms. Smith. Ms. Smith, no. Ms. Stabenow. Ms. Stabenow, no. Mr. Sullivan. Mr. Sullivan, aye. Mr. Tester. Mr. Tester, no. Mr. Thune. Mr. Thune, aye. Mr. Tillis. Mr. Tillis, aye. Mr. Toomey. Mr. Toomey, aye. Mr. Udall. Mr. Udall, no. Mr. Van Hollen. Mr. Van Hollen, no. Mr. Warner. Mr. Warner, no. Ms. Warren. Ms. Warren, no. Mr. Whitehouse. Mr. Whitehouse, no. Mr. Wicker. Mr. Wicker, aye. Mr. Wyden. Mr. Wyden, no. Mr. Young. Mr. Young, aye.
Does any member in the chamber wish to change his or her vote? If not, the yeas are 53, the nays are 47. The motion is agreed to. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena John R. Bolton, and I ask that it be read.
The clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment number 1296. At the appropriate place in the resolving clause, insert the following. Section, notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena for the taking of testimony of John Robert Bolton, and the Sergeant-at-Arms is authorized to utilize the services of the Deputy Sergeant-at-Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
The majority leader is recognized.
I move to table the amendment and ask for the yeas and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. No. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. No. Mr. Burr. Aye. Ms. Cantwell. No. Mrs. Capito. Aye. Mr. Cardin. No. Mr. Carper. No. Mr. Casey. No. Mr. Cassidy. Aye. Ms. Collins. No. Mr. Coons. No. Mr. Cornyn. Aye. Ms. Cortez Masto. No. Mr. Cotton. Aye. Mr. Kramer. Aye. Mr. Crapo. Aye. Mr. Cruz. Aye. Mr. Daines. Aye. Ms. Duckworth. No. Mr. Durbin. No. Mr. Enzi. Aye. Ms. Ernst. Aye. Mrs. Feinstein. No. Mrs. Fisher. Aye. Mr. Gardner. Aye. Mrs. Gillibrand. No. Mr. Graham. Aye. Mr. Grassley. Aye. Ms. Harris. No. Ms. Hassan. No. Mr. Hawley. Aye. Mr. Heinrich. No. Ms. Hirono. No. Mr. Hoven. Aye. Mrs. Hyde-Smith. Aye. Mr. Inhofe. Aye. Mr. Johnson. Aye. Mr. Jones. No. Mr. Kane. No. Mr. Kennedy. Aye. Mr. King. No. Ms. Klobuchar. No. Mr. Lankford. Aye. Mr. Leahy. No. Mr. Lee. Aye. Mrs. Loeffler. Aye. Mr. Manchin. No. Mr. Markey. No. Mr. McConnell. Aye. Ms. McSally. Aye. Mr. Menendez. No. Mr. Merkley. No. Mr. Moran. Aye. Ms. Murkowski. Aye. Mr. Murphy. No. Mrs. Murray. No. Mr. Paul. Aye. Mr. Perdue. Aye. Mr. Peters. No. Mr. Portman. Aye. Mr. Reed. No. Mr. Risch. Aye. Mr. Roberts. Aye. Mr. Romney. No. Ms. Rosen. No. Mr. Rounds. Aye. Mr. Rubio. Aye. Mr. Sanders. No. Mr. Sass. Aye. Mr. Schatz. No. Mr. Schumer. No. Mr. Scott of Florida. Aye. Mr. Scott of South Carolina. Aye. Mrs. Shaheen. No. Mr. Shelby. Aye. Ms. Sinema. No. Ms. Smith. No. Ms. Stabenow. No. Mr. Sullivan. Aye. Mr. Tester. No. Mr. Thune. Aye. Mr. Tillis. Aye. Mr. Toomey. Aye. Mr. Udall. No. Mr. Van Hollen. No. Mr. Warner. No. Ms. Warren. No. Mr. Whitehouse. No. Mr. Wicker. Aye. Mr. Wyden. No. Mr. Young. Aye.
Are there any senators in the chamber wishing to vote or change his or her vote? If not, the yeas are 51, the nays are 49. The motion is agreed to. The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to subpoena John R. Bolton, provided further that there be 1 day for a deposition presided over by the Chief Justice and 1 day for live testimony before the Senate, both of which must occur within 5 days of the adoption of the underlying resolution, and I ask that it be read.
The clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment number 1297. At the appropriate place of the matter following the resolving clause.
Be considered as read.
So ordered. The majority leader is recognized.
I move to table the amendment and ask for the ayes and nays.
Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Mr. Alexander, aye. Ms. Baldwin. Ms. Baldwin, no. Mr. Barrasso. Mr. Barrasso, aye. Mr. Bennett. Mr. Bennett, no. Mrs. Blackburn. Mrs. Blackburn, aye. Mr. Blumenthal. Mr. Blumenthal, no. Mr. Blunt. Mr. Blunt, aye. Mr. Booker. Mr. Booker, no. Mr. Bozeman. Mr. Bozeman, aye. Mr. Braun. Mr. Braun, aye. Mr. Brown. Mr. Brown, no. Mr. Burr. Mr. Burr, aye. Ms. Cantwell. Ms. Cantwell, no. Mrs. Capito. Mrs. Capito, aye. Mr. Cardin. Mr. Cardin, no. Mr. Carper. Mr. Carper, no. Mr. Casey. Mr. Casey, no. Mr. Cassidy. Mr. Cassidy, aye. Ms. Collins. Ms. Collins, no. Mr. Coons. Mr. Coons, no. Mr. Cornyn. Mr. Cornyn, aye. Ms. Cortez Masto. Ms. Cortez Masto, no. Mr. Cotton. Mr. Cotton, aye. Mr. Kramer. Mr. Kramer, aye. Mr. Crapo. Mr. Crapo, aye. Mr. Cruz. Mr. Cruz, aye. Mr. Daines. Mr. Daines, aye. Ms. Duckworth. Ms. Duckworth, no. Mr. Durbin. Mr. Durbin, no. Mr. Enzi. Mr. Enzi, aye. Ms. Ernst. Ms. Ernst, aye. Mrs. Feinstein. Mrs. Feinstein, no. Mrs. Fisher. Mrs. Fisher, aye. Mr. Gardner. Mr. Gardner, aye. Mrs. Gillibrand. Mrs. Gillibrand, no. Mr. Graham. Mr. Graham, aye. Mr. Grassley. Mr. Grassley, aye. Ms. Harris. Ms. Harris, no. Ms. Hassan. Ms. Hassan, no. Mr. Hawley. Mr. Hawley, aye. Mr. Heinrich. Mr. Heinrich, no. Ms. Hirono. Ms. Hirono, no. Mr. Hoven. Mr. Hoven, aye. Mrs. Hyde-Smith. Mrs. Hyde-Smith, aye. Mr. Inhofe. Mr. Inhofe, aye. Mr. Johnson. Mr. Johnson, aye. Mr. Jones. Mr. Jones, no. Mr. Kane. Mr. Kane, no. Mr. Kennedy. Mr. Kennedy, aye. Mr. King. Mr. King, no. Ms. Klobuchar. Ms. Klobuchar, no. Mr. Langford. Mr. Langford, aye. Mr. Leahy. Mr. Leahy, no. Mr. Lee. Mr. Lee, aye. Mrs. Loeffler. Mrs. Loeffler, aye. Mr. Manchin. Mr. Manchin, no. Mr. Markey. Mr. Markey, no. Mr. McConnell. Mr. McConnell, aye. Ms. McSally. Ms. McSally, aye. Mr. Menendez. Mr. Menendez, no. Mr. Merkley. Mr. Merkley, no. Mr. Moran. Mr. Moran, aye. Ms. Murkowski. Ms. Murkowski, Aye. Mr. Murphy? Mr. Murphy? No. Mrs. Murray? Mrs. Murray? No. Mr. Paul? Mr. Paul? Aye. Mr. Perdue? Mr. Perdue? Aye. Mr. Peters? Mr. Peters? No. Mr. Portman? Mr. Portman? Aye. Mr. Reed? Mr. Reed? No. Mr. Risch? Mr. Risch? Aye. Mr. Roberts? Mr. Roberts? Aye. Mr. Romney? Mr. Romney? No. Ms. Rosen? Ms. Rosen? No. Mr. Rounds? Mr. Rounds? Aye. Mr. Rubio? Mr. Rubio? Aye. Mr. Sanders? Mr. Sanders? No. Mr. Sass? Mr. Sass? Aye. Mr. Schatz? Mr. Schatz? No. Mr. Schumer? Mr. Schumer? No. Mr. Scott of Florida? Mr. Scott of Florida? Aye. Mr. Scott of South Carolina? Mr. Scott of South Carolina? Aye. Mrs. Shaheen? Mrs. Shaheen? No. Mr. Shelby? Mr. Shelby? Aye. Ms. Sinema? Ms. Sinema? No. Ms. Smith? Ms. Smith? No. Ms. Stabenow? Ms. Stabenow? No. Mr. Sullivan? Mr. Sullivan? Aye. Mr. Tester? Mr. Tester? No. Mr. Thune? Mr. Thune? Aye. Mr. Tillis? Mr. Tillis? Aye. Mr. Toomey? Mr. Toomey? Aye. Mr. Udall? Mr. Udall? No. Mr. Van Hollen? Mr. Van Hollen? No. Mr. Warner? Mr. Warner? No. Ms. Warren? No. Ms. Warren? No. Mr. Whitehouse? Mr. Whitehouse? No. Mr. Wicker? Mr. Wicker? Aye. Mr. Wyden? Mr. Wyden? No. Mr. Young? Mr. Young? Aye.
Is there any member in the chamber who wishes to vote or change his or her vote? If no, the yeas are 51, the nays are 49. The motion is agreed to.
Mr. Chief Justice.
The senator from Maryland.
Mr. Chief Justice, I send an amendment to the desk to have the Chief Justice rule on motions to subpoena witnesses and documents and to rule on any assertion of privilege, and I ask that it be read.
The clerk will report.
The senator from Maryland, Mr. Van Hollen, proposes an amendment number 1298. At the appropriate place in the matter following the resolving clause, insert the following. Notwithstanding any other provision of this resolution, the presiding officer shall issue a subpoena for any witness or any document that a senator or a party moves to subpoena if the presiding officer determines that the witness or document is likely to have probative evidence relevant to either article of impeachment before the Senate and consistent with the authority of the presiding officer to rule on all questions of evidence, shall rule on any assertion of privilege.
Leader is recognized.
Mr. Chief Justice, I move to table the amendment and ask for the yeas and nays.
Is there sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso? Aye. Mr. Bennett? No. Mrs. Blackburn? Aye. Mr. Blumenthal? No. Mr. Blunt? Aye. Mr. Booker? No. Mr. Bozeman? Aye. Mr. Braun? Aye. Mr. Brown? No. Mr. Burr? Aye. Ms. Cantwell? No. Mrs. Capito? Aye. Mr. Cardin? No. Mr. Carper? No. Mr. Casey? No. Mr. Cassidy? Aye. Ms. Collins? Aye. Mr. Coons? No. Mr. Cornyn? Aye. Ms. Cortez Masto? No. Mr. Cotton? Aye. Mr. Kramer? Aye. Mr. Crapo? Aye. Mr. Cruz? Aye. Mr. Daines? Aye. Ms. Duckworth? No. Mr. Durbin? No. Mr. Inzy? Aye. Ms. Ernst? Aye. Mrs. Feinstein? No. Mrs. Fisher? Aye. Mr. Gardner? Aye. Mrs. Gillibrand? No. Mr. Graham? Aye. Mr. Grassley? Aye. Ms. Harris? No. Ms. Hassan? No. Mr. Hawley? Aye. Mr. Heinrich? No. Ms. Hirono? No. Mr. Hoven? Aye. Mrs. Hyde-Smith? Aye. Mr. Inhofe? Aye. Mr. Johnson? Aye. Mr. Jones? No. Mr. Kane? No. Mr. Kennedy? Aye. Mr. King? No. Ms. Klobuchar? No. Mr. Lankford? Aye. Mr. Leahy? No. Mr. Lee? Aye. Mrs. Loeffler? Aye. Mr. Manchin? No. Mr. Markey? No. Mr. McConnell? Aye. Ms. McSally? Aye. Mr. Menendez? No. Mr. Merkley? No. Mr. Moran? Aye. Ms. Murkowski? Aye. Mr. Murphy? No. Mrs. Murray? No. Mr. Paul? Aye. Mr. Perdue? Aye. Mr. Peters? No. Mr. Portman? Aye. Mr. Reed? No. Mr. Risch? Aye. Mr. Roberts? Aye. Mr. Romney? Aye. Ms. Rosen? No. Mr. Rounds? Aye. Mr. Rubio? Aye. Mr. Sanders? No. Mr. Sass? Aye. Mr. Schatz? No. Mr. Schumer? No. Mr. Scott of Florida? Aye. Mr. Scott of South Carolina? Aye. Mrs. Shaheen? No. Mr. Shelby? Aye. Ms. Sinema? No. Ms. Smith? No. Ms. Stabenow? No. Mr. Sullivan? Aye. Mr. Tester? No. Mr. Thune? Aye. Mr. Tillis. Aye. Mr. Toomey. Aye. Mr. Udall. No. Mr. Van Hollen. No. Mr. Warner. No. Ms. Warren. No. Mr. Whitehouse. No. Mr. Wicker. Aye. Mr. Wyden. No. Mr. Young. Aye.
Is there any senator in the chamber wishing to vote or change his or her vote? If no, the yeas are 53, the nays are 47. The motion is agreed to. The question occurs on the adoption of Senate Resolution 488. Is there a sufficient second? There is. The clerk will call the roll.
Mr. Alexander. Mr. Alexander, aye. Ms. Baldwin. Ms. Baldwin, no. Mr. Barrasso. Mr. Barrasso, aye. Mr. Bennett. Mr. Bennett, no. Mrs. Blackburn. Mrs. Blackburn, aye. Mr. Blumenthal. Mr. Blumenthal, no. Mr. Blunt. Mr. Blunt, aye. Mr. Booker. Mr. Booker, no. Mr. Bozeman. Mr. Bozeman, aye. Mr. Braun. Mr. Braun, aye. Mr. Brown. Mr. Brown, no. Mr. Burr. Mr. Burr, aye. Ms. Cantwell. Ms. Cantwell, no. Mrs. Capito. Mrs. Capito, aye. Mr. Cardin. Mr. Cardin, no. Mr. Carper. Mr. Carper, no. Mr. Casey. Mr. Casey, no. Mr. Cassidy. Mr. Cassidy, aye. Ms. Collins. Ms. Collins, aye. Mr. Coons. Mr. Coons, no. Mr. Cornyn. Mr. Cornyn, aye. Ms. Cortez Masto. Ms. Cortez Masto, no. Mr. Cotton. Mr. Cotton, aye. Mr. Kramer. Mr. Kramer, aye. Mr. Crapo. Mr. Crapo, aye. Mr. Cruz. Mr. Cruz, aye. Mr. Daines. Mr. Daines, aye. Ms. Duckworth. Ms. Duckworth, no. Mr. Durbin. Mr. Durbin, no. Mr. Enzi. Mr. Enzi, aye. Ms. Ernst. Ms. Ernst, aye. Mrs. Feinstein. Mrs. Feinstein, no. Mrs. Fisher. Mrs. Fisher, aye. Mr. Gardner. Mr. Gardner, aye. Mrs. Gillibrand. Mrs. Gillibrand, no. Mr. Graham. Mr. Graham, aye. Mr. Grassley. Mr. Grassley, aye. Ms. Harris. Ms. Harris, no. Ms. Hassan. Ms. Hassan, no. Mr. Hawley. Mr. Hawley, aye. Mr. Heinrich. Mr. Heinrich, no. Ms. Hirono. Ms. Hirono, no. Mr. Hoven. Mr. Hoven, aye. Mrs. Hyde-Smith. Mrs. Hyde-Smith, aye. Mr. Inhofe. Mr. Inhofe, aye. Mr. Johnson. Mr. Johnson, aye. Mr. Jones. Mr. Jones, no. Mr. Kane. Mr. Kane, no. Mr. Kennedy. Mr. Kennedy, aye. Mr. King. Mr. King, no. Ms. Klobuchar. Ms. Klobuchar, no. Mr. Langford. Mr. Langford, aye. Mr. Leahy. Mr. Leahy, no. Mr. Lee. Mr. Lee, Aye. Mrs. Leffler? Mrs. Leffler? Aye. Mr. Manchin? Mr. Manchin? No. Mr. Markey? Mr. Markey? No. Mr. McConnell? Mr. McConnell? Aye. Ms. McSally? Ms. McSally? Aye. Mr. Menendez? Mr. Menendez? No. Mr. Merkley? Mr. Merkley? No. Mr. Moran? Mr. Moran? Aye. Mr. Murkowski? Mr. Murkowski? Aye. Mr. Murphy? Mr. Murphy? No. Mrs. Murray? Mrs. Murray? No. Mr. Paul? Mr. Paul? Aye. Mr. Perdue? Mr. Perdue? Aye. Mr. Peters? Mr. Peters? No. Mr. Portman? Mr. Portman? Aye. Mr. Reed? Mr. Reed? No. Mr. Risch? Mr. Risch? Aye. Mr. Roberts?
Order.
Mr. Roberts? Aye. Mr. Romney? Mr. Romney? Aye. Ms. Rosen? Ms. Rosen? No. Mr. Rounds? Mr. Rounds? Aye. Mr. Rubio? Mr. Rubio? Aye. Mr. Sanders? Mr. Sanders? No. Mr. Sass? Mr. Sass? Aye. Mr. Schatz? Mr. Schatz? No. Mr. Schumer? Mr. Schumer? No. Mr. Scott of Florida? Mr. Scott of Florida? Aye. Mr. Scott of South Carolina? Mr. Scott of South Carolina? Aye. Mrs. Shaheen? Mrs. Shaheen? No. Mr. Shelby? Mr. Shelby? Aye. Ms. Sinema? Ms. Sinema? No. Ms. Smith? Ms. Smith? No. Ms. Stabenow? Ms. Stabenow? No. Mr. Sullivan? Mr. Sullivan? Aye. Mr. Tester? Mr. Tester? No. Mr. Thune? Mr. Thune? Aye. Mr. Tillis? Mr. Tillis? Aye. Mr. Toomey? Mr. Toomey? Aye. Mr. Udall? Mr. Udall? No. Mr. Van Hollen? Mr. Van Hollen? No. Mr. Warner? Mr. Warner? No. Ms. Warren? Ms. Warren? No. Mr. Whitehouse? Mr. Whitehouse? No. Mr. Wicker? Mr. Wicker? Aye. Mr. Wyden? Mr. Wyden? No. Mr. Young? Mr. Young? Aye.
Is there any member in the chamber who wishes to vote or change his or her vote? If no, the yeas are 53, the nays are 47. The resolution is agreed to. Mr. Majority Leader?
Mr. Chief Justice, I ask unanimous consent that the Secretary be authorized to include statements of senators explaining their votes, either given or submitted during the legislative sessions of the Senate on Monday, February 3rd, Tuesday, February 4th, and Wednesday, February 5th, along with the full record of the Senate's proceedings and the filings by the parties in a Senate document printed under the supervision of the Secretary of the Senate that will complete the documentation of the Senate's handling of these impeachment proceedings.
Without objection, so ordered.
Further, I ask unanimous consent that when the Senate resumes legislative session on Monday, February 3rd, Tuesday, February 4th, and Wednesday, February 5th, the Senate be in a period of morning business with senators permitted to speak for up to 10 minutes each for debate only.
Without objection, so ordered.
And finally, I ask unanimous consent that the trial adjourn until 11 a.m., February 3rd, and that this order also constitute the adjournment of the Senate.
Without objection, so ordered. We are adjourned.
And the McConnell resolution to create a roadmap going forward on the court of impeachment has passed 53 to 47. The 4 Democratic amendments offered were all tabled. The only time that anyone broke party lines was during the 2 votes on the Bolton amendments. Senators Romney and Collins both voted not to table those amendments. Now, S. Res. 488, which they